than the 101,872 already arrested accused in these cases had a different participation in the events leading to November 23, 2009. Based on the volumes of exhibits and testimonies presented during the proceedings, this court has narrowed down the accused to six classifications. Thus, those who had prior knowledge of the murder plot could either had 1. Fired at the victims in sitio Masali, 2. Performed other acts outside of sitio Masali, or 3. Did not at all perform any overt act. 872 originally 117 including one whose cases were dismissed as against him for lack of probable cause, one dropped from the amended informations by virtue of a joint order dated February 13, 2013 and order dated November 5, 2013, 2 discharged as state witnesses, 8 including Datu Undal Ampatuan, Sr. already died while in detention, and 4 were ordered released on ground of insufficiency of evidence. Page 623 Those who had no prior knowledge of the murder plot could either had 4. Fired at the victims in sitio Masali, 5. Performed other acts outside of sitio Masali, and 6. Did not at all perform any overt act. Before discussing each of these classifications, this court will make a factual determination of whether the killing of the 57 victims were preceded by a murder plot. This finding is relevant to resolve the issue of whether or not conspiracy exists. The court finds that the prosecution has proven beyond reasonable doubt that the killing of the 57 victims were planned prior to November 23, 2009. Both direct and corroborative evidence point toward this conclusion. Direct evidence exists to prove that on the evening of July 20, 2009, a meeting was conducted at Century Park Hotel, Manila, which was held after the meeting in Camp Aguinaldo. The defense had failed to refute that said meeting took place, which was about the persistence of Datu Toto Mangudadatu, Datu Toto, to run as governor of Maguindanao for the 2010 national and local elections. Eyewitness Sukarno Badal had testified regarding the agenda and minutes of the meeting that transpired on the aforesaid date. The conversations he recalled before the court depicted that those who actively participated in said meeting wanted to prevent Datu Toto from running as governor, and even to kill him, so that political power would remain in the hands of the Ampatuans. Said direct testimony is corroborated by several pieces of evidence. The testimonies of Datu Toto and even Datu Undal Unsay Ampatuan, Jr., Datu Unsay, himself showed that a meeting was conducted at Camp Aguinaldo regarding the Maguindanao elections. LCR Gaba, the front desk manager of Century Park Hotel, as well as her bleeding records, proved that on July 20, 2009, several Ampatuans booked rooms thereat. Fabian S. Fabian, supervisor of the records section from the Philippine Airlines, PAL, as well as the travel documents on record, depicted that Ampatuans, together with other accused in these cases, were in Manila on even date. 4 days later, on July 24, 2009, in Maguindanao, unrefuted is the fact that Sukarno Badal received M14 rifles to be used to implement the plan to kill the Mangudadatas. Likewise, the testimony of Badal revealed that a week before November 23, 2009, or on November 16, 2009, the Ampatuans had a meeting in Apurik at the farm of Datu Undal Ampatuan, Sr., Datu. Page 624 Undal, Sr., in BRGY. Bagong, Sheriff Agwak. Transfer certificates of TITLE 873 on record would verify that the latter has properties in the said area. Badal, who was present at the gathering, recalled that in furtherance of the plan to kill the Mangudadatas, the possible locations of the filing of the certificate of candidacy were assigned to different persons. The killing will be committed by several men and with the use of firearms, and that the bodies and vehicles would be buried using a backhoe 874, which was subsequently identified with a marking acquired under the administration of Datu Undal S. Ampatuan, Sr., Governor, and Sangguniang Panlalawigan members, Province of Maguindanao. On November 19, 2009, another meeting was conducted according to state witness then P/Insp Ariel Diangon. He detailed that it was discussed that Datu Toto will pass by Malating, will have armed escorts, as Sangguniang will be used. Datu Toto might not himself file his cock, but regardless of who will file the same, that persons shall be killed, and the heads of the checkpoint were to receive a sack of rice and money to buy viands for the conduct of checkpoint operations. Right after this meeting, checkpoints were installed. The timeline proves beyond reasonable doubt that there were gatherings prior to November 23, 2009. The purpose had been laid out in these meetings, to not just prevent, but kill all the persons transporting the candidacy papers of Datu Toto to Sheriff Oglek. The method had also been ascertained. Numerous men, firearms, checkpoints, sangukos, and a backhoe would be used to accomplish the murder objective. Having now established that a roughly detailed planning preceded the killing of the 57 victims, this court now identifies those accused who had prior knowledge of the murder plot and the consequences that befall them. The first class of accused, those who had prior knowledge of the murder plot and fired at the victims in Insidio Masali, are clearly guilty as principals by direct participation. A principal by direct participation is one who takes part in the execution of the crime. Thus, in a prosecution for murder, the person who actually kills the victim is a principal by direct participation. 875 The following were identified by several witnesses as knowledgeable of the murder plot, and had participated in the actual killing of the victims, namely, Datu Undal Unse Ampatuan, Jr., Datu Anwar Sajid Datu Yulo Ampatuan, Datu Anwar Datu Ipi Ampatuan, Jr. Page 625 P/Insp Saudi Mokammad, P01 Jonathan Ejid, Abedi Almada aka Kubander Beatty, Talimbo Tami Majikat aka Talimbo Kahar Abdulrahman, Then P Salad aka Abdullah Hamid Abdul Kahar, Mani Ampatuan, and Nasser Esmail aka Nasruddin Esmail. Prosecution witness, Sukarno Badal had testified that the aforementioned accused had attended the meeting at Century Park Hotel on July 20, 2009. Together with other Ampatuan members and supporters, during which the plot to kill Datu Toto was first hatched due to his persistence to join the gubernatorial race in Maguindanao. Sukarno Badal had testified having seen Mokammad at a meeting on November 16, 2009 at the house of Datu Undal, Sr. in Bagong, Sheriff Oglek. Lokmodan Salil had likewise testified having seen accused Mani Ampatuan during the meeting held on November 17 and 22, 2009 at the house of Datu Zaldi Ampatuan and at the farm of Datu Undal, Sr. in Brgy. Bagong, Sheriff Oglek, respectively. Earlier, on November 21, 2009, another meeting was held in the house of accused Datu Unse at number 33, Sheriff Oglek, wherein the installation of checkpoints along the road from Isulan going to Sheriff Oglek and Cotabato, Midsayap, going to Sheriff Oglek was discussed. During the said meeting, Badal had seen accused Datu Unse, Mokammad, Datu Yulo, Datu Ipi, P01 Ejid, Alamada and then Salid. In fact, Mokammad together with Decay were assigned by Datu Unse to man the checkpoint in Malating, the place where the passengers of the convoy were to be halted. 876 Subsequent to the foregoing series of meetings held, and pursuant to their agreement to kill Datu Toto to prevent him from filing his certificate of candidacy, Datu Unse together with his armed men and the aforesaid accused had conducted checkpoint operations in crossing Saniog in the morning of November 23, 2009. They were actually seen by witnesses Sukarno Badal and Rasul Sankey. 877 After the convoy of Datu Toto led by his wife, by Ginalan Mangyudadatu and 56 other companions had passed crossing Saniog, on their way to Sheriff Oglek, they were subsequently halted at the Malating checkpoint being manned by members of the 1508th PMG. Even before the convoy could leave, Datu Kaner and his armed men arrived, followed by the group of Datu Unse, and thereafter, the passengers of the convoy were ordered to alight from their vehicles and lie prostrate on the ground while being divested of their personal belongings, employing force and violence upon them. They were subsequently brought to the hilly portion of Sidio Masali, Brgy. Salman, Ampatuan, Maguindanao, by Datu Kaner and Datu Unse together with the aforesaid accused as well as their armed cohorts, where they, passengers, were mercilessly killed with the use of high-powered firearms. 878 876 TSN, February 14. Page 626 Based from the foregoing, it is thus indubitable that Datu Unse, Datu Ipi, Datu Yulo, all surnamed Ampatuan, P/Insp Saudi Mohammad, P01 Jonathan Enjad, Abedin Almada, Talambo Tami Majakat, the P. Salid, Mani Ampatuan, and Nasser Esmail are considered principal by direct participation. Their acts were deliberate and obviously in pursuance of their plan to kill Datu Toto or whoever will file his certificate of candidacy. Said accused were positively identified and seen by witnesses to have actually participated in the shooting of the 57 innocent victims. In his memorandum, accused Datu Unsay asserts that he could not have committed the crimes charged given that he was at the Municipia Ng Bayan, Datu Unsay municipality, on that fateful day attending a meeting with local officials from 8 a.m. to 12 p.m. This alibi deserves scant consideration. The eyewitnesses who are familiar with accused Datu Unsay such as Rasul Sanki, Ahmed Abubakar Esmail, Anukakil, Noordin Mauyag, and Sukarno Badal categorically declared that they saw said accused in Saniog, Malating, and Masali on November 23, 2009. At the risk of being repetitive, the court must remind again the accused that not only was he merely cited, witnesses claimed that he was seen performing overt acts significant to the realization of the crimes charged. Collectively, from the testimonial and documentary evidence on record, Datu Unsay was linked in these crimes on the aforesaid date in the following manner. Saniog 1. He was seen conducting checkpoint operations and giving commands to his armed men, and 2. He was seen and heard constantly communicating via ICOM radio throughout the day with P/Insp Sukarno Deke. Specifically, the former uttered orders directing the latter to close the checkpoints and to look for the file of Datu Toto from the waylaid passengers. Malating 1. He was seen approaching the passengers of the convoy, who were already lying prostrate on the ground at that time. He was particularly observed by a witness as pointing a gun at them, and shouting "Dapa, lie down," to them. 2. He was seen and heard directing his armed men to get the cell phones of the herded victims. 3. Witnesses saw the accused as he took 2 women from one of the vehicles of the convoy. One witness saw him bringing them inside. Page 627. Another vehicle, while the other saw that the accused grabbed, slapped, and shoot a woman between her legs. 4. Rasul Sanki categorically testified that inside the vehicle of the accused, he saw various cameras belonging to the media. In that car, the witness heard the accused say, "AMA, they are already here?" 5. He was heard commanding the closure of the Malating checkpoint via ICOM, and thereafter, the accused left towards the direction of Sheriff Oglak. Masali 1. He was seen directing the passengers of the convoy to alight from their vehicles and then commanding his armed men to fire at them. 2. He was seen shouting "Dapa" to the passengers of the convoy herded in front of him. 3. Several witnesses saw him shooting at the victims with high-powered weapons. A witness saw him firing at those already dead. Lest it be forgotten, the minutes of the meeting dated November 23, 2009-9879, which was submitted to the court to buttress his defense of alibi, was merely a photocopy. Hence, the admission thereof was denied by the court in its order dated December 28, 2018, in light of the accused's failure to submit before it the original or at least a certified true copy thereof. Neither was an explanation offered by the accused to justify the admission of secondary evidence. In the case of Abdi, Jr. v. People 880, it was held that the court has consistently ruled that the defense of alibi must be received with suspicion and caution, not only because it is inherently weak and unreliable, but also because it can be easily fabricated. Alibi is a weak defense that becomes even weaker in the face of the positive identification of the accused. An alibi cannot prevail over the positive identification of the petitioners by credible witnesses who have no motive to testify falsely. On the issue of absence of ballistics report, it may be well to point out that the findings of expert witnesses such as the medical legal officers who conducted the autopsy on the cadaver of the victims, and had examined the injuries inflicted on them are one and saying that the latter died due to gunshot wounds inflicted by more than 2 assailants using high-powered firearms. This was categorically pointed out by Dr. Ricardo Rodage, Dr. Dean Cabrera, Dr. Reynaldo Romero, Dr. Felino Brunia, Jr., Dr. Ruperto Sambilan, Jr., Dr. Raymond Cabling, and Dr. Tomas de Mondal, Jr., when presented on the witness stand. It may also be worthy to mention that the receipt/inventory of properties seized confiscated at the Ampatuan Rice Mill, NFA warehouse, in 800. Page 628 Sheriff Oglek, on December 5, 2009, which shows among others, 250 boxes of ammunitions of cal 5.56 mm and 3 PCS, M16 rifle /5.56 mm and 3 black bandolier, 881 the empty shells of 5.56 caliber firearm found among others, in the Toyota Hiace Grandia VAN882 owned by Katafi Mangyudadatu, which was used by some of the victims on November 23, 2009, who were shot right then and there when they refused to alight therefrom, and the result of the ballistic examination requested by the medical legal officers. 883 on the fragments and slugs recovered from the herein victims. 884 reveal that most of the slugs from the victims were 5.56 mm copper jacketed bullets which were fired from a 5.56 firearm. 885 with riflings twisting to the right, all bear a common denominator, 5.56 mm, which means that this kind of slugs were used by the assailants. It matters not from whose firearms said slugs were fired. In this kind of a crime involving multitude participants, what matters is that they were used by the same assailants who were the armed group or CVOs of the Ampatuans who provided them with firepower. It must also be borne in mind that the fact that two of the prosecution witnesses, Thontilawani and Lagiadin, Alfonso, had subsequently retracted their testimonies to the effect that they were not present at the highway in Sitio Masali and they did not see Datu Unse on November 23, 2009, is of no moment. Even since their testimonies, the prosecution's evidence will remain unaffected, in light of the overwhelming evidence as above explained. It must be noted that recantation by a witness is nothing new, or it is a frequent occurrence in criminal proceedings. As a general rule, it is not well regarded by the courts due to its nature as the mere afterthought of the witness. 886 Lastly, assuming and arguendo that the phone calls between Datu Toto and Biginal and Mangyudadatu and the latter's utterances Malapit Nasi Unse, Sinampalakeo were not substantiated by the prosecution, given that only the Globe billing statement was adduced. Undisputed is the fact, however, that the text and call transcription made by the NBI on the Sony Ericsson P1i Cellular PHONE 887 of victim attorney Cynthia Oquendo, in which was identified by witness attorney Jem Oquendo to show that on November 23, 2009 at 10:39 a.m., a text message from attorney Aiden was received by attorney Arnold O'Claret which says, Christian GRTNG. No, kidnap me with Tati, Dahan me, PLS advise client Ampatuan. Tama NA, PLS, we MYT get killed they are firing. PLS sent to Tom. Referring to attorney Tomas Falgui, one of the legal counsel of Ampatuans, constitutes Res 800. Jesty as such utterance was made during a startling occurrence. Hence, pursuant to Rule 130, Section 42, which provides, thus, Sector 42, part of the residential jesty. Statements made by a person while a startling occurrence is taking place or immediately prior or subsequent thereto with respect to the circumstances thereof, may be given in evidence as part of the residential jesty. XXX said text message of attorney Oquendo Aid is admissible to show that Ampatuan was present at the crime site. The second class of accused, those who had prior knowledge of the murder plot and performed other acts outside of Sitio Masali, are also principals by direct participation. This class of accused are considered as such notwithstanding their absence at the locus criminis, as their actuations had for their purpose the attainment of their common objective of committing the unlawful act. In this case, the following were identified by various witnesses as knowledgeable of the murder plot and performed overt acts relevant to these crimes. Datu Zaldi Ampatuan, P/Ciansp. Sukarno Adildike, P/Superintendent of Yusuf Amundas Maguid, P/Superintendent Ban Aaron Kamwang and Datu Anwar Ampatuan, Sr. Given that the thrust of accused Datu Zaldi's defense, denial and alibi, has not changed, it may not be amiss to reiterate some of the facts as found by this court relative to his bail application. Accused claims that on July 20, 2009, November 16, 17, 21, and 22, 2009, when meetings were held for the purpose of discussing the plot to kill Datu Toto and the manner by which the same shall be implemented, that he was somewhere else. The court, however, is not persuaded. As regards the July 20, 2009 meeting held at Century Park Hotel, the defense failed to include in the alibi that it was impossible for the accused to leave the ARMM Manila liaison office in Makati City and head out to the meeting at the Department of National Defense, DND, and Century Park Hotel, which are all in Metro Manila. Based on the testimony of the defense witness herself, there was no work on that day. The accused arrived in the office after brunch time, left right after signing the documents only to return between 5 to 6 p.m., and left around 10 p.m. Obviously, the accused was not hampered from leaving the office and to proceed to other destinations as he may please. As regards the meeting on November 16, 2009, the evidence appears to show that the accused is in the same locality of Sheriff Oglic on said date and during the material time when the alleged meeting transpired. With only a thin margin as regards the exact location when the meeting was supposed to start at 10 a.m. in Sheriff Oglic, and the defense mentioned that the accused was in his office in Sheriff Oglic. Page 630. From at least 10 to 11 a.m., it cannot be gainsaid that there is no reasonable probability as regards the conclusion that the accused attended the meeting in BRGY Bagong, Sheriff Oglic. With respect to the alleged meeting on November 17, 2009, the defense claims that the accused did not attend said meeting, which started after 8:30 p.m. in Sheriff Oglic, for he was then at the Municipal Hall of Datu Hofer at around 7:30 p.m. up to 10 p.m. Here, the defense again failed to present a picture that limits the body of the accused from locomotion around the municipalities of said places. The defense witness even stated the tendency of the accused on that day to travel from Sheriff Oglic to Datu Hofer. Hence, it cannot be outrightly concluded that it is impossible for the accused to be in Sheriff Oglic at one point in time. Finally, regarding the supposed meeting on November 22, 2009, which started after 9 p.m., the defense posits that accused was then at home in Junas Subdivision, Manila, Davao City. However, this alibi, presented, appears to the court as still lacking the fundamental requisite that would show the accused's inability to travel from Davao to Sheriff Oglic. The defense of alibi fails to make the presence of the accused in times and places other than those in the meetings the controversial issue. The proofs shown allude to the locations of the accused, but not to his actual and fixed confinement in a certain place that would have supported his alibi. With the foregoing, the court is of the opinion that the defense of alibi of Datu Zaldi cannot be given due consideration. Well settled is the rule that it is not enough to prove that the accused was somewhere else when the crime was committed, but he must also demonstrate by clear and convincing evidence that it was physically impossible for him to have been at the scene of the crime at the time the same was committed. 888. Moreover, in his memorandum, herein accused is in effect questioning the credibility of Lacmodan Salio. According to him, it was impossible for the former to have been accorded trust and confidence, especially on confidential and sensitive matters involving a killing, as he was relatively a new employee in 2009, a complete stranger at the time he was hired. It must be pointed out, however, that when Lieutenant Colonel Randolph Kabangbang was presented on the witness stand on May 23, 2012, he testified that when he arrived at Camp Panakan Station Hospital to visit Datu Undal, Sr., he was told by the nurses thereat that he should approach the watcher first before he could enter the room, and whoever comes in the room of Undal, Sr., should first go to the watcher, who introduced himself as Lacmodan Salio, who was a trusted aide. 888 People vs. Abagni, GR number 199740, March 24, 2014, People vs. Castro, E.T. AL, GR number 187073, March 14, 2012. Page 631. He was a cell phone holder of Undal, Sr. Every transaction that Undal makes locks was part of it. 889. This only refutes accused's allegations that Salio has not been accorded trust and confidence by Datu Undal, Sr., as he was merely a Kazambahi. Accused Datu Zaldi likewise questions the credibility of witness Sukarno Badal in relation to his testimony regarding the high-powered firearms that were supposed to be loaded in a passenger or commercial flight. He claims that P/Gary Pozo had testified that the protocol observed in loading firearms is opposed to Badal's allegation. On cross-examination, however, it turned out that Pozo has no personal knowledge of any incident or procedures or protocol prior to 2017 as to the transport or facilitation of firearms to commercial flight because he only started his duty at PNPAVS in October 2017. Only 890 from the foregoing. It is thus clear that the grounds relied upon by the accused in questioning the credibility of prosecution witnesses is unfounded. On the issue of whether or not Datu Zaldi had made utterances during the alleged meetings sufficient to make him criminally liable, and whether or not there was an overt act on his part, it cannot be gainsaid that in a meeting at the house of accused Datu Zaldi Ampatuan on November 17, 2009, which was attended by several members of the Ampatuan clan, among others, except Datu Unsay, who was admittedly airborne on his way to the Philippines from the United States at the time, witness Lokmodan Salio heard the former uttered Kong Yanang Mapag USAPANKALA NGANPLANU HIN MABUTIPARA HIN DTYOMABISTO 891 in a subsequent meeting on November 22, 2009, in BRGY. Bagong, Sheriff Oglak, said accused also uttered Kong Yan Nang final decision, Nadan Na Patin Silang Lahat I Pupunta Akong Manila Para Hindi Tayo Mahalata at Magdawagan Na Lang Tayo. 892 previous to this meetings, accused likewise attended the meeting at Century Park Hotel on July 20, 2009 wherein accused mentioned Todo Suporta Ako Dayan, AMA Dapat Malinas Angpagawa. Dilkong Hindi Malinas. Madudung is an Angpang Alan KOATMA KUKULO NGTAYONG La HAT 8930 on November 16, 2009 at the mansion of Datu Undal, Sr. in Bagong. Witness Sukarno Badal said that he heard Zaldi utter Todo Suporta Ako Dayan, Kahit Laha NG Baril KOGAGA Mitan NYO. Kaila NGANM Linus ANGPAGKAKATRABAHOKASIKAPAG Nagatan Makukulang Taong Lahati Alalahanin Nadan Ang Sabi Ni8CYN 894-889 TSN, May 23, 2012, pages 83 to 84. 890 TSN, February 1, 2018, pages 6 and 9. 891 TSN, January 7, 2000. Page 632. Considering the attendance of the accused and his utterances during the subject meetings, the court finds that based on the evidence presented, there are clear, strong, and convincing pieces of evidence, which tend to exclude all reasonable probability of any other conclusion that the accused was deeply involved in the planning of the crimes. During said meetings, he consistently gave his support to the plans and advised about being cautious so as not to get caught. That would put his name to shame, and those attending the meetings, behind bars. While it is admitted that accused Datu Zaldi was not at the locus criminis when the implementation of the plot to kill was finally made, this will not ipso facto exonerate him from criminal liability, given that aside from said utterances, he did not only offer to give all his guns, but agreed to be assigned in Metro Manila, as possible place for the filing of Datu Toto's cock. Thus, he was heard saying, Kung yan ang final decisiun natin sa, sick, Patin silang lahat I pupunta Ako Manila para hindi tayo mahalata at magdawagan nalan tayo. In the ordinary context, these words heard from the accused would show his agreement and unity with the plans discussed during the meeting. Beyond agreement, the accused gave moving utterances that elicited emotions, responses, and further actions from the group. Otherwise, he should have done something to prevent his cohort, specifically Datu Unsay and others whose names are mentioned herein, from acting in furtherance of their plot to kill. An accepted badge of conspiracy is when the accused, by their collective acts aimed at the same object, one performing one part and another performing another so as to complete it with a view to the attainment of the same objective, indicating closeness of personal association, concerted action, and concurrence of sentiments. 895 To exempt himself from criminal liability, A conspirator must have performed an overt act to dissociate or detach himself from the conspiracy to commit the felony and prevent the commission thereof. 896 Likewise identified by witnesses on several occasions, i.e., prior to, during and after November 23, 2009, is P/C. Sukarno Deke, who at that time was the Deputy Director of Maguindanao Police Provincial Office. Sukarno Badal pointed to Deke as one of the police officers who were present at the meeting on November 16, 2009 in Bagong, Sheriff Oglak. He was likewise seen at the meeting on November 21, 2009 in the house of Datu Unsay at number 33, Sheriff Oglak. 897 While nothing was heard from him during said meetings, it is obvious that in furtherance of the plan to kill Datu Toto, he performed another act in order to attain their common objective. 800 First, Deke was seen by Noordin Mauyag as one of the armed men he saw in Sitio Malating on November 20 to 23, 2009. 898 Second, at past 9 a.m. on November 23, 2009, then P/Insprex Ariel Diangon saw Datu Kainer and Deke at their checkpoint. Upon arrival of the 8 vehicles from Esperanza Road, Deke ordered the men of Datu Kainer to scatter. 899 Thereafter, Rasul Sankey testified that he saw Deke pointing a gun at the people lying prostrate on the ground in Sitio Malating, on November 23, 2009. 900 Upon arrival of Datu Unsay, together with Datu Kainer, the passengers of the Manggudadata convoy were brought to the hilly portion in Sitio Masali, Brgy. Salmon, Maguindanao, where they were subsequently killed. On the following day, November 24, 2009, Deke was seen by Anukakil at the house of Datu Undal, Sr., who told the former and Carol Blah that a person will conduct an interview and they were to tell them that Deke and Diangon arrived in Sitio Masali and Sitio Malating at 11:30 a.m. In fact, on November 23, 2009, in crossing Saniog, it was Deke who called Datu Unsay through an ICOM that the Manggudadata convoy has already passed the Takurong round ball. He was even the one who was asked by Datu Unsay to close the Malating checkpoint. After the Manggudadata convoy was brought to the hilly portion of Sitio Masali, Brgy. Salmon, and while still at the Malating checkpoint, Deke instructed one of the CVOs of Datu Kainer to burn all the evidence left in Malating, upon instruction of P/Insmakamad. Subsequently, under the guise of lack of trust but actually a cover-up, Deke deliberately did not divulge to the members of the 64th Infantry Battalion, IB, when asked about the abduction incident upon their arrival at the Malating checkpoint on that fateful day. When presented on the witness stand, Major Peter Edwin R. Navarro testified, thus, pros reas, and what happened next after Colonel Narana instructed you to proceed to the PNP checkpoint in Malating? When we reached the PNP checkpoint, sir, we saw the PNP personnel, see Insp. Deke, Insp Diangon and Insmakata or Makarig. XXXQ Now, after approaching the checkpoint, what happened next? Our battalion commander, Lieutenant Colonel Narana, said to Insp. Deke that there was an abduction report in Masali. Q. And what was the reply of Insp Deke? 898 TSN, September 7, 2011, pages 66. TSN, November 23, 2011, pages 46 to 47. From the foregoing, it is indubitable that accused Deke had conspired with his co-accused in order to attain their common goal, i.e., to kill Datu Toto or whoever will file his cock on his behalf. The above quoted reply of Deke is evidently a cover-up. Thus, he must be made to suffer for all the consequences of his wicked act. As for P/Superintendent Ban Aaron Kamong, allegedly a trusted man of Datu Zaldi Ampatuan, the former was cited by Sukarno Badal to have attended the meeting on July 20, 2009 at Century Park Hotel where the plot to kill Datu Toto was hatched. While thereat, he was heard by the witness uttering the words pagdating sa punto na yan sabi naya, Datu, ako na ang bahala pati na mga tul erhankeo. 901 He was likewise seen by said witness in the meeting held on November 16, 2009 at the mansion of Datu Undal, Sr. in Bagong, Sheriff Oglak, where he uttered Sabi Nayapo, Pagdating Ng Ors Nayan, Kami Na Ang Bahala Pati Ang Mga Taoko 902 on November 17 and 22, 2009. Kamong was also cited by prosecution witness, Lokmodan Salio, to have attended the meetings held at the house of Datu Zaldi and at the farm of Datu Undal, Sr. in Bagong, respectively. In the latter meeting, Kamong was seen giving instructions to the police officers to bring out the firearms. 903 While Kamong did not actually participate in the shooting of herein victims, neither was he actually seen at the crime site on November 23, 2009. It cannot be denied that he was part of the plot to kill Datu Toto. His overt act in directing the police officers to bring out the firearms apparently to be used by the assailants in carrying out their plan speaks for itself. No other conclusion can be had except that he was part of the conspiratorial act. He thus must be made to suffer the consequences thereof. P/Superintendent Abusima Maguid, Al-Haj, the provincial director of the PNP, is likewise part of the conspiratorial act. He was identified by witness Rex Ariel Diangon, who went to Malating checkpoint together with Ins Makamat right after the passengers of the convoy were halted thereat and brought to the hilly portion of Sitio Masali. Said witness claimed that Maguid talked to him, Decay and Macarig, and told him to say bomb threat, false alarm. Maguid had likewise instructed Decay to burn all the evidence in said place which were left by the victims. 904 901 Page 635 Moreover, Maguid was identified by witness Esmail Canapia as the person who he met on November 23, 2009 while he was on his way to the hilly portion of Sitio Masali. When he testified on October 4, 2012, 905, he quoted his affidavit, Exhibit 13E, which said, thus, PAR 5. Sa aking pagachkit sa vilabun duking bahagi ng Sitio Masali I nazalubang ko ang convoy ng mga sasakyan ni Datu Unsay, Kazamasina Mohads Ampatuan at si Colonel Maguid at Pati na rin ang maraming lalaking armadong naka-uniforme. Sila I pababa nasa bundok Kazama ang mga iba pang armadong kalalakay Honolulu ng mga sasakyan. His being cited as one of the companions of Datu Unsay on November 23, 2009 while descending from the mountain or hilly portion of Masali, and his act of directing Decay to make it appear that the incident of abduction at Malating checkpoint on said date was a bomb threat, false alarm to mislead the would-be investigators clearly show unity of purpose with Datu Unsay. Lastly, witness Sukarno Badal had testified that accused Datu Anwar Ampatuan, Sr. was present in the meeting at Century Park Hotel on July 20, 2009, when the plot to kill Datu Toto was hatched. 906 Datu Anwar, Sr. was likewise present during the meeting held on November 16, 2009 at the mansion of Datu Undal Sr. in Bagong, Sheriff Oglak. In fact, on said occasion, he even uttered Patin Natin yung mga Mangyudadatu, Pati yung mga Sasakyan nila Ililibing na Natin yan 907. He was also present in the meeting on November 17 and 22, 2009, at the house of Datu Zaldi and in Bagong, Sheriff Oglak. 908 Admittedly, Datu Anwar, Sr. was not at the crime site on November 23, 2009. No witness had identified him as being present thereat on said date. Unfortunately, however, this will not ipso facto exonerate him from criminal liability, it appearing that at the meeting on November 16, 2009, he uttered the aforequoted suggestion which to the mind of the court was one of the moving factors which emboldened all the more Datu Unsay and their other cohorts in carrying out their wicked plan. In fact, as pointed out by the prosecution in its memorandum, said suggestion was actually carried out to the letter when accused Bong Undal was asked to operate the backhoe to dig a hole and bury the lifeless bodies of the victims together with their vehicles. Moreover, his role in the aiding and facilitating the escape of his brother Datu Unsay with his cohorts immediately after the commission of the crime cannot be underestimated. This signifies oneness and unity with his brothers in committing the crimes charged. page 636, the defense of Datu Anwar being a mere denial, which, like alibi, is the weakest defense, will thus crumble in light of the positive and categorical identification of the witnesses that he indeed attended the meetings to discuss their plot to kill Datu Toto notwithstanding his absence at the crime site. His absence becomes irrelevant since in conspiracy, the act of one is the act of all. 909 The third class of accused, those who had prior knowledge of the murder plot but did not at all perform any overt act. The following accused fall under this category: Datu Ahmed Tato Ampatuan and Datu Sajid Islam Ampatuan. In the meeting held on July 20, 2009, Datu Sajid Islam Ampatuan and Datu Ahmed Tato Ampatuan were two of those who attended the meeting at Century Park Hotel to discuss the plot to kill Datu Toto Mangudata. This was categorically stated by witness Sukarno Badal when he testified in court. 910 They were likewise present in the meeting to further discuss the details of the plot on November 17 and 22, 2009 at the house of Datu Zaldi and in Bagong, Sheriff Oglak, respectively. 911 However, no one among the eyewitnesses had testified and pointed to them as being present at the crime site on November 23, 2009. The fact that on November 24, 2009, Datu Sajid was heard by Anukakil to be discussing with some of his visitors in his house on how to save the backhoe and subsequently giving him P2,000.00 is of no moment. This cannot be considered an overt act indicative of conspiracy with his brothers and cohorts. His presence in the above-mentioned meetings without uttering any words of encouragement that served to embolden and influence his brothers to carry out their plan so as to make him liable as a conspirator is wanting. It must be kept in mind that conspiracy must be established by positive and conclusive evidence. It cannot be based on mere conjectures but must be established as a fact. The same degree of proof required to establish the crime is necessary to support a finding of the presence of conspiracy, that is, it must be shown to exist as clearly and convincingly as the commission of the offense itself. An assumed intimacy is of no legal bearing inasmuch as conspiracy transcends companionship. 912 It bears stressing that the burden lies not on the accused to prove his innocence but on the prosecution to prove his guilt beyond reasonable doubt. Thus, for failure of the prosecution to discharge its duty, this court has no other option except to exonerate him from the crimes charged. 909 People versus Ubiko, GR number 178039. Even assuming that it is, conspiracy alone, without the execution of its purpose, is not a crime punishable by law except in special cases. 913 His mere presence in the meeting will not suffice to declare that he indeed conspired with the other Ampatuans to commit the crimes charged. The fact that he uttered the following at the meeting, thus, Pakington Nadan Siama. OK kami lahat na patin sila and mabuti na samga manggudadatu na mahilig magambisian na patin sila lahat, does not necessarily mean that he pushed for the commission of the crime which prima facie may suffice to find a strong evidence of guilt. However, his having attended a medical mission for the whole day in collaboration with Smart Network International, at the municipal gymnasium near the Municipal Hall of Mamasapano on November 23, 2009 will show that he did not cling to the agreed plot to kill. There is no clear and convincing evidence that will show that accused had committed an overt act in furtherance of the agreed plan. In the absence of evidence pointing to the accused as being present at the crime site, the court is convinced that he cannot be made criminally liable under the circumstance even with the utterances he made since overt acts. The fourth class of accused, those who had no prior knowledge of the murder plot but were actual assailants in sitio Masali, are likewise guilty as principals by direct participation. Here, the following were identified by various witnesses as having actually fired at the victims: Tato Tampajao, Mohad Ampatuan, Mohammed T. Datuman aka Nicomedes Ahmed Tolentino, Mijori Ampatuan, Taya Bankulat, Salik Bankulat, Thong Diamano aka Ibrahim Kamal Tatak, Sunny K. Pindai aka Hovan Salazar Piang aka Bimbo Salazar Piang, Armando Ambalgan aka Jamil Bulatukan Kayan Zang / Bulatokan Omar, testified as Omar Bulatukan Kayan Zang, Kajam Majakat Ugia aka Datu Teng. Ibrahim / Mustafa Ibrahim, Edris Kazan aka Edris Gogolib, testified as Edris Gugo Kazan, Zakaria Piakil aka Quigoakil and Saman Anatuan. Esmail Amilanag testified that Tato Tampajao was among those armed men he brought from the house of Datu Kaner Ampatuan to Malating. Both of them are CVO 914 and he was pointed as among those who were present in the crime site on November 23, 2000, and 9.915 he was also 900 and Page 638 seen among the group of Datu Unsay who alighted from one of the vehicles on said date. 916 like Tato Tampajao, Mohads Ampatuan, Mohammed Datumanan aka Nicomedes Ahmed Tolentino, and Mijuri Ampatuan were among those armed men brought by witness Esmail Amilanag from the house of Datu Kaner Ampatuan to Malating. 917 he saw them on board the truck called Weapon going to Malating on November 23, 2009. Witness Sukarno Badal testified that they were with a group of Datu Unsay and were present at the crime site on the aforesaid date. They were among the many more who fired shots at those passengers that were brought in front of Datu Unsay. 918 on the other hand, Salik and Tayabankulat were among the armed men witness Heiko Magako had seen at the checkpoint in Sidio Masali. They were among the armed men who were present at the crime site on the aforesaid date. 919 Sunny K. Pindai was one of the armed men who was seen in crossing Malating, standing at the highway and likewise at the crime site on November 23, 200-9920 while Thongiamano aka Ibrahim Kamal Tatak was among the group of Datu Kaner with more or less 40 armed CVS who asked the witness Esmail Canapia the way to Boian. Datu Hoffer. 921 witness Esmail Canapia saw Armando Ambalgan as among the group of Datu Unsay whom he saw on the way to the mountain of Masi on November 23, 2000, and 9.922 on the other hand, Kajam Majakot was among the group of Datu Kaner whom he saw in a hilly portion of Masali on said date wearing a soldier uniform, carrying a firearm with a camera hanging on his neck which apparently was taken from one of the passengers of the convoy. Edras Kazan, Zakaria Akil aka Quigo Akil and Saman Anatuan were among the armed men present at the crime site on said date. In fact, Zakaria was among the Marami Pang Iba who were present during the time that victims by Gigi and by Eden and the passengers of the first vehicle were brought before Unsay on November 23, 2009.923 It must be stressed that the foregoing accused were among the armed men who were seen in the company of either Datu Kaner or Datu 906. Page 639 Unsay who abducted and brought the passengers of the convoy to the hilly portion of Masali, Brgy. Salman, Ampatuan where the latter were subsequently killed after they were divested of their personal belongings at the checkpoint in Sidio Masali. They were actually seen by witnesses at the crime site. With a multitude of participants who actually shot the 57 victims, it can be reasonably deduced that all of them actually participated in the killing of the victims, they being the CVOs of the Ampatuans who are the latter's armed group. While there is no evidence that they attended the several meetings conducted prior to November 23, 2009, but having been at the crime site with Datu Kaner and Datu Unsay who were actually in the company of more than 100 armed men ready to kill upon their prodding, they too must be considered as principal by direct participation. The fifth class of accused, those who had no prior knowledge of the murder plot but were still identified or had performed overt acts. The following accused fall under this category: police officers at the scene at the Malating checkpoint, namely, P/Ins Michael Joy Makarig, PO3 Felix Enate, PO3 Avibudan Abdul Ghani, PO3 Razid Anton, PO2 Hamid Nana, PO2 Saudi Basudan, PO2 Saudi Arula, PO1 Esprilito Lejarso, PO1 Nurkalk Mascud, PO1 Pia Comadon, PO1 Esmail Gilal, PO1 Arnulfo Soriano and PO1 Harakambaba, members of the 1508th PMG, P/S-INSP. Abdul Gapar Abid, and Bong Undel. Witness then P/INSP Rex Ariel Diangon had testified that the aforementioned police officers together with him and Decay who were members of the 1508th PMG, were assigned in Sidio Malating to man a checkpoint on November 23, 2000, and 9.924 prior to this, from November 19 to 22, 2009, said police officers, except for Makarig who arrived only in the afternoon on November 22, 2009, have been manning said checkpoint pursuant to the in-plan issued by Maguindanao Police Provincial Office. 925 by 9 a.m. of November 23rd, said police officers were no longer seen at the Malating checkpoint, albeit they remained along the highway as they were already replaced by the augmentation from other municipal police stations provided by Decay. After they were halted and before the convoy could leave, Datu Kane aimed their guns at the passengers of the vehicles. They were directed to alight therefrom and to lay prostrate on the ground while being divested of their personal belongings. By 10:30 a.m., the convoy of Datu Toto was already with Datu Unsay and brought to the hilly portion of Sitio Masali. Brgy. Salmon, Ampatuan, Maguindanao. 920. Page 640. The prosecution posits that the aforesaid accused should be made liable for they conspired with the principal accused and had played an indispensable role in the abduction of the Mangyudata convoy. On the other hand, members of the 1508th claimed that high-powered firearms were likewise pointed at them, hence, they were not able to do anything to prevent the abduction of the victims for fear of their lives. The court is not convinced. Surely, while the firearms of the men of Datu Kaner were pointed at them, their lives were in danger. Thus, it is understandable that the instinct of self-preservation will set in. However, as police officers, they are not only mandated to maintain peace and order but ensure public safety as well. Hence, as soon as Datu Kaner and his armed men had already left Malating checkpoint, and danger to their lives were no longer present, they were duty-bound to immediately report said incident to their higher officials so that appropriate action can be made which could have saved the lives of the victims. Having failed to do so, the court is of the view that they should be made liable under the law under Par 3 of Article 19 of the Revised Penal Code, which penalizes accessories who are public officers who harbors, conceals, or assists in the escape of principal, there being no showing that the members of the 1508th PMG had conspired with the principal accused. It appears that P/S Abbott had no prior knowledge of the plot to kill. No witness had categorically testified that he attended any of the meetings held. However, given that said accused who set up a checkpoint in crossing Saniog on November 23, 2009, 926 was seen and identified by witness Diangon to be in the company of Ins Mohammad, declared as principal in these cases, who kept on coming back and forth at Malating checkpoint 927 well knowing that an abduction incident had already occurred, and yet, he failed to report the same. He should likewise be made liable as an accessory under Par 3 of Article 19 of the Revised Penal Code. Insofar as Bong Undal is concerned, the court is of the view that he should likewise be made liable as an accessory only for burying the dead bodies of the 57 victims and neglecting to inform the authorities about it, there being no showing that he conspired with the principal accused. The sixth class of accused, those who had no prior knowledge of the murder plot were not at all identified in the locus criminis, are totally innocent of these crimes. The following accused fall under this category, viz. SPO2 George Labayan, SPO1 Eliza Rendage, SPO1 Alamola Gianatun, SPO1 Samad 926 TSN, June 5, 2013, pages 100 Magandra, PO3 Ricky Balanuaco, PO3 Jibril Alano, PO2 Rexundima, PO1 Emir Soliman, PO1 Badjun Panigas, PO1 Pendadandima, PO1 Ibarra Bibat, PO1 Tamano Hadi, PO1 Michael Makarangan, known as Labayan Group, SPO1 Ali Solano, PO3 Felix Tequilos, PO2 Ken De Rakim, PO1 Abdul Rahman Badaraza, PO1 Marjal Jelkati, PO1 Datu Jeriato, PO1 Mohammed Balading, PO1 Marsman Nilong, PO1 Ismail Baraquir, PO1 Abdul Manan Saavedra, and PO1 Jimmy Kodtung, known as Solano Group, PO1 Sandy Saban. Takpandalan, Edris Tiki Nanding aka Ibrahim Kakob, Warden Ledwan, Jonathan Ampatuan, Jimmy Ampatuan, Rainer Ebis, and Mohammed Sankey, though Amino, Norman Tatak, Malgil Tanarai aka Yulhari Montak Malgil, Alim Yudin Sangiad aka Noordin Malang, Mama Habib, Sahid Yamadal aka Arnal Abdullah Datuchulan Esmail, Qasim Lingkong aka Abdul Qadir Saluddin, Akad B. Makadon aka Mohammed Salazar Piang, Norato Kamano aka Alfasht Banding, Nasser Malgia aka Ramon Dejalo, P/Insp. Ban Aaron Kamwang and P/Superintendent Abdul Wahid Petkazan, PO1 Ahmed Badal, PO2 Tani Dalgan, PO1 Anwar Majikat, Samsudin Dud, Mitbankulat aka Benji Dagandengan, Dengamendal aka Rani, Fataduto aka Richard Goful, PO1 Abdullah Bagwadatu, PO1 Oscar Donato and PO1 Michael Madsig. Evidence shows that the members of the Labayan Group and Solano Group were assigned in CDO Bini Byron and CDO Masali, respectively. 928. While admittedly, the convoy of Datu Toto had passed their checkpoints, it is unrefuted that they were not aware who were the passengers of the convoy, they having been abducted at Malating checkpoint. It stands to reason, therefore, that while they may have heard the burst of gunfires after said convoy had passed, their failure to report the same or respond thereto should not be taken against them, given that burst of gunfires is considered a normal occurrence in their place, the peace and order situation being one of the major problems therein since time immemorial. On the other hand, while PO1 Sandy Sabang were identified to have been present during one of the meetings of the Ampatuan, there is no showing, however, that he was one of the conspirators. No overt act can be attributed to him. Tak Pandalan, who was arrested for possessing firearm, cannot likewise be made liable, it appearing that no one among the prosecution witnesses had identified him as among those who were present at the crime scene. Neither was he identified to have conspired with any of the principal accused. PO1 Ahmed Badal and PO2 Tani Dalgan may have been identified by witness Sukarno Badal as being present at the crime scene on November 23, 2009. But this can be explained by the fact that they were the security escorts of said witness. They were not identified to have fired shots at the 57 victims. 900. Insofar as Petkazan and Kamwang are concerned, admittedly they were identified by prosecution witnesses. However, it cannot be denied that the only act that can be attributed to the former was being present at the cafeteria or eatery in Labo National Highway and nothing more on the aforesaid date. Same thing can be said of Kamwang. Nothing can be attributed to him except that he manned the checkpoint at Ampatuan Municipal Police Station. No overt act in pursuance of the plot to kill Datu Toto can be attributed to him. Although Warden Ledwan was seen by witness Sukarno Badal together with Mokammad, it cannot be denied, however, that he categorically declared that he did not notice where Ledwan was at the time of the shooting. Neither was he identified to have been seen at the crime site. While Rainer Ebbs was identified to be a security escort of Datu Unsay and Mohammed Sankey was cited in crossing Saniog, the fact that no one among the prosecution witnesses had categorically identified them as having conspired or committed overt acts in pursuance of the plan to kill, reason dictates that they be exculpated from criminal liability. Lastly, while the rest of the accused were identified as allegedly being members of CVOs, for want of evidence clearly pointing to them to have participated in the shooting of the 57 victims nor had they executed acts that can be considered as conspiratorial, the court is of the view that they should likewise be exonerated from the crimes charged. Well settled is the rule that conviction must be made on the strength of the prosecution and not on the weakness of the defense. 929 Conviction based merely on speculation and conjecture cannot satisfy the question of evidence required for a pronouncement of guilt. 930 The court is likewise not convinced that the accused mentioned under this category had conspired with the principal accused. No convincing evidence to this effect was presented in court. Verily, all the accused who were found to falling under the first and fourth categories were the authors of the crimes charged. Thus, it is only proper that they, together with their conspirators, as well as those declared by the court to have acted as accessories to the crime of murder, be made liable accordingly. Insofar as PO1 Abdullah Bagwadatu, SPO1 Oscar Donato and PO1 Michael Madsig are concerned, the prosecution did not squarely refute the alibi they invoked. Nonetheless, while the prosecution has the burden 900 Page 643 of proof to establish the guilt of the accused, the burden of evidence falls to them to prove their affirmative defense of alibi. 931 To establish such a defense, It must be proved by nothing less than full, clear, and satisfactory evidence. Point 932. The twofold elements of alibi are as follows. 933a. That he was in another place at the time of the commission of the offense, and b. That he must demonstrate that it would be physically impossible for him to be at the locus criminis at the time of the alleged crime. Bhagwatata has produced evidence that he was at RD Pawn Shop Tulunan branch, Tulunan, North Cotabato on November 23, 2009. The receipt from RD Pawn Shop, Ig. 3, and the testimony of Michael Zaldivar depicted that the accused was collecting 5,500 Cuban pesos sent by Daisy Mangalamas at 10:02 a.m. on that day. With the unrefuted testimony that North Cotabato was 90 kilometers away from Sitio Malating, and considering the undisputed narration that the bodies were discovered in the uphill portion of Sitio Masali in the afternoon of November 23, 2009, it would be physically impossible for Bhagwatata to be at the locus criminis at the time of the alleged crime. For his part, Donato produced evidence that he was at the Maguindanao Police Provincial Headquarters at Camp Datu Ukilan, Ampatuan, Sheriff Oglak on November 23, 2009. Special Order Number 352 issued on November 23, 2009, and the testimony of the witness himself convincingly showed that the accused was receiving his reassignment order in the morning of that date. With the unrefuted testimony of his police superiors, Diangon and Decay, that the accused figured in a commotion against members of the 1508th PMG in the evening of November 22, 2009, which led to his immediate transfer to Buldan MPS, he could not have returned to his station in Sitio Malating after his trip to the provincial headquarters. On the other hand, Madsa categorically declared that he was not at the Malating checkpoint on November 23, 2009 as he asked permission from Diangon at about 8 or 9 a.m. that day to be excused from checkpoint duties because he will be going home to bring food to his family. It was only around 1 or 2 p.m. that he left home and proceeded to Sitio Malating. Considering the totality of the evidence presented by Bhagwatata and Donato, vis-a-vis the lack of refutation from the prosecution, the court is convinced, with moral certainty, that both of them were not in Sitio Malating on November 23, 2009. Same thing can likewise be said of 930. Madsig. While there may have been minor inconsistencies in his testimony, this should not be taken against him in light of the absence of evidence clearly pointing to him to have conspired or actually committed the crimes charged. THEPRAYEROFDEFENSECOUNSLFOR attorney's lien as a penultimate matter. The court notes without action the prayer of counsel of the accused for attorney's lien equivalent to 10% of the back wages and monetary benefits of the accused from the Philippine National Police. According to Rule 138, Section 37 of the Rules of Court, an attorney's lien is of two kinds. One is called retaining lien and the other charging lien. 934 The latter is the right which the attorney has upon all judgments for the payment of money, and executions issued in pursuance of said judgments, which he has secured in a litigation of his client. 935 To be enforceable, a charging lien requires as a condition sine qua non a judgment for money secured in the main action by the attorney in favor of his client. Considering that a charging lien is an equitable right to have the fees and costs due to counsel for services in a suit secured to him out of the judgment or recovery in that particular suit, the attorney's fees can only be determined and enforced in the same action where the services were rendered. 936 In this case, the counsel of accused seeks to charge his lien from the back wages and monetary benefits from the Philippine National Police. In effect, he is applying his charging lien not pursuant to this judgment, but based on another forum. Obviously, the prayer of the counsel before this court is misplaced. He should file the appropriate action before the proper tribunal to collect the attorney's fees privy between him and his clients. In light of the findings of existence of conspiracy between and among the accused herein, specifically those belonging to the first, second, and fourth classes of accused, all are considered principal regardless of their participation, as the act of one becomes the act of all. 934 VDA. Dakina v. Victoriano, GR Noel 12905, February 26, 1959, 100. Page 645. The qualifying circumstances per Article 248 of the Revised Penal Code. The following circumstances qualify the killing to murder. 1. With treachery, taking advantage of superior strength, with the aid of armed men, or employing means to weaken the defense or of means or persons to ensure or afford impunity. 2. In consideration of a price, reward, or promise. 3. By means of inundation, fire, poison, explosion, shipwreck, stranding of a vessel, derailment, or assault upon a streetcar or locomotive, fall of an airship, by means of motor vehicles, or with the use of any other means involving great waste and ruin. 4. On occasion of any of the calamities enumerated in the preceding paragraph, or of an earthquake, eruption of a volcano, destructive cyclone, epidemic, or any other public calamity. 5. With evident premeditation. 6. With cruelty, by deliberately and inhumanly augmenting the suffering of the victim, or outraging or scoffing at his person or corpse. The informations before this court allege the first, fifth, and sixth enumerated qualifying circumstances. This court finds that all such allegations exist in the killing of the 57 victims. From the discussion made by the court, treachery is present in the instant case as obviously, the 57 victims who were unarmed were not in a position to defend themselves. While some of them may have been shot in front, however, taking into consideration the number of armed men more than 100 with high-powered firearms, it is next to impossible that these victims will be able to defend themselves. Evident premeditation is likewise present in the case at bar. The prosecution was able to prove that from the time the plot to kill Datu Toto was first hatched on July 20, 2009, it was only on November 23, 2009 that the execution thereof was made, after several meetings were held by Datu Unsay and his cohorts to discuss the mode and manner of its execution. The court, however, is not convinced that cruelty attended the killing of the victims. There is cruelty when unnecessary injuries were inflicted by the offender while the victim is alive. Evidence will show, however, that the unnecessary shots or finishing were made by the offenders when the victims were already dead. Page 646. The aggravating circumstances. The prosecution stated conspiring, confederating and mutually helping one another, with evident premeditation, taking advantage of superior strength, treachery, with cruelty, in an uninhabited place and by a band, armed with high-powered firearms in the informations of these cases. Hence, in relation to Article 14 of the Revised Penal Code, the following are the alleged aggravating circumstances in these cases. Article 14. Aggravating circumstances. The following are aggravating circumstances, XXXX6. That the crime be committed in the nighttime, or in an uninhabited place, or by a band, whenever such circumstances may facilitate the commission of the offense. Whenever more than 3 armed malefactors shall have acted together in the commission of an offense, it shall be deemed to have been committed by a band. XXXX8. That the crime be committed with the aid of armed men or persons who ensure or afford impunity. XXXX13. That the act be committed with evident premeditation. XXXX15. That advantage be taken of superior strength, or means be employed to weaken the defense. 16. That the act be committed with treachery, alavosia. There is treachery when the offender commits any of the crimes against the person, employing means, methods, or forms in the execution thereof which tend directly and specially to ensure its execution, without risk to himself arising from the defense which the offended party might make. XXXX21. That the wrong done in the commission of the crime be deliberately augmented by causing other wrong not necessary for its commission. XXXX. Page 647. Considering that the aforementioned were already earlier discussed by the court except for uninhabited place, the court deems it proper to discuss the latter. People v. Coders 937 instructs that 3 elements must be taken into account before the aggravating circumstance of uninhabited place may be considered, to wit, a. when it facilitated the commission of the crime, or b. when especially sought for by the offender, or c. when offender took advantage thereof for the purpose of impunity. This court appreciates that the aggravating circumstance of uninhabited place exists in this case. The crime site, as depicted in the pictures, i.e. A8, A9, Quintuple T205, video footage, sketches, and testimonies from those who discovered the crime scene, the relatives as well as the first responders and crime scene operatives, has sparse and scattered cottages at a great distance from each other. It was grassy, with a terrain that is rolling and uncultivated. The houses therein were few and situated wide apart from each other. The surroundings, as described, are indeed isolated. The location where the crime site was found is uphill with ditches, called by the locals as Boondock ng Masali. It is away from the national highway, see the sketch in Quintuple T223, and could be traversed upward through a narrow rough road mountainous terrain with no electrical post. The place of mass killing was at the topmost portion of the mountain. It is surrounded by shrubs, cornfield, and few growing trees. Quintuple T230. The area was accessed by the responders from the military after passing a very rough, treacherous, and rugged terrain XXX. 11, F13. Both the height and the access to site allow the perpetrators to conceal and hide the firing of the victims from plain view. Undoubtedly, the situs that the aggressors traversed facilitated the commission of the crime. Just a last note on the criminal aspect. Previously under RA number 7,659,938 the imposed for the crime of murder is reclusion perpetua to death. Since the penalty for murder consists of two indivisible penalties, Article 63,939 of the revised penal code must be considered. Thus, in order to impose the proper penalty, especially in cases of indivisible penalties, the court has the duty to ascertain the presence of any mitigating or aggravating circumstances. Accordingly, in crimes where the imposable penalty is reclusion perpetua to death, the court can impose either reclusion perpetua or death. But with the enactment of RA Page 648 9346, 940 the imposition of death penalty is prohibited. It provides that in lieu of the death penalty, the penalty of reclusion perpetua shall be imposed when the law violated makes use of the nomenclature of the penalties of the RPC. As a result, the death penalty can no longer be imposed. Instead, they have to impose reclusion perpetua. On the civil aspect pursuant to Article 100 of the Revised Penal Code, RPC, every person criminally liable for a felony is also civilly liable. In relation thereto, Section 1 of Rule 111 of the Revised Rules of Criminal Procedure states that when a criminal action is instituted, the civil action for the recovery of civil liability arising from the offense charged shall be deemed instituted with a criminal action unless the offended party waives the civil action, reserves the right to institute it separately or institutes the civil action prior to the criminal action. In the instant cases, it appears that no reservation was made by the prosecution before it presented evidence to institute the civil action separately from the criminal action. Neither was a civil action filed prior to the criminal action. This being the case, the civil action is deemed instituted with the criminal action. Although the criminal and civil actions can be litigated in the same proceedings, the quanta of evidence for the two actions are not the same. In criminal actions, for an accused to be found guilty, there must be proof beyond reasonable doubt. Proof beyond reasonable doubt does not mean such a degree of proof as, excluding possibility of error, produces absolute certainty. Moral certainty only is required, or that degree of proof which produces conviction in an unprejudiced mind. 941 On the other hand, in civil cases, the party having the burden of proof must establish his case by preponderance of evidence. In determining where the preponderance or superior weight of evidence on the issues involved lies, the court may consider all the facts and circumstances of the case, the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts to which they are testifying, the nature of the facts to which they testify, the probability or improbability of their testimony, their interest or want of interest, and also their personal credibility so far as the same may legitimately appear upon the trial. 942 Despite the singularity of the proceedings of both the criminal case and the civil case, it is possible for there to be an acquittal on the criminal 904 case and yet a finding of civil liability. The respective weights of the evidence in the criminal and civil cases are evaluated independently. 943 When death occurs due to a crime where the imposable penalty is reclusion perpetua, the following damages may be recovered. 1. Actual damages, which may consist of the actual expenses incurred in relation to the death of the victim, as well as the loss of earning capacity. 2. Civil indemnity ex delicto. 3. Moral damages. 4. Exemplary damages. And 5. Tempered damages in some cases. Actual or compensatory damages refer to an adequate compensation only for such pecuniary loss suffered by a person as he has duly proved. 944 In crimes, the damages to be adjudicated may be respectively increased or lessened according to the aggravating or mitigating circumstances. 945 Jurisprudence dictates that to be entitled to compensatory damages, it is necessary to prove the actual amount of loss with a reasonable degree of certainty, premised upon competent proof and the best evidence obtainable to the injured party. 946 Receipts should support claims of actual damages. 947 In case of death, it has been held that the heirs are entitled to the amount that they spent during the wake and funeral of the deceased. However, expenses after the burial are not compensable. Thus, those expenses incurred relating to the 9th day, 40th day, and 1st year death anniversaries are not anymore entitled to the award of actual damages. 948 Loss of earning capacity is a form of actual or compensatory damages under the Civil Code. Under Article 2206 of the Civil Code, the heirs of the victim are entitled to indemnity for loss of earning capacity. Compensation of this nature is awarded not for loss of earnings, but for loss of capacity to earn. The indemnification for loss of earning capacity partakes of the nature of actual damages, which must be duly proven by competent proof and the best obtainable evidence thereof. Thus, as a rule, documentary evidence should be presented to substantiate the claim for damages for loss of earning capacity. It was ruled that by way of exception, damages for loss of earning capacity may be awarded despite the absence of documentary evidence when 1. The deceased is self-employed and earning less than a minimum wage under current labor laws, in which case, judicial notice may be taken of the fact that in the deceased's line of work no documentary evidence is available, or 2. The deceased is 900 employed as a daily wage worker earning less than a minimum wage under current labor laws. 949 However, in the recent case of People v. Wahiman, 950, the Supreme Court awarded lost earnings to the heir of the victim who was neither as self-employed earning less than a minimum wage nor was he employed as a daily wage earner, even if there was no documentary proof presented by the prosecution. The court ruled in said case that the testimony of the victim's wife was not objected to or questioned during cross-examination or on appeal, and from said testimony, the existence of factual basis of the award had been satisfactorily established by the prosecution. Hence, the award of the lost earnings. In determining the lost earning capacity, what is important is proof of capacity to earn, not merely proof of actual loss of a specified amount of income. 951 Based on the landmark case of Villa Reytra and Sit v. Courtof Appeals, 952 The formula for the computation of the loss of earning capacity of a deceased is net earning capacity equals life expectancy x gross annual income less necessary living expenses. To determine the life expectancy, below is the formula used by the court in the aforesaid jurisprudence. Life expectancy equals 2/3 x, 80, age of the deceased at time of death. With respect to the necessary living expenses, the High Court in the case of Negroes Navigation Co., in v. The Court of Appeals, et. Al. 953 ruled that only 50% of her gross salary redounds to a person's living expense. Thus, the formula for the net earning capacity is net earning capacity equals life expectancy x gross annual income less necessary living expenses, 50%, when the evidence on record only shows monthly gross income. Annual gross income is derived from multiplying the monthly gross income by 12. When the daily wage is the only information provided during trial, such amount may be multiplied by 260, or the number of usual workdays in a year 954 to arrive at annual gross income. This is under the presumption that an average laborer works 5 days a week and 52 weeks in a year. This value should change if the laborer's work days are different. 955. Another kind of damages in murder cases is the civil indemnity ex delicto. Civil indemnity ex delicto is the indemnity authorized in our criminal law for the offended party, in the amount authorized by the prevailing judicial policy and apart from other proven actual damages, which itself is equivalent to actual or compensatory damages in civil law. This award stems from Article 100 of the RPC, which states, every person criminally liable for a felony is also civilly liable. 956. It is to be noted that civil indemnity is, technically, not a penalty or a fine, hence, it can be increased by the court when appropriate. 957. Article 2206 of the Civil Code imposes a minimum amount for civil indemnity, which states that the amount of damages for death caused by a crime or quasi-delict shall be at least 3,000 Cuban pesos, even though there may have been mitigating circumstances. This is in addition to other liability of the defendant, such as the loss of the earning capacity of the deceased and support. In our jurisdiction, civil indemnity is awarded to the offended party as a kind of monetary restitution or compensation to the victim for the damage or infraction that was done to the latter by the accused, which in a sense only covers the civil aspect. Precisely, it is civil indemnity. Thus, in a crime where a person dies, in addition to the penalty of imprisonment imposed to the offender, the accused is also ordered to pay the victim a sum of money as restitution. The law did not provide for a ceiling. Thus, although the minimum amount for the award cannot be changed, increasing the amount awarded as civil indemnity can be validly modified and increased when the present circumstance warrants it. 958. Another type of damages are the moral damages, which are also compensatory in nature. Article 2217 of the Civil Code provides that moral damages include physical suffering, mental anguish, fright, serious anxiety, besmirched reputation, wounded feelings, moral shock, social humiliation, and similar injury. Though incapable of pecuniary computation, moral damages may be recovered if they are the proximate result of the defendant's wrongful act or omission. The court explained the nature and purpose of this kind of damages in the case of Del Mundo v. Court of Appeals, 959. Thus, moral damages, upon the other hand, may be awarded to compensate one for manifold injuries such as physical suffering, mental anguish, serious anxiety, besmirched reputation, wounded. Page 652. Feelings and social humiliation. These damages must be understood to be in the concept of grants, not punitive or corrective in nature, calculated to compensate the claimant for the injuries suffered. Although incapable of exactness and no proof of pecuniary loss is necessary in order that moral damages may be awarded, the amount of indemnity being left to the discretion of the court, it is imperative, nevertheless, that 1. Injury must have been suffered by the claimant, and 2. Such injury must have sprung from any of the cases expressed in Article 221-9960 and Article 222-0961 of the Civil Code. The rationale for awarding moral damages was explained in Lambert v. Ayres of Rey Castellan. The award of moral damages is aimed at a restoration, within the limits possible, of the spiritual status quo ante, and therefore, it must be proportionate to the suffering inflicted. 962. Corollarily, moral damages under Article 222-0963 of the Civil Code also does not fix the amount of damages that can be awarded. It is discretionary upon the court, depending on the mental anguish or the suffering of the private offended party. The amount of moral damages can, in relation to civil indemnity, be adjusted so long as it does not exceed the award of civil indemnity. 964. Further, moral damages are mandatory in cases of murder without need of to allege and prove such damages. 965. With respect to exemplary damages, the Civil Code provides, Article 2229. Exemplary or corrective damages are imposed, by way of example or correction for the public good, in addition to the moral, temperate, liquidated or compensatory damages. Article 2230. In criminal offenses, exemplary damages as a part of the civil liability may be imposed when the crime was committed with one or more aggravating circumstances. Such damages are separate and distinct from fines and shall be paid to the offended party. 900. Also known as punitive or vindictive damages, exemplary or corrective damages are intended to serve as a deterrent to serious wrongdoings, and as a vindication of undue sufferings and wanton invasion of the rights of an injured or a punishment for those guilty of outrageous conduct. These terms are generally, but not always, used interchangeably. In common law, there is preference in the use of exemplary damages when the award is to account for injury to feelings and for the sense of indignity and humiliation suffered by a person as a result of an injury that has been maliciously and wantonly inflicted. 966. The theory being that there should be compensation for the hurt caused by the highly reprehensible conduct of the defendant, associated with such circumstances as willfulness, wantonness, malice, gross negligence, or recklessness, oppression, insult, or fraud or gross fraud. 967. That intensifies the injury. The terms punitive or vindictive damages are often used to refer to those species of damages that may be awarded against a person to punish him for his outrageous conduct. In either case, these damages are intended in good measure to deter the wrongdoer and others like him from similar conduct in the future. 968. The term aggravating circumstances used by the Civil Code, the law not having specified otherwise, is to be understood in its broad or generic sense. The commission of an offense has a two-pronged effect, one on the public as it breaches the social order and the other upon the private victim as it causes personal sufferings, each of which is addressed by, respectively, the prescription of heavier punishment for the accused and by an award of additional damages to the victim. The increase of the penalty or a shift to a graver felony underscores the exacerbation of the offense by the attendance of aggravating circumstances, whether ordinary or qualifying, in its commission. Unlike the criminal liability, which is basically a state concern, the award of damages, however, is likewise, if not primarily, intended for the offended party who suffers thereby. It would make little sense for an award of exemplary damages to be due the private offended party when the aggravating circumstance is ordinary but to be withheld when it is qualifying. Withal, the ordinary or qualifying nature of an aggravating circumstance is a distinction that should only be of consequence to the criminal, rather than to the civil, liability of the offender. In fine, relative to the civil aspect of the case, an aggravating circumstance, whether ordinary or qualifying, should entitle the offended party to an award of exemplary damages within the unbridled meaning of Article 2230 of the Civil Code. 969. Being corrective in nature, exemplary damages, therefore, can be awarded, not only due to the presence of an aggravating circumstance, 900 but also where the circumstances of the case show the highly reprehensible or outrageous conduct of the offender. In much the same way as Article 2230 prescribes an instance when exemplary damages may be awarded, Article 2229, the main provision, lays down the very basis of the award. 970. Lastly, the court may grant tempered damages to the heirs of the victim under Article 222-4971 of the Civil Code where it has been shown that they suffered pecuniary loss but the amount thereof cannot be proved with certainty. 972. In the case of People v. Ibrazaldo 973, the Supreme Court allows the grant of temperate damages in the amount of 25,000 Cuban pesos if there is no evidence of burial and funeral expenses. This is in lieu of actual damages, as it would be unfair for the victim's heirs to get nothing, despite the death of their kin, for the reason alone that they cannot produce any receipts. The High Court also ruled there that temperate and actual damages are mutually exclusive in that both may not be awarded at the same time. Hence, no temperate damages may be granted if actual damages have already been granted. Under the prevailing jurisprudences, the rule is that when actual damages proven by receipts during the trial amount to less than 25,000 Cuban pesos, the award of tempered damages for 25,000 Cuban pesos is justified in lieu of actual damages of a lesser amount. Conversely, if the amount of actual damages proven exceeds 25,000 Cuban pesos, then tempered damages may no longer be awarded. Actual damages based on the receipts presented during trial should instead be granted. 974. But pursuant to the latest jurisprudence, 975 tempered damages are now increased to 50,000 Cuban pesos. Previously, under Republic Act, R.A. Number 7,659,976, the penalty imposed for the crime of murder is reclusion perpetua to death. Since the penalty for murder consists of two indivisible penalties, Article 63,000 Page 655 of the RPC must be considered. Thus, in order to impose the proper penalty, especially in cases of indivisible penalties, the court has the duty to ascertain the presence of any mitigating or aggravating circumstances. Accordingly, in crimes where the imposable penalty is reclusion perpetua to death, the court can impose either reclusion perpetua or death, depending on the mitigating or aggravating circumstances present. 978 But with the enactment of RA No. 9346,979 the imposition of death penalty is now prohibited. It provides that in lieu of the death penalty, the penalty of reclusion perpetua shall be imposed when the law violated makes use of the nomenclature of the penalties of the RPC. 980 As a result, the death penalty can no longer be imposed. Instead, they have to impose reclusion perpetua. In the latest jurisprudence of People v. Gambale et al. 981 the Supreme Court took the opportunity to increase the amounts of indemnity and damages, where the penalty for the crime committed is death which, however, cannot be imposed because of the provisions of RA No. 9346, 1. 100,000 Cuban pesos as civil indemnity, 2. 100,000 Cuban pesos as moral damages which the victim is assumed to have suffered and thus needs no proof, and 3. 100,000 Cuban pesos as exemplary damages to set an example for the public good. These amounts shall be the minimum indemnity and damages where death is the penalty warranted by the facts but is not imposable under present law. Moreover, Article 109 of the Revised Penal Code provides that if there are 2 or more persons civilly liable for a felony, the courts shall determine the amount for which each must respond. Article 110 of the same code likewise provides that the principals, accomplices, and accessories, each within their respective class, shall be liable severally, in solidum, among themselves for their quotas, and subsidiarily for those of the other persons liable. The subsidiary liability shall be enforced, first against the property of the principals, next, against that of the accomplices, and lastly, against that of the accessories. Whenever the liability in solidum or the subsidiary liability has been enforced, the person by whom payment has been made shall have a right of action against the others for the amount of their respective shares. It is also important to take into consideration the ruling of the Supreme Court in People v. Montes Claros 982 as it is instructive on the 4. Page 656 Apportionment of civil liabilities among all the accused. The entire amount of the civil liabilities should be apportioned among all those who cooperated in the commission of the crime according to the degrees of their liability, respective responsibilities, and actual participation. Hence, each principal accused should shoulder a greater share in the total amount of indemnity and damages than those who were adjudged as only accomplices. With respect to the interest rate on the damages awarded, the Supreme Court ruled in Gamboa v. People 983 that the interest rate on civil indemnity allowed in judgments is pegged at 6%, reckoned from the rendition of judgment until the award shall have been fully paid. In relation to the Banco Central NG Filipinas Circular No. 799,984 pegging the rate of interest allowed in judgments back to 6%, as also discussed in the landmark case of Nacar v. Gallery Frames. 985 Lastly, it may be worthy to mention that in case damages other than actual shall be granted to the offended party without having specified the amount thereof in the complaint or information, the filing fees relative thereto shall constitute a first lien on the judgment. This is pursuant to paragraph 3 of section 1, rule 111 of the Rules of Court, which provides, thus, XXX when the offended party seeks to enforce civil liability against the accused by way of moral, nominal, temperate, or exemplary damages without specifying the amount thereof in the complaint or information, the filing fees therefore shall constitute a first lien on the judgment awarding such damages. XXX This was also reiterated in OCA Circular No. 54/2018 dated March 21, 2018, which directed clerks of court/accountable officers to collect the appropriate legal fees for the total sum claimed, excluding actual damages. Based on the third amended information dated March 2, 2016, the murders herein were committed with the following aggravating circumstances: evident premeditation, taking advantage of superior strength, treachery, in an uninhabited place, by a band, and armed with high-powered firearms. These aggravating circumstances were 983 gr. Page 657 exhaustively discussed in the main decision on the criminal liability of the accused, and were duly proved by the prosecution based on the pieces of evidence presented. Thus, it is imperative that exemplary damages should be awarded to all the heirs of the victims. Regarding the civil indemnity, it is also proper to award the same as the deaths were due to the crimes committed by the accused. The same goes with respect to moral damages. As regards actual damages including the loss of earning capacity and or tempered damages, the same shall be discussed individually as it will depend on the evidence presented by each of the heirs of the victims which were admitted by the court in evidence. 1. For victim by Ginal Mangudadatu, witness Esmail Toto Mangudadatu testified that he spent 2 million Cuban pesos for the burial of his wife. However, he admitted that he was not able to keep the receipts of said expenses because under the Islam culture or practice, they do not keep receipts related to the death of their loved ones. He further testified that he paid for the production of 57 death certificates amounting to 100 Cuban pesos each, which were supported by official receipts from the local civil registrar marked as exhibits A2PPP to A2LLLL. He also presented PAL travel certifications marked as exhibits A2L to A2GG and an official receipt No. E00000582889 from PAL for the booking certification fee amounting to 27,328 Cuban pesos marked as Exhibit A2HH. As earlier discussed, actual damages in murder cases relate to those expenses incurred in relation to the burial and wake of the victim. Notwithstanding that the witness admitted that he was not able to keep the receipts, it cannot be denied that the death of the victim was established by the prosecution and there were indeed expenses incurred in connection thereto. Hence, the court grants the amount of 50,000 Cuban pesos as tempered damages in lieu of the actual damages which were not supported by receipts. Based on the testimony of the witness, he did not state anything or presented any document which relates to the claim for loss of earning capacity of the victim. Therefore, the court cannot grant the same considering the absence of evidence to prove the same. In view of the foregoing, the following are the damages to be awarded to the family of the victim by Ginal Mangudadatu: A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. Page 658, Center exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.002, for victim Napoleon Salazar. Witness Ramonita Salazar testified that she incurred a total amount of 115,000 Cuban pesos for the wake and burial expenses of her deceased husband Napoleon Salazar. As proof of her claim, she presented an affidavit of burial expenses with a said amount, marked as Exhibit 5J7, and a contract with number 2361 from Marble Subir Funeral Homes dated November 25, 2009 with a total amount of 30,000 Cuban pesos. Considering that the said amount indicated in the affidavit of burial expenses was not fully supported by receipts and the only proof presented was the receipt from the funeral home, the court will only grant the amount of 50,000 Cuban pesos as tempered damages since the fact of death of said victim was clearly established by the prosecution and there were expenses incurred in relation thereto, in keeping with the recent jurisprudence. Insofar as the claim for loss of earning capacity, the witness testified that her husband was earning around 20,000 Cuban pesos to 25,000 Cuban pesos as publisher/editor of the Clearview Gazette. The witness likewise presented the ID card of victim Napoleon Salazar from Gazette newspaper as publisher/editor marked as Exhibit 5J5 and a copy of the Clearview Gazette newspaper dated November 9 to 16, 2009 showing the staff box with the name of the victim as publisher/editor marked as Exhibit 5J6. Considering that the witness was not cross-examined by the defense counsels and the latter did not object to the presentation of the said evidence to prove the claim of the witness, the court is inclined to grant the claim for loss of earning capacity as it was established that at the time of death of the victim, he was gainfully employed and had capacity to earn for a living. Based on the certificate of marriage marked as Exhibit 5J2, the victim was born on June 11, 1954, hence, at the time of his death on November 23, 2009, he was already 55 years old. Since the compensation provided by the witness was the range of the salary the victim received, the court will get the average to arrive at the monthly allowance of the victim. Thus, net earning capacity equals life expectancy x gross annual income less necessary living expenses. Life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80255, equals 2/3x25. Page 659 equals 16.6667 years income provided equals 20,000 Cuban pesos to 25,000 Cuban pesos. AVERAGE MONTHLYSLRY equals 2 Cuban pesos 0, 0, 0, 0. 00 plus 2 Cuban pesos 5, 0, 0, 0. 00/2 equals P4500.00/2 equals 22,500 Cuban pesos. Gross annual income equals 22,500 Cuban pesos x 12 months equals 270,000 Cuban pesos. Loss of earning capacity equals life expectancy x 1/2 annual gross income equals 16.6667 years x 1/2, 270,000 Cuban pesos equals 16.6667 years x 135,000 Cuban pesos. Loss of earning capacity equals 2,250,004 Cuban pesos and 50 cents. From the foregoing, the following are the damages to be awarded to the heirs of victim Napoleon Saliza. A. Civil indemnity, 100,000.00. B. Moral damages, 100,000.00. C. Exemplary damages, 100,000.00. D. Tempered damages, 50,000.00. E. Loss of earning capacity, 2,250,004 Cuban pesos and 50 cents. 3. For victim Victor Nunez, witness Catherine Nunez testified that she incurred a total amount of 100,000 Cuban pesos as expenses for the burial and wake of her husband victim Victor Nunez. However, she also confirmed that she did not keep the receipts. This notwithstanding, since the death of the victim was duly established by the prosecution and the court notes that there were expenses incurred in relation thereto, the court is inclined to grant the amount of 50,000 Cuban pesos as tempered damages in lieu of the actual damages which were not proven by receipts. With regard to the claim for loss of earning capacity, the witness testified that her husband at the time of his death worked as a reporter for UNTV and was earning 385 Cuban pesos per day. Her claim was evidenced by a certification dated November 9, 2010, issued by Breakthrough and Milestones Productions International Incorporated, signed by Ramona G. Domingo, Chief Finance Officer, certifying that the late Victor Nunez at the time of his death was a contractual talent of BMPI-UNTV Channel 37, and was receiving a fee of 385 Cuban pesos per day, marked as Exhibit 4, Z12, and an ID card of the victim for UNTV 37, for the August 11, 2008 ARMM. Page 660 elections marked as Exhibit 4, Z13. Although the witness was cross-examined by the defense counsels, the subject of the same was about the corpse of the victim and not as regards with the earning capacity of the latter. Hence, the court believes that with the evidence presented by the prosecution as well as the testimony of the witness, it is only proper to allow the grant of the loss of earning capacity of the victim. Based on his death certificate marked as Exhibit T50, the victim was 24 years old at the time of his death. Hence, applying the formula for the loss of earning capacity, viz., net earning capacity equals life expectancy x gross annual income less necessary living expenses. Life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80224, equals 2/3x56 equals 37.3333 years. Gross annual income equals 385 Cuban pesos x 260 working days equals 100,100 Cuban pesos. Loss of earning capacity equals life expectancy x 1/2 annual gross income equals 37.3333 years x 1/2, 100,100 Cuban pesos, equals 37.3333 years x 50,050 Cuban pesos. Loss of earning capacity equals 1,868,531 Cuban pesos and 67 cents. To summarize, The following are the damages to be awarded to the heirs of victim Victor Nunez. A. Civil indemnity, 100,000.00. B. Moral damages, 100,000.00. C. Exemplary damages, 100,000.00. D. Tempered damages, 50,000.00. E. Loss of earning capacity, 1,868,531 Cuban pesos and 67 cents. For victim Joel V. Parkin, to claim for actual damages in relation to the wake and burial expenses of victim Joel V. Parkin. Witness: Noemi Parkin executed an affidavit of burial expenses with a total amount of 154,500 Cuban pesos, marked as Exhibit 5D10. But she admitted when she testified in court that she was not able to collect the receipts for all expenses. Despite the failure. Page 661 to present receipts. The court believes that it should grant the amount of 50,000 Cuban pesos as tempered damages since the heirs of the victim suffered pecuniary loss in connection with the death of the victim. Regarding the claim for loss of earning capacity, the witness testified that the victim at the time of his death was the publisher/editor of PRON Terra News and was earning 30,000 Cuban pesos to 35,000 Cuban pesos a month. To prove her claim, she presented the following, among others: A. ID card number 1010 of the victim for the 2007 Polarong Pambanza marked as Exhibit 5D6. B. A copy of the PRON Terra dated August 9th to 15th, 2006 with a staff box showing that the victim was the publisher/editor marked as Exhibit 5D7. C. A purchase order from the provincial government of South Cotabato for publication of notice of delinquency in PRON Terra News with the amount of 19,800 Cuban pesos marked as Exhibit 5D8. D. Billing statement addressed to the LGU, City of Coronadal, South Cotabato for the amount of 14,700 Cuban pesos issued by PRON Terra News Service signed by the victim marked as Exhibit 5D8B. When these documents were presented, the defense counsels did not object thereto. Further, during cross-examination of the witness, she was only asked as to the SSS membership of the victim and if she received benefits from said agency. Also, during cross, she mentioned that the business was supposed to expand to Quitapavan City, but since her husband died, the business had to close. Considering the foregoing, the court is convinced with the evidence presented by the prosecution in connection with a claim for loss of earning capacity of the victim. According to the witness, the victim was 49 years old at the time of his death. Based also on her testimony, the provided salary was in a range of 30,000 Cuban pesos to 35,000 Cuban pesos, so it is only proper to get the average to arrive at the monthly salary of the victim. Hence, net earning capacity equals life expectancy x gross annual income less necessary living expenses. Life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80249, equals 2/3x31 equals 20.6667 years. Income provided equals 30,000 Cuban pesos to 35,000 Cuban pesos. AVERAGE. MONTHLYSRY equals 3 Cuban pesos. 0, 0, 0, 0. 0, 0 plus 3 Cuban pesos. 5, 0, 0, 0. 0, 0 slash 2 equals 6 Cuban pesos. 5, 0, 0, 0.00 slash 2 equals 32,500 Cuban pesos. Gross annual income equals 32,500 Cuban pesos x 12 months. Page 662 equals 390,000 Cuban pesos. Loss of earning capacity equals life expectancy x 1/2 annual gross income equals 20.6667 years x 1/2, 390,000 Cuban pesos equals 20.6667 years x 195,000 Cuban pesos. Loss of earning capacity equals 4,030,006 Cuban pesos and 50 cents. In summary, the following damages are to be awarded to the family of victim Joel Parkin. A. Civil indemnity, 100,000.00. B. Moral damages, 100,000.00. C. Exemplary damages, 100,000.00. D. Tempered damages, 50,000.00. E. Loss of earning capacity, 4,030,006 Cuban pesos and 50 cents. 5. For victim Santos June P. Gatchalian, to prove her claim for actual damages, witness Ma. Cipriana A. Gatchalian presented a handwritten list of burial expenses with a total amount of 112,650 Cuban pesos marked as Exhibit 5, H8. Likewise, she presented the following receipts. Description date amount official receipt No 050-6584 from the Office of the Treasurer, City of Coronadal marked as Exhibit 5, H9 November 25, 2009 100 Cuban pesos permit to transfer the cadaver from the Office of the City Health, City of Coronadal with a handwritten note transportation fee, van, to carry the coffin containing the cadaver of the victim from Marble Subir Funeral Homes to Davos City, marked as Exhibit 5, H9 November 26, 2009. 12,000.00. Page 663 San Antonio de Padua Parish Official Receipt Number 35,161 marked as Exhibit 5, H9C November 28, 2009 700 Cuban pesos Forest Lake San Pedro, Incorporated Official Receipt No 02535 marked as Exhibit 5, H9D November 28, 2009 16,000 Cuban pesos Forest Lake Development, Incorporated Official Receipt Number 156,936 marked as Exhibit 5, H9E November 28, 2009 850 Cuban pesos handwritten note for the full payment of a Forest Lake lot signed by a certain Colonel Noel Bravo marked as Exhibit 5, H9F November 28, 2009 26,000 Cuban pesos. Forest Lake San Pedro, Incorporated Deed of Transfer for a memorial lot executed between Alexis Noel C. Bravo and Ana Victoria A. Gatchalian marked as Exhibit 5, H10 December 2, 2009 total 55,650 Cuban pesos given that the total amount of the expenses which were duly substantiated with receipts amounted to only 55,650 Cuban pesos, lesser than that indicated in the handwritten list of burial expenses. The court is inclined to grant that amount which is supported by receipts as actual damages. Regarding the claim for loss of earning capacity, witness testified that the victim was a correspondent of Metro Gazette as evidenced by a certification issued by Metropolitan Gazette dated April 5, 2011 signed by Francis R.V.B. Dianza, certifying that the victim was a correspondent of said newspaper. She also testified that her husband was earning 5,000 Cuban pesos monthly when he was still alive. Considering that the defense counsels did not conduct their cross-examination on the witness and they did not object to the presentation of the certification issued by Metro Gazette, the court believes that the evidence presented by the prosecution is sufficient to award the claim for loss of earning capacity. Page 664 Based on his death certificate marked as Exhibit T38, the victim was 52 years old at the time of his death. Applying the formula to get the loss of earning capacity, viz. Net earning capacity equals life expectancy x gross annual income ls necessary living expenses life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80252, equals 2/3x28 equals 18.6667 years gross annual income equals 5,000 Cuban pesos x 12 months equals 6 Cuban pesos 0.0000 loss of earning capacity equals life expectancy x 1/2 annual gross income equals 18.6667 years x 1/2, 60,000 Cuban pesos equals 18.6667 years x 30,000 Cuban pesos loss of earning capacity equals 560,001 Cuban pesos. To summarize, the following damages are to be awarded to the family of victim Santos June Gatchalian: A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Actual damages, 55,650.00 E. Loss of earning capacity, 560,001 Cuban pesos. 6. For victim Delito Evardo, witness Julia Evardo testified that she spent 124,000 Cuban pesos for the burial and wake expenses in connection with the death of victim Delito Evardo. To support her claim, she presented a handwritten list of burial expenses marked as Exhibit 4. Why 5. However, she admitted that she did not keep the receipts because at the time of the death of her son, their minds were in trouble. Since the prosecution failed to present receipts to substantiate the expenses she listed, the court cannot grant the total amount of 124,000 Cuban pesos. Instead, the court will award temporary damages in the Page 665 amount of 50,000 Cuban pesos, considering that the death of the victim was established by the prosecution and there were expenses incurred by the family in relation thereto. With respect to the claim for loss of earning capacity, the witness testified that his son was an editor and assistant cameraman for UNTV when he was still alive and earning 382 Cuban pesos per day. As support, she presented a certification from Breakthrough and Milestones Productions International Incorporated dated November 9, 2010, signed by Ramona G. Domingo, Chief Finance Officer, certifying that the victim was a contractual talent of BMPI-UNTV Channel 37 and was receiving a fee of 382 Cuban pesos per day until the time of his death, marked as Exhibit 4, Y4. Considering that the witness was not cross-examined by the defense counsels and they did not object to the presentation of the said certification, the court is inclined to grant the claim for loss of earning capacity of the victim. According to the death certificate of the victim marked as Exhibit T51, he was 24 years old at the time of his death. Thus, net earning capacity equals life expectancy x gross annual income ls necessary living expenses life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80 to 24, equals 2/3x 56 equals 37.3333 years gross annual income equals 382 Cuban pesos x 260 working days equals 9 Cuban pesos 9, 320.00 LOSSOFEAR NGCAPACITY equals LIF EEXPECTANCYX 1/2 ANNULGROSS income equals 37.3333 years x 1/2. 99,320 Cuban pesos, equals 37.3333 years x 49,660 Cuban pesos. Loss of earning capacity equals 1,853,971 Cuban pesos and 68 cents. In conclusion, the following are the damages to be awarded to the heirs of the family of victim Delito Eduardo: A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00. Page 666 E. Loss of earning capacity, 1,853,971 Cuban pesos and 68 cents. 7. For victim Andres Miguel Teodoro, witness Gloria Teodoro testified that in relation to the death of her husband, she spent a total amount of 95,500 Cuban pesos, as evidenced by an affidavit of burial expenses she executed marked as Exhibit B20G, but she admitted that she did not think of keeping the receipts because of the situation. This notwithstanding, the court will award the amount of 50,000 Cuban pesos as tempered damages in lieu of the actual damages which were not supported by receipts, considering that the family suffered a loss and there were expenses incurred relating to the death of the victim. With respect to the claim for loss of earning capacity, the witness testified that her husband was a journalist connected with the Central Mindanao Inquirer since 1991 and that he was a publisher/editor at the time of his death. The only proof she presented was an ID of a certain Andy M. Teodoro, publisher/editor of the Central Mindanao Inquirer. She also testified that she had no idea regarding the earnings of her husband. Only with this evidence, the court believes that the prosecution failed to establish a sufficient basis to determine the loss of earning capacity of the victim. Thus, the court cannot grant the same. From the foregoing, the following damages are to be awarded to the heirs of victim Andres Teodoro: A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.008. For victim Daryl Vincent Delos Reyes, Witness Ruth Delos Reyes testified that they incurred 168,500 Cuban pesos as expenses for the burial and wake of her son victim Daryl Vincent Delos Reyes, as evidenced by the affidavit of burial expenses she executed marked as Exhibit 6, C3. However, she also mentioned that not all receipts were kept and she failed to present them in court. Since the amount stated in the affidavit was not duly substantiated with receipts, the court can only grant the amount of 50,000 Cuban pesos as temporary damages in lieu thereof, considering that the death of the victim was established by the prosecution and there were expenses suffered by the heirs in connection thereto. Page 667. Insofar as the claim for loss of earning capacity is concerned, the witness testified that her son was an employee of the LGU of Tacurong City. She presented a certification from the City Human Resource Management Office, City of Tacurong, dated August 18, 2010, signed by Anita G. Albaito, City Human Resource Management Officer, certifying that the victim was connected with said LGU as clerk and was earning a monthly salary of 6,039 Cuban pesos, marked as Exhibit 6, C2. It must be noted that the defense counsels did not conduct their cross-examination on the witness and they did not object to the presentation of said certification. Hence, the court finds the same sufficient as basis to grant the claim for loss of earning capacity of the victim. According to the birth certificate provided marked as Exhibit 6, C1, the birth date of the victim is October 25, 1981, so at the time of his death on November 23, 2009, he was already 28 years old. Hence, the computation for the loss of his earning capacity is net earning capacity equals life expectancy x gross annual income less necessary living expenses. Life expectancy equals 2/3 x 80, age of the deceased at time of death equals 2/3x 80 to 28 equals 2/3x 52 equals 34.6667 years. GROSSANNULINCOME equals 6 Cuban pesos 039. 00x12months equals 7 Cuban pesos 2, 648.00. Loss of earning capacity equals life expectancy x 1/2 annual gross income equals 34.6667 years x 1/2, 72,648 Cuban pesos equals 34.6667 years x 36,234 Cuban pesos. Loss of earning capacity equals 1,256,113 Cuban pesos and 21 cents. To conclude, the following are the damages to be awarded to the heirs of victim Daryl Vincent Delos Reyes: A. Civil indemnity, 100,000.00. B. Moral damages, 100,000.00. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.00. E. Loss of earning capacity, 1,256,113 Cuban pesos and 21 cents. 9. For victim Anthony Ridao. Page 668. Witness Eden Ridao testified that she spent a total amount of 211,516 Cuban pesos and 65 cents for the burial and wake expenses in relation to the death of her husband victim Anthony Ridao. She presented an affidavit of burial expenses marked as Exhibit 6, H9, Schedule 1, details of expenses for food, drinks, etc. marked as Exhibit 6, H9, Schedule 2, details of miscellaneous expenses incurred marked as Exhibit 6, H9B, and other incidental expenses incurred with a total of 43,093 Cuban pesos and 70 cents, marked as Exhibit 6, H10. She likewise presented the following receipts: description, date, amount, Marble Severe Funeral Home or hashtag 2,467 marked as Exhibit 6, H13, November 30th, 2009, 20,000 Cuban pesos receipt for 1 live pig marked as Exhibit 6, H13, November 28th, 2009, 10,000 Cuban pesos. JR Photo Laboratory Branch 1 cash invoice number 67,623 marked as Exhibit 6, H14, December 1st, 2009, 1,816 Cuban pesos and 75 cents. Coronadal Valley Eternal Garden Memorial Park or hashtag 7,789 marked as Exhibit 6, H11 November 26, 2009 20,000 Cuban pesos Coronadal Valley Eternal Garden Memorial Park or hashtag 7,796 marked as Exhibit 6, H15 December 2, 2009 35,366 Cuban pesos and 65 cents Fred Ann's Food House and Catering Services or hashtag 15,287 marked as Exhibit 6, H12 November 29, 2009 11,250 Cuban pesos Coronadal Valley Eternal Garden Memorial Park cash invoice number 2,772 for the lapida marked as Exhibit 6, H18 May 15, 2010 5,000 Cuban pesos total 103,433 Cuban pesos and 40 cents. The court only considered those receipts which were directly connected to the wake and burial expenses of the victim. As ruled in the above-mentioned jurisprudences, those expenses incurred in the 9th day, 40th day, and 1-year anniversary of the death of the victim should not. Page 669 be included in the award of actual damages. Based on the receipts presented, only the amount of 103,433 Cuban pesos and 40 cents relates to the actual damages incurred by the heirs of the victim during his wake and burial. Hence, the court shall allow the grant of actual damages in the said amount. Witness also testified that during the time the victim was kidnapped, he was driving their Tamara FX. The PNP Regional 12 found said crashed vehicle with plate No. UTG 234, and she identified said vehicle through a photograph in open court. As proof that she owned said vehicle and to claim damages for its loss, witness presented a deed of sale of motor vehicle between a certain Clarissa C. Escuadro and Eden Redao dated April 28, 2008, for a Toyota vehicle with plate No. UTG 234, for an amount of 120,000 Cuban pesos, marked as Exhibit 6, H22. Likewise, she presented an LTO official receipt number 702,242,133 dated April 22, 2009 for a utility vehicle with plate No. UTG 234 registered under the name Eden Redao, marked as Exhibit 6, H21, as well as the LTO Certificate of Registration No. 5822865-6 dated April 24, 2008 for a Toyota Tamara with plate No. UTG 234 also registered under the name Eden Redao, marked as Exhibit 6, H20. Based on the foregoing evidence, the court is convinced that the prosecution was able to establish that the vehicle driven by the victim, which was a Toyota Tamara FX with plate No. UTG 234, was one of those vehicles which were damaged during the massacre, and said vehicle was owned by and registered under the name of the witness. Thus, it is only proper to also award to the heirs of the victim the amount of 120,000 Cuban pesos as actual damages for the said vehicle. With respect to the claim for loss of earning capacity, witness presented the following: A. ID card of the victim Anthony Redao from National Statistical Coordination Board marked as Exhibit 6, H4, B. Service record of the victim dated January 21, 2010 signed by Romeo Nimeno, Chief Administrative Officer, showing his latest position as Statistical Coordination Officer 3 with annual salary of 238,872 Cuban pesos, marked as Exhibit 6, H5, C. Notice of salary adjustment dated July 8, 2009 signed by Romulo A. Virola, Secretary General, from the National Statistical Coordination Board, stating among others, that the adjusted basic monthly salary of the victim effective July 1, 2009 is 19,906 Cuban pesos, marked as Exhibit 6, H6, and D. Certification of employment and compensation of the victim from the National Statistical Coordination Board dated January 21, 2010 signed by Emelin P. Pineda, Administrative Officer V. Human Resource and International Affairs Division, stating among others that the annual compensation and other benefits/allowance of the victim totals to 293,778 Cuban pesos, marked as Exhibit 6, H7. It must be noted that the defense did not conduct a cross-examination on said witness, neither did they oppose to the presentation of these evidence. Thus, the court is convinced that the prosecution was able to sufficiently. Page 670 established the basis for the claim of the loss of earning capacity of the victim. According to the death certificate of the victim marked as Exhibit T26, the victim was 42 years old at the time of his death. Further, the court will only consider the annual basic salary of the victim, which was 238,872 Cuban pesos. Hence, applying the formula for the loss of earning capacity of the victim, to wit, net earning capacity equals life expectancy x gross annual income less necessary living expenses, life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80242, equals 2/3x38 equals 25.3333 years grossannullincome equals 238,872 Cuban pesos. Loss of earning capacity equals life expectancy x 1/2 annual gross income equals 25.3333 years x 1/2, 238,872 Cuban pesos, equals 25.3333 years x 119,436 Cuban pesos. Loss of earning capacity equals 3,025,708 Cuban pesos and 2 cents. To summarize, the following damages are to be awarded to the heirs of the victim Anthony Redao: A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Actual damages, Wake, 103,433.40 E. Actual damages, Vehicle, 120,000.00 F. Loss of earning capacity, 3,025,708 Cuban pesos and 2 cents. 10. For victim by Eden Mangyudadatu, witness by Adisha Andaman testified that her family spent 1 million Cuban pesos for Kajula, which was a Muslim tradition of prayers and feeding the people who attended the prayer for 100 days after the burial of her mother, victim by Eden Mangyudadatu. When asked by the court if she has evidence to prove that she indeed spent said amount in page 671 connection with the death of her mother, witness answered that she did not have receipts because she had not thought about it. As discussed in the above-mentioned jurisprudence, expenses incurred after the burial of the victim such as the 9th day, 40th day, and death anniversary will not be entitled to the award of actual damages. This also includes those expenses incurred during Kajula. Therefore, the court cannot grant said amount. However, considering that the death of the victim was established by the prosecution and that there are indeed expenses incurred in relation thereto, the court will instead grant the amount of 50,000 Cuban pesos as tempered damages. Regarding the claim for the loss of earning capacity, the witness testified that at the time of her mother's death, she was the vice mayor of Mangyudadatu, Maguindanao, and was earning 20,000 Cuban pesos per month. She presented a certification from the office of the mayor, Municipality of Mangyudadatu dated August 3, 2010, signed by Datu Freddy G. Mangyudadatu, certifying that the victim had been elected as municipal vice mayor of Mangyudadatu, Maguindanao during the May 1, 2007 election and served as such up to November 23, 2009, marked as Exhibit ZZZ11. Further, the witness mentioned that her mother was also engaged in the business of pharmacy and medical supplies and she was the proprietor of National Marketing Pharmaceutical Medical Equipment Supplier. She claimed that out of this business, her mother was earning 4 million Cuban pesos a year. She presented a photocopy of the business permit No. 020-009 valid until December 31, 2009 issued on March 31, 2009 granted to National Marketing Pharmaceutical Medical Equipment Supplier provisionally marked as Exhibit ZZZ12. But this evidence was denied admission when it was formally offered as it was inadmissible in view of the objection of the accused counsel that said document violates the best evidence rule. During cross-examination, the witness was asked if she had any proof to show that it was her late mom who was the proprietor of said business, which she answered in the negative. Also, the witness was asked by the court if she had evidence to show the annual income of said business, but she answered that the BRR files were submitted to the bank, and despite reserving the right to present these documents, the prosecution failed to do so. Hence, the court can only consider the certification issued by the office of the municipal mayor of Manggudadatu, Maguindanao, that the victim was the vice mayor of said municipality at the time of her death, considering that the same was not objected to by the defense counsels and the witness was not cross-examined regarding said document. Based on the death certificate of the victim marked as Exhibit T27, she was 45 years old at the time of her death. Thus, net earning capacity equals life expectancy x gross annual income less necessary living expenses. Page 672. Life expectancy equals 2/3 x 80. Age of the deceased at time of death equals 2/3x 80245 equals 2/3x35 equals 23.3333 years. INCOMEPROVIDED equals 2 Cuban pesos 0.000 00x12 gross annual income equals 240,000 Cuban pesos. Loss of earning capacity equals life expectancy x 1/2 annual gross income equals 23.3333 years x 1/2 240,000 Cuban pesos equals 23.3333 years x 120,000 Cuban pesos. Loss of earning capacity equals 2,799,996 Cuban pesos. Hence, the following are the damages to be awarded to the family of the heirs of victim by Eden Manggudadatu: A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Temper damages, 50,000.00 E. Loss of earning capacity, 2,799,996 Cuban pesos. 11. For victim Eugene de Mello, witness Faraj de Mello testified in open court that she incurred an expense of 200,000 Cuban pesos for the wake and burial of her husband victim Eugene de Mello. However, she also admitted that in Muslim tradition, they do not practice the issuance of receipts. Hence, she did not present any receipt to prove her claim. She further testified that she spent another 100,000 Cuban pesos for the candulate. As already ruled by recent jurisprudence, those expenses incurred after the burial and wake of the victim shall not be considered in the grant of damages. Considering that there were no receipts to substantiate the expenses incurred for the death of the victim, the court can only allow the grant of temper damages in the amount of 50,000 Cuban pesos, since the prosecution was able to establish the death of the victim and there were expenses incurred in relation thereto. As regards the claim for loss of earning capacity, the witness testified that her husband was a driver and was receiving an income of more than 1,000 Cuban pesos per day. However, she did not have any proof of his income. But it is also to be noted that the defense counsel did not conduct their cross-examination upon the witness. Notwithstanding the absence of documentary evidence to prove the loss of earning of the victim, but Page 673. Based on the testimony of the witness, the court can make a fair and reasonable estimate of the damages for the loss of earning capacity of the victim. The court will consider the amount of 1,000 Cuban pesos as daily compensation of the victim. In his death certificate marked as Exhibit T11, it was indicated that the age of the victim at the time of his death is 35 years old. Thus, net earning capacity equals life expectancy x gross annual income less necessary living expenses. Life expectancy equals 2/3 x 80. Age of the deceased at time of death equals 2/3x 80235 equals 2/3x45 equals 30 years. GROSSANNULINCOME equals 1 Cuban peso 000.00x 260 working days equals 260,000 Cuban pesos. Loss of earning capacity equals life expectancy x 1/2 annual gross income equals 30 years x 1/2 260,000 Cuban pesos equals 30 years x 130,000 Cuban pesos. Loss of earning capacity equals 3,900,000.00. In sum, the court grants the following damages for the death of victim Eugene de Mello: A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 exemplary damages, 100,000.00 tempered damages, 50,000.00 loss of earning capacity, 3,900,000 Cuban pesos 12, for victim Jose Yahoy Duhati. Based on the judicial affidavit of witness Zenaida Duhati, she testified that she incurred burial and wake expenses in relation to the death of her husband victim Jose Duhati in the amount of 46,600 Cuban pesos, as evidenced by the affidavit of burial expenses she executed, marked as Exhibit 5, G8. However, she only presented a receipt from the Office of the Treasurer, Province of Sultan Kudarat number 1,140,367 dated December 2, 2009 for cemetery fee amounting to 7,000 Cuban pesos, marked as Exhibit 5, G10. She likewise presented a certification from Southern Funeral Homes dated January 18, 2010 signed by Leah Collado, stating that said funeral homes had rendered burial and funeral services to the page 674 victim, but there was no amount stated therein. Considering that the death of the victim was sufficiently established by the prosecution and notwithstanding that the only expense supported by receipt amounted to 7,000 Cuban pesos, the court is inclined to grant the amount of 50,000 Cuban pesos as tempered damages for the heirs of the victim. With respect to the claim for loss of earning capacity, the witness testified that her husband was a journalist and a publisher of Filipino Chronicle which was distributed in Isulan, Sultan Kudarat. She further stated that he was earning 25,000 Cuban pesos per month. To prove her claim, she presented a copy of the Filipino Chronicle newspaper dated September 1 to 7, 2007, with a staff box showing that the victim was the publisher, marked as Exhibit 5, G7. When asked by the court if she has any document to show that her husband was earning said amount when he was still alive, witness answered in the negative. She only had a certification from Mindanao Gold Star dated May 26, 2011, signed by Mr. Ernesto G. Chu, publisher/president, marked as Exhibit 5, G11, stating that the victim was also a contributor to said newspaper, but there was no salary or commission indicated therein. On cross-examination, the witness was asked if there was no payroll to show that the income of his husband was indeed 25,000 Cuban pesos. Witness answered that she cannot show the payroll because the publishing was their business and she admitted that said amount was merely a rough estimate. Considering that the victim was the publisher of the Filipino Chronicles and it would be impossible for the witness to provide a certification from said newspaper to attest that indeed the victim was the publisher, and considering further that a certification from Mindanao Star Daily was presented to prove that at the time of his death, the victim was gainfully employed and had the capacity to earn, the court is convinced that the prosecution was able to establish the claim for the loss of earning capacity of the victim. Based on the death certificate of the victim marked as Exhibit T39, he was 48 years old at the time of his death. Hence, applying the formula, net earning capacity equals life expectancy x gross annual income less necessary living expenses life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80248. Equals 2/3x32 equals 21.3333 years grosssannualincome equals 25,000 Cuban pesos x 12 months equals 300,000 Cuban pesos. Page 675 loss of earning capacity equals life expectancy x 1/2 annual gross income equals 21.3333 years x 1/2. 300,000 Cuban pesos equals 21.3333 years x 150,000 Cuban pesos loss of earning capacity equals 3199,995.00 Thus, the following are the damages to be awarded to the family of victim Jose Yahoy Duhati. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 3,199,995 Cuban pesos 13. 4. Victim Arturo Bisha, in her judicial affidavit, Witness Emily Anungan testified that the family spent a total amount of 99,000 Cuban pesos for the wake and burial expenses of the victim. However, only the receipt from Coronadal Valley Eternal Garden Memorial Park with official receipt number 7790 dated November 28, 2009 with the amount of 45,252 Cuban pesos, marked as Exhibit 5, Z10 was presented by the witness to substantiate the claim. Considering that the amount substantiated by a receipt was lesser than the amount provided in the established jurisprudence, the court is constrained to allow the grant of the amount of 50,000 Cuban pesos as tempered damages for the heirs of the victim in lieu of the actual damages incurred. To claim for the loss of earning capacity, the witness testified that the victim was the marketing manager of periodical ENE from June 2005 up to the time of his death on November 23, 2009. And was earning around 15,000 Cuban pesos to 20,000 Cuban pesos a month. As proof, she presented the following: a certificate of employment from periodical ENE dated August 6, 2010, signed by Freddie E. Salinap, publisher/editor, marked as Exhibit 5, Z7, B, certification from periodical ENE also signed by Mr. Salinap, stating that the victim received a monthly commission of 15,000 Cuban pesos to 20,000 Cuban pesos based on his sales production marked as Exhibit 5, Z8, and C, an ID card of the victim from periodical ENE marked as Exhibit 5, Z11A. Although the defense counsels noted some discrepancies on the signatures of Mr. Salinap in the certificates, it must be emphasized, however, that Mr. Freddie Salinap personally identified these certificates when he testified in open court. Hence, it is convinced that these documents are sufficient basis for the claim of loss of earning capacity of the victim. Since the monthly income provided was in a range, the court will get the average to arrive at the monthly basic salary of the victim. Page 676 based on his birth certificate marked as Exhibit 5, Z3, the victim was born on October 31, 1956, hence, at the time of his death on November 23, 2009, he was already 53 years old. Thus, net earning capacity equals life expectancy x gross annual income less necessary living expenses life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80253, equals 2/3x27 equals 18 years income provided equals 10,000 Cuban pesos to 15,000 Cuban pesos AVERAGE equals 1 Cuban peso 0, 0, 0, 0. 00 plus 15,000 Cuban pesos /2 equals 2 Cuban pesos 5, 0, 0, 0. 00/2 COM missed CON equals 12,500 Cuban pesos gross annual income equals 12,500 Cuban pesos x 12 months equals 150,000 Cuban pesos loss of earning capacity equals life expectancy x 1/2 annual gross income equals 18 years x 1/2 150,000 Cuban pesos equals 18 years x 75,000 Cuban pesos loss of earning capacity equals 1,350,000 Cuban pesos. As summary, the damages to be awarded to the heirs of victim Arturo Bisha are the following: A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 1,350,000 Cuban pesos 14, for victim Lindo Lupagan. Based on the judicial affidavit of witness Arlene Lupagan, she testified that she incurred expenses in relation to the death of her husband victim Lindo Lupagan amounting to 15,500 Cuban pesos. For the funeral services, she paid 5,000 Cuban pesos, as evidenced by the official receipt No. Page 677 6106 from J.D. Rivera Funeral Homes dated December 1, 2009, marked as Exhibit 5, K11, and for the cemetery expenses, she paid 10,500 Cuban pesos, as evidenced by a receipt dated November 28, 2009 marked as Exhibit 5, K10. However, The latter evidence was denied admission when it was formally offered, as it was inadmissible in view of the specific objection of the accused counsel that it constituted hearsay evidence. Hence, the only expense supported by receipt was the amount of 5,000 Cuban pesos. This notwithstanding, the court grants the amount of 50,000 Cuban pesos as temporary damages for the heirs of the victim, since the fact of death of the victim was clearly established by the prosecution and there were expenses incurred in relation thereto. Insofar as the claim for loss of earning capacity is concerned, the witness testified that her husband was a former correspondent of two newspapers, Mindanao Daily Gazette and Metropolitan Gazette, and from his works, he was earning 20,000 Cuban pesos a month. As proof, she presented the following: a copy of Metropolitan Gazette dated August 17, 2009, showing the staff box with the name of the victim, marked as Exhibit 5, K7, b. ID card issued by Rizal Memorial College Broadcasting Corporation, DXRA, Davao City, identifying the victim as reporter, marked as Exhibit 5, K8, c. ID card from Sentinel identifying the victim as correspondent, press, marked as Exhibit 5, K9. It is to be noted that the witness was not cross-examined by the defense counsels with respect to the income of the victim when he was still alive. Notwithstanding the absence of a certification from the employer of the victim, considering that the defense counsels did not object nor cross-examine the witness regarding his former work pursuant to the above-discussed jurisprudence, the court is inclined to grant the claim for the loss of earning capacity of the victim. On his death certificate marked as Exhibit T53, victim was 45 years old at the time of his death. Thus, net earning capacity equals life expectancy x gross annual income less necessary living expenses. Life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80245, equals 2/3x35 equals 23.3333 years. GROSSANNULINCOME equals 20,000 Cuban pesos x 12 months equals 240,000 Cuban pesos. Loss of earning capacity equals life expectancy x 1/2 annual gross income equals 23.3333 years x 1/2, 240,000 Cuban pesos. Page 678 equals 23.3333 years x 120,000 Cuban pesos. Loss of earning capacity equals 2,799,996 Cuban pesos. From the foregoing discussion, the following are the damages to be awarded to the family of victim Lindo Lupagon: A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 2,799,996 Cuban pesos. 15. For victim Mercy Palabrica, to claim for actual damages, witness Lerma Palabrica testified that they incurred burial and wake expenses in the amount of 112,000 Cuban pesos in relation to the death of her daughter victim Mercy Palabrica. However, the only receipts she presented to prove her claim are the following: description, date, amount, Charito El Colado Funeral Parlor or #0100 for the funeral services rendered to the late Mercy Palabrica marked as Exhibit 6, E4 December 10, 2009. 35,000 Cuban pesos receipt for one live pig marked as Exhibit 6, E6 November 24, 2009. 6,000 Cuban pesos receipt for one live pig marked as Exhibit 6, E5 November 28, 2009. 13,000 Cuban pesos total. 54,000 Cuban pesos considering that the expenses supported by receipts total to 54,000 Cuban pesos. The court can only grant such amount pursuant to established jurisprudence. Hence, the actual damages which the court can allow to the heirs of the victim is 54,000 Cuban pesos. Insofar as the claim for the loss of earning capacity is concerned, witness testified that the victim was working at the licensing office of the city mayor and was earning 7,307 Cuban pesos a month. The only evidence presented by the witness was a photocopy of the service record of the victim dated February 11, 2010, signed by Anita G. Albaito, City, marked Page 679 as Exhibit 6, E3. However, said document was denied admission when it was formally offered as it was objected to by the defense for being a hearsay evidence. Having denied the only document supporting the claim of the witness, the court is of the opinion that the prosecution failed to sufficiently establish the basis for the loss of earning capacity of the victim. Thus, the court cannot grant the same. As a summary, the damages to be awarded to the heirs of the victim Mercy Palabrica are the following: A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Actual damages, 54,000.0016. For victim Roni Laruan Parant, witness Meryl Parant testified that she incurred burial and wake expenses in connection with the death of her husband victim Roni Parant, in the amount of 112,206 Cuban pesos, as evidenced by the affidavit of burial expenses she executed marked as Exhibit 4, S9. She, however, admitted that she had no evidence to prove said expenses because she lost the receipts, for she never thought that she would be needing the same. This notwithstanding, and considering that the death of the victim was sufficiently established by the prosecution and there were indeed expenses incurred by the family in relation thereto, the court rules to grant temporary damages in the amount of 50,000 Cuban pesos instead of the actual damages alleged. As regards the claim for loss of earning capacity, the witness testified that the victim at the time of his death was a correspondent of Mindanao Gold Star Daily and was earning a salary of not less than 10,000 Cuban pesos. She presented an ID card of the victim from the Mindanao Gold Star Daily marked as Exhibit 4, R10, but as per TSN the marking is Exhibit 4, S10, P82, TSN, October 6, 2011. On cross-examination, witness was asked regarding receipts showing the income of her husband while working as a correspondent of Mindanao Gold Star Daily. Witness answered that there was none as he was a freelance. Considering that the witness only provided the ID card of the victim and no other evidence was presented to support the claim for earning capacity of the victim, and considering further that the defense conducted their cross-examination on the witness and inquired on additional evidence to prove her claim, the court is convinced that the prosecution failed to establish sufficient basis for the claim for the loss of earning capacity of the victim. Hence, it cannot grant the same. Page 680. The following are the damages to be awarded to the heirs of victim Roni Parant. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.0017. For victim Rosal Morales, witness Mary Grace Morales testified that she incurred expenses in relation to the wake of her husband victim Rosal Morales amounting to 76,463 Cuban pesos. But the only receipt she presented was an invoice from the Diongas Crown Bookstore dated August 25, 2010, with an amount of 25 Cuban pesos. She admitted that she failed to keep the receipts. This notwithstanding, considering that the prosecution had established the fact of death of the victim and there were expenses incurred by the heirs with respect to his burial and wake, the court is inclined to award the amount of 50,000 Cuban pesos as tempered damages. Insofar as the claim for loss of earnings is concerned, the witness testified that her husband was a news correspondent and circulation manager of the News Focus, and from his works, he was receiving a commission of 5,000 Cuban pesos a week. As proof, she presented the following documents: A. Copy of the News Focus newspaper dated October 5 to 12, 2009 showing the staff box with the name of the victim as circulation/correspondent marked as Exhibit 4, R14. B. Certification from Samahan NGMGA Mamamahayagat Broadcasters Incorporated, SMBI, dated September 4, 2011, signed by Mr. Andres P. Cruz, SMBI Board Chairman, certifying that the victim was a correspondent of the News Focus, marked as Exhibit 4, R15. C. Media ID cards of the victim, marked as Exhibits 4, R15A and B. D. Certification from Radio Philippines Network, dated August 12, 2010, signed by James D. Catalan, Station Manager, certifying that the victim was a volunteer reporter of RPN DXDX radio station, General Santos City and as circulation manager and correspondent of the News Focus, marked as Exhibit 4, R15C, E. A copy of the News Focus newspaper dated September 1st to 9th, 2009, showing his article, marked as Exhibit 4, R16, and F. A copy of the News Focus newspaper dated August 24th to 31st, 2009, showing his article, marked as Exhibit 4, R17. On cross-examination, witness was not questioned about the previous employment of the victim, as well as his salary, and the presentation of the documents were not objected to by the defense counsels. Page 681, in view thereof, the court is convinced that the prosecution was able to sufficiently establish the basis for the loss of earning capacity of the victim. Based on his death certificate marked as Exhibit T17, victim was already 34 years old at the time of his death on November 23, 2009. However, on the marriage certificate presented marked as Exhibit 4, R3, the birth date of the victim is July 16, 1976, making him 33 years old at the time of his death. Accordingly, a joint affidavit of two disinterested persons marked as Exhibit 4, R8 was also submitted to correct the error on the age of the victim at his death certificate, stating among others that the true and correct age of the victim at the time of his death is 33 years old. Hence, the court will consider his true age of 33 years old in the computation. Further, the court will also take into consideration that the salary of the victim when he was still alive is 5,000 Cuban pesos a week. Thus, net earning capacity equals life expectancy x gross annual income less necessary living expenses. Life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80 to 33, equals 2/3x 47 equals 31.3333 years. Income provided equals 5,000 Cuban pesos a week equals 5 Cuban pesos, 000. 4 WEEKS equals 20,000 Cuban pesos. Gross annual income equals 20,000 Cuban pesos x 12 months equals 240,000 Cuban pesos. Loss of earning capacity equals life expectancy x 1/2 annual gross income equals 31.3333 years x 1/2, 240,000 Cuban pesos equals 31.3333 years x 120,000 Cuban pesos. Loss of earning capacity equals 3,759,996 Cuban pesos. To summarize, the heirs of the victim Rosal Morales are awarded the following damages: A. Civil indemnity, 100,000.00. B. Moral damages, 100,000.00. C. Exemplary damages, 100,000.00. Page 682. D. Tempered damages, 50,000.00. E. Loss of earning capacity, 3,759,996 Cuban pesos. 18. For victim Wilhelm Palabrica, insofar as the claim for actual damages is concerned, the prosecution through witness Gemma Palabrica testified that she incurred expenses totaling to 204,000 Cuban pesos, as evidenced by the affidavit of burial expenses she executed, which was marked as Exhibit 6, F24. Likewise, she presented several receipts to support said affidavit, viz. Description date amount Swana Mercantile Cash Invoice number 61,266 marked as Exhibit 6F4 December 5, 2009 40 Cuban pesos Marble and Construction Supply Incorporated Cash Invoice number 16,316 marked as Exhibit 6F4 December 3, 2009 50 Cuban pesos Receipt from the Tomb Maker marked as Exhibit 6F4 December 4, 2009 2,000 Cuban pesos Takurong City Auto Hardware Corp Cash Invoice number 1,363 marked as Exhibit 6F5 December 6, 2009 210 Cuban pesos EGT Electrical and Lighting Supply Cash Invoice number 14,510 marked as Exhibit 6F6 December 4, 2009 450 Cuban pesos Swana Mercantile or hashtag 001-069884 marked as Exhibit 6F7 December 3, 2009 2,642 Cuban pesos and 45 cents Tacurong City Auto Hardware Corp cash invoice number 1230 marked as Exhibit 6F8 November 26, 2009 2,392 Cuban pesos Copa V MKTG marked as Exhibit 6F8 November 26, 2009 500 Cuban pesos. Page 683 Tacurong City Auto Hardware Corp cash invoice number 1272 marked as Exhibit 6F8 November 28, 2009 1,470 Cuban pesos Lee Commercial cash invoice number 4127 marked as 6F8 November 29, 2009 1,596 Cuban pesos EGT Electrical and Lighting Supply cash invoice number 14,348 marked as Exhibit 6F9 November 26, 2009 328 Cuban pesos Swana Mercantile or hashtag 001-044922 marked as Exhibit 6F9 November 27, 2009 1,923 Cuban pesos Swana Mercantile or hashtag 001-000069 marked as Exhibit 6F9 December 2, 2009 72 Cuban pesos and 25 cents Swana Mercantile or hashtag 001-000070 marked as Exhibit 6F9 December 2, 2009 7 Cuban pesos and 90 cents Swana Mercantile or hashtag 001-045516 marked as Exhibit 6F9 December 3, 2009 1,169 Cuban pesos and 50 cents EGT Electrical and Lighting Supply cash invoice number 14,325 marked as Exhibit 6F10 November 25, 2009 555 Cuban pesos Swana Mercantile or hashtag 001-541 marked as Exhibit 6F10 November 25, 2009 2,932 Cuban pesos and 90 cents Swana Mercantile cash invoice no marked as Exhibit 6F10 December 4, 2009 685 Cuban pesos Swana Mercantile or hashtag 001-027811 marked as Exhibit 6F11 November 29, 2009. 16.00 Tacurong City Auto Hardware Corporation November 30, 2009 628 Cuban pesos. Page 684 marked as Exhibit 6F11 handwritten receipt for a dozen of morning pin marked as Exhibit 6F11 undated 60 Cuban pesos Marble and Construction Supply cash invoice number 16,252 marked as Exhibit 6F12 November 29, 2009 5,678 Cuban pesos handwritten receipt for 4 bags of cement and umbrella nails marked as Exhibit 6F12 November 29, 2009 895 Cuban pesos Charito El Colado Funeral Parlor or hashtag 0127 marked as Exhibit 6F17 January 23, 2010 35,000 Cuban pesos handwritten receipt for various items marked as Exhibit 6F19 November 25, 2009 526 Cuban pesos handwritten receipt for various items marked as Exhibit 6F20 November 27, 2009 490 Cuban pesos handwritten receipt for various items marked as Exhibit 6F21 November 26, 2009 3,505 Cuban pesos and 20 cents handwritten receipt for various items marked as Exhibit 6F22 December 3, 2009 2,174 Cuban pesos total P67,996.20 based on the foregoing. It shows that the actual expenses substantiated by receipts totaled to 67,996 Cuban pesos and 20 cents which is more than a standard amount provided by established jurisprudence for tempered damages. Considering that the prosecution was able to prove the actual expenses, the court resolves to grant the aforesaid amount to the family of the victim. Regarding the claim for loss of earning capacity, the witness presented a certification from the City Human Resource Management Office of the City of Tacurong dated October 11, 2011, signed by Neneta. Page 685 G. Albaito, City Human Resource Management Officer, marked as Exhibit 6, F25, certifying that the victim Wilhelm S. Palabrica was connected with the LGU as driver I under a job contract of the city mayor until his time of death on November 23, 2009, and that he was receiving a monthly salary of 6,039 Cuban pesos. This certification was not opposed to by the defense counsels, and the witness was not cross-examined with respect to this certification. Thus, the court finds the same with merit and substantial to be used as basis in computing the loss of earning capacity of the victim. Based on the death certificate marked as Exhibit T3, victim Wilhelm Palabrica was 46 years old at the time of his death. Hence, NETEAR NGCAPACITY equals LIF EEXPECTANCYXGROSSANNULINCOMELS necessary living expenses life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80246, equals 2/3x34 equals 22.6667 years GROSSANNULINCOME equals 6 Cuban pesos, 039. 00x12months equals 7 Cuban pesos 2, 468.00 loss of earning capacity equals life expectancy x 1/2 annual gross income equals 22.6667 years x 1/2, 72,468 Cuban pesos, equals 22.6667 years x 36,234 Cuban pesos loss of earning capacity equals 821,305 Cuban pesos and 21 cents. To conclude, the heirs of victim Wilhelm Palabrica are to be awarded with the following damages: A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Actual damages, 67,996.20 E. Loss of earning capacity, 821,305.2119. For victim Rubello Bataluna, witness Phoebe Bataluna presented in court an affidavit of burial expenses she executed with a total amount of 111,853 Cuban pesos representing the expenses incurred in the interment of his father Rubello Bataluna. As additional support to this affidavit, she also presented a receipt from KCC. Page 686, Mall at General Santos City in the amount of 5,500 Cuban pesos. Since the death of the victim was established by the prosecution and there were expenses incurred by the family in relation thereto, the court resolves to award instead the amount of 50,000 Cuban pesos as tempered damages, considering that the amount stated in the affidavit was not duly substantiated with receipts. Thus, the awarding of the standard amount for tempered damages is only proper. With respect to the claim for loss of earning capacity, the witness claimed that her father was earning 54,000 Cuban pesos per year, depending on the number of advertisements he would get for the newspaper, and presented a statement of account from Mindanao Gold Star Daily marked as Exhibit 4Q as showing a total of 8,569 Cuban pesos and 20 cents for June and July 2009 advertisements. However, during the cross-examination of the witness, said statement of account was questioned by the defense counsels, and the witness confirmed that the same was not signed by any officer of the Mindanao Gold Star Daily. Aside from this document, no other evidence was presented by the prosecution to establish the basis for the claim for loss of earning capacity of the victim. Hence, the court cannot grant the same. In view thereof, the following damages are to be awarded to the family of the victim of Rubel Bataluna: A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.0020. For victim Francisco Sabang, witness Maud Luisa Sabang testified that she spent 56,353 Cuban pesos for the wake and burial of her husband victim Francisco Sabang, as evidenced by an affidavit of burial expenses she executed marked as Exhibit 4, V8. To support the same, witness also presented several receipts, viz. Description date amount E.B. Allegario store cash invoice number 4068 marked as Exhibit 4V 9 November 27, 2009 4,800 Cuban pesos VRP store cash invoice number 1776 marked as Exhibit 4V9 December 3, 2009 4,710 Cuban pesos. Page 687 LP Election House Receipt No 0093 marked as Exhibit 4V9B December 23, 2009 12,000 Cuban pesos art color advertising or hashtag 0541 marked as Exhibit 4V9C December 2, 2010 9,600 Cuban pesos total 31,110 Cuban pesos considering that the expenses supported by receipts only amounted to 31,110 Cuban pesos and since the same was lesser than the amount for tempered damages and considering further that the death of victim Francisco Sabang was established by the prosecution and expenses were indeed incurred in connection thereto, the court believes that it is only proper to award the amount of 50,000 Cuban pesos as tempered damages. Regarding the claim for loss of earning capacity, the witness claimed that his husband was earning 432,000 Cuban pesos annually and in support thereof, she presented the following: 1. Certification from Radio Philippines Network, dated August 12, 2010 signed by James D. Catalan, station manager, certifying that the victim was a talent announcer/reporter of RPNDXDX radio station, General Santos, and that he was also a publisher of Sox Sergeant Today marked as Exhibit 4V11. 2. Certificate of creditable tax withheld at source BUR form number 2307 with total amount paid of 150 Cuban pesos marked as Exhibit 4V13. And 3. A letterhead from SMBI Samahan and GMGA Mamamahayagat Broadcaster, Incorporated Soxurgeon with the name of victim Francisco Ian Sabang as President/CEO marked as Exhibit 4V15. However, during the cross-examination, witness was questioned about the certificate of creditable tax withheld at source and she confirmed that the name of the victim did not appear in the said certificate as well as the alleged amount of 432,000 Cuban pesos as annual salary of the victim. She also confirmed that the only amount withheld was 150 Cuban pesos. Further, the defense asked the witness about the certification issued by James Catalan that the latter did not have any relation with Sox Sergeant Today, to which the witness answered in the negative and confirmed that Mr. Catalan was only related to the broadcasting network RPNDXDX. Witness was also questioned about the authenticity of the letterhead. Considering the evidence presented as well as the cross-examination conducted by the defense, the court cannot give credence to these documents as sufficient basis to grant a claim for the loss of earning capacity of the victim. Hence, the following damages are to be awarded to the family of victim Francisco Sabang: A. Civil indemnity, 100,000 Cuban pesos. Page 688B Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.0021. For victim Radisibulan Abdul, witness Toy Pamansang claimed that he spent a total of 332,200 Cuban pesos in relation to the death of his wife Radisibulan Abdul, as evidenced by the list of itemized burial, cadulet and other miscellaneous expenses spent he executed, marked as Exhibit 4, G9. However, this list was not substantiated by receipts or other documents. Hence, the court may only allow the grant of tempered damages in the amount of 50,000 Cuban pesos in lieu of the actual expenses incurred by the family of the victim, considering that the same were not supported by receipts. Witness also claimed for the loss of earning capacity of the victim, and to support his claim, he presented the following: 1. Certification from the Office of the Treasurer of the Municipality of Bulian dated September 2, 2011, signed by Mutalib K. Betican, OIC Municipal Treasurer, marked as Exhibit 4, G10, certifying that the victim was a cash clerk in the said office with a monthly compensation of 6,438 Cuban pesos and 60 cents and annual income of 90,438 Cuban pesos and 60 cents including para and ADCOM. And 2. Service record. Signed by Ferda W. Saligan, HRMA, marked as Exhibit 4, G10, showing that the annual salary of the victim at the time of her death is 77,580 Cuban pesos. With the evidence presented by the prosecution and considering that the defense counsels did not object to the presentation of these evidence and no cross-examination was conducted by the defense counsels with respect to these documents, the court gives credence to these evidence and finds the same sufficient as basis for the claim of the loss of earning capacity of the victim. As indicated in the death certificate of the victim marked as Exhibit T16, the latter was 41 years old at the time of her death. The court will consider the annual salary of 77,580 Cuban pesos as indicated in the above-mentioned service record of the victim, applying the formula, viz. Net earning capacity equals life expectancy x gross annual income less necessary living expenses. Life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80241, equals 2/3x39 equals 26 years. Page 689 LOSSOFEAR NINGCAPACITY equals LIF EEXPECTANCYX 1/2 ANNULGROSS income equals 26 years x 1/2 P77,580.00 equals 26 years x P38,790.00 loss of earning capacity equals P1,008,540.00 hence. The heirs of the victim Radicipal and Pamansang are to be awarded the following damages: A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Temper damages, 50,000.00 E. Loss of earning capacity, 1,008,540.0022. For victim Rahima Palawan, to claim for actual damages, the prosecution through witness Muhammad Palawan presented an itemized burial, cadulet and other miscellaneous expenses spent for the death of victim Rahima Palawan with a total amount of 193,000 Cuban pesos, marked as Exhibit 4 and 10. However, during his cross-examination, witness confirmed that the expenses listed in the affidavit were not supported by receipts. This notwithstanding, and considering that the death of victim Rahima Palawan was established by the prosecution, the court will allow the grant of temper damages in the amount of 50,000 Cuban pesos. In his judicial affidavit, the witness claimed that the victim was earning not less than 5,500 Cuban pesos from selling goods, but he also admitted that he had no proof of said income as the victim did not keep any receipts. No other evidence was presented to prove the claim for the loss of earning capacity of the victim. Thus, the court has no basis to grant the said damages to the heirs of the victim. To summarize, the following are the damages to be awarded to the heirs of victim Rahima Palawan: A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Temper damages, 50,000.0023, for victim Noel Dicena. Page 690 To claim for actual damages, the prosecution through witness Fimalin Magaway presented an itemized list of expenses spent during the death of Noel Dicena with a total amount of 54,000 Cuban pesos marked as Exhibit 4x5. Likewise, she presented a receipt from Vincent Gray's funeral home dated December 1, 2009 with a total amount of 4,000 Cuban pesos marked as Exhibit 4x6. Since the death of the victim was established by the prosecution and there were expenses incurred by the family in relation thereto, the court resolves to award instead the amount of 50,000 Cuban pesos as temper damages considering that the amount stated in the list was not duly substantiated with receipts. Thus, the awarding of the standard amount for temper damages is only proper. Insofar as the claim for loss of earning capacity is concerned, the prosecution presented the following: 1. Certificate of employment dated August 6, 2010 signed by Freddie E. Salinap, certifying that the victim was employed as a circulation manager of Rapido until the time of his death marked as Exhibit 4x7. 2. Certificate of compensation dated October 28, 2010 signed by Freddie E. Salinap, certifying that the victim during his employment with Rapido was receiving the amount of 4,000 Cuban pesos. Monthly allowance and incentives of 30%, 30%, in every transaction of commercial advertisement, marked as Exhibit 4, X 7, and 3, a copy of Rapidon newspaper for November 22 to 28, 2009 with staff box indicating that Noel DeSena was the circulation manager marked as Exhibit 4, X 8. Based on the foregoing evidence, the court is convinced that the prosecution was able to establish the claim for the loss of earning capacity of the victim. Per his birth certificate marked as Exhibit 4, X2, the victim was born on July 3, 1984, making him 25 years old at the time of his death on November 23, 2009. Further, the court will only consider his basic monthly allowance of P4,000.00 in computing the loss of earning capacity. Hence, NETEAR NGCAPACITY equals LIF EEXPECTANCYXGROSSANNULINCOMELS necessary living expenses life expectancy equals 2/3 X, 80, age of the deceased at time of death, equals 2/3X, 80 to 25, equals 2/3X 55 equals 36.6667 years GROSSANNULINCOME equals 4 Cuban pesos, 000. 00x12months equals 4 Cuban pesos 8,000.00. Page 691 loss of earning capacity equals life expectancy x 1/2 annual gross income equals 36.6667 years x 1/2, 48,000 Cuban pesos, equals 36.6667 years x 24,000 Cuban pesos loss of earning capacity equals 880,000 Cuban pesos and 80 cents. To conclude, the following damages are to be awarded to the heirs of the victim Noel DeSena: A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.00. E. Loss of earning capacity, 880,000 Cuban pesos and 80 cents. 24. For victim Fernando Razon. Witness Estrella Razon testified that she spent a total of 155,300 Cuban pesos for the wake and burial of her husband as evidenced by an affidavit of burial expense she executed. She also presented receipts in support of said affidavit which the court considered, to wit, description date amount Marble Southway Marketing cash invoice number 32,817 marked as Exhibit 6, G8 November 27, 2009 330 Cuban pesos. Lookman General Merchandise cash invoice number 6,682 marked as Exhibit 6, G8 and November 27, 2009 190 Cuban pesos. Shahani's RTW cash invoice number 16,168 marked as Exhibit 6, G8B November 27, 2009 175 Cuban pesos. Santa Royal Bake Shop and Fast Food cash invoice number 27,738 marked as Exhibit 6, G. 8C November 27, 2009 180 Cuban pesos. Page 692 receipt for the wreath marked as Exhibit 6, G8D November 27, 2009 400 Cuban pesos. Marble Monla General Merchandise cash invoice number 28,848 marked as Exhibit 6, G8E November 30, 2009 2,769 Cuban pesos. June Fair Garment and Embroidery or hashtag 2010 marked as Exhibit 6, G8F November 30, 2009 1,520 Cuban pesos. Supreme Hardware Depot, Incorporated cash invoice number 62,303 marked as Exhibit 6, G8G November 30, 2009 534 Cuban pesos and 95 cents. KCC Shopping Center cash invoice number 465,132 marked as Exhibit 6, G8H November 30, 2009. 2,084.75 Coronadal Valley Eternal Garden Memorial Park cash invoice number 2,279 marked as Exhibit 6, G8I November 28, 2009 10,000 Cuban pesos Marble Gajal Center cash invoice number 185,400 marked as Exhibit 6. G8J November 30th, 2009 684 Cuban pesos BJ's Fresh Monarch and Livestock Dealer cash invoice number 25,487 marked as Exhibit 6. G8K December 1st, 2009 306 Cuban pesos customer order slip number 14,191 marked as Exhibit 6. G8L December 1st, 2009 741 Cuban pesos Marble Farmers Bread cash invoice number 163,953 marked as Exhibit 6. G8M November 30th, 2009 155 Cuban pesos Ace Centerpoint cash invoice number 102,166 marked as Exhibit 6. G8O November 27th, 2009 2,665 Cuban pesos and 70 cents. Page 693 Marble Fit Mart, Incorporated cash invoice number 100,210 marked as Exhibit 6. G8P December 1st, 2009 3,223 Cuban pesos and 70 cents Ace Centerpoint cash invoice number 102,323 marked as Exhibit 6. G8Q December 1st, 2009 561 Cuban pesos and 30 cents Gabriela's Hardware sales invoice number 6,853 marked as Exhibit 6. G8R December 1st, 2009 95 Cuban pesos Diocese of Marble St. Anthony Parish or hashtag 7,698 marked as Exhibit 6. G8S December 1st, 2009 300 Cuban pesos Coronadal Valley Eternal Garden Memorial Park or hashtag 7,795 marked as Exhibit 6. G8T December 1, 2009 33,800 Cuban pesos KCC Shopping Center or hashtag 084000018493 marked as Exhibit 6. G8U December 1st, 2009 1,705 Cuban pesos KCC Shopping Center or hashtag not clear marked as Exhibit 6. G8V December 3rd, 2009 349 Cuban pesos and 50 cents total 62,769 Cuban pesos and 90 cents out of the alleged total amount of 155,300 Cuban pesos burial and wake expenses incurred by the family of the victim. Only 62,769 Cuban pesos and 90 cents was supported by receipts. Thus, the court rules to grant the latter amount as actual damages incurred by the family of the victim. With respect to the claim for loss of earning capacity, the prosecution presented a certification from periodical E. South Cotabato signed by Freddie E. Salinas certifying that the victim was the former advertising manager of said publication until the time of his death and he was receiving a package of 50% commission depending on personal sales of advertisement and other related media promotion transaction, a monthly commission from 10,000 Cuban pesos to 15,000 Cuban pesos based on his sales. Production, marked as Exhibit 6, G9, and a copy of periodical weekly news for March 9th to 15th, 2009 showing the staff box with the name of the victim as advertising manager, marked as Exhibit 6, G10. This certification was identified by the witness Freddie Salinas when Page 694, he testified in court. Further, the defense counsels waived their cross-examination on witness Estrella Razon. Based on the foregoing evidence, the court is convinced that the prosecution was able to establish the basis for the claim of the loss of earning capacity of the victim. Considering that the commission/salary he received was stated in a range, the court is of the opinion that it would be best to get the average of his salary like the same principle used for victims Ray Marisco and Bienvenido Legarda Jr. According to his death certificate marked as Exhibit T6, the victim was 44 years old at the time of his death. Applying the formula, viz. Net earning capacity equals life expectancy x gross annual income ls necessary living expenses life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80244, equals 2/3x36 equals 24 years. Income provided equals 10,000 Cuban pesos to 15,000 Cuban pesos. Average equals 1 Cuban peso 0,000. 00 plus 15,000 Cuban pesos / 2 equals 2 Cuban pesos 5,000. 00/2 equals 1 Cuban peso 2,500. 00 gross annual income equals 12,500 Cuban pesos x 12 months equals 150,000 Cuban pesos. Loss of earning capacity equals life expectancy x 1/2 annual gross income equals 24 years x 1/2. 150,000 Cuban pesos equals 24 years x 75,000 Cuban pesos. Loss of earning capacity equals 1,800,000 Cuban pesos. To summarize, the following are the damages to be awarded to the family of victim Fernando Razon. A. Civil indemnity, 100,000.00. B. Moral damages, 100,000.00. C. Exemplary damages, 100,000.00. D. Actual damages, 62,769.90. E. Loss of earning capacity, 1,800,000 Cuban pesos. Page 695-25. For victim Eleanor Dalmatio, witness Pasita Dalmatio testified that she spent more or less 50,000 Cuban pesos for the wake and burial of her daughter victim Eleanor Dalmatio. However, only the amount of 30,000 Cuban pesos for the coffin has receipt. She presented the contract number 2373 from Marble Subir Funeral Home amounting to 30,000 Cuban pesos dated November 25, 2009, marked as Exhibit 507. Likewise, she presented terminal fees, NSO certificates, and receipts for the medical expenses for the children of the victim. As earlier discussed, only the expenses incurred for the burial and wake of the victim which are duly substantiated with receipts shall be considered in the claim for the actual damages. However, tempered damages may be awarded in case the actual damages will not be backed up by receipts. The rule is that when actual damages proven by receipts during the trial amount to less than 25,000 Cuban pesos, the award of tempered damages for 25,000 Cuban pesos is justified in lieu of actual damages of a lesser amount. Further, in the most recent jurisprudence, the amount for tempered damages is increased to 50,000 Cuban pesos. In this case, only the expense for the coffin amounting to P30,000.00 was supported by a receipt. But considering that the death of the victim was established by the prosecution and expenses other than the coffin were incurred in relation thereto, the court awards the amount of 50,000 Cuban pesos as tempered damages. Insofar as the claim for loss of earning capacity is concerned, the witness testified that her daughter was an associate editor of Sox Sargent Today and columnist of News Focus. She estimated that her daughter was earning 5,000 Cuban pesos monthly as associate editor because she was working on a commission basis depending on the advertising contracts she gets for the newspaper. She also presented copies of the Sox Sargent Today May 7 to 13, 2009 issue with name of Leah Dalmatio appearing inside staff box marked as Exhibit 5/010, the August 27 to September 13, 2007 issue of News Focus. Witness identified that picture appearing on right side of first page of News Focus as Leah Dalmatio marked as Exhibit 5/011, and the September 21 to 28, 2009 issue of News Focus with name of Leah Dalmatio appearing inside staff box marked as Exhibit 5/011D. Likewise, she presented a sample advertising contract from Soxygen Today marked as Exhibit 5/012. When witness was asked why she was not able to get certificate of employment of the victim from the said publications, witness answered that publishers Francisco Subang of Sox Sargent Today and Maritz Cabletas of News Focus were among those who were massacred together with the victim. Page 696. Considering the documents presented by the prosecution and the fact that there could be no certificate of employment and compensation which can be issued since the publishers of the aforesaid publications were also victims of the massacre, and considering further that there was no cross-examination conducted on the witness when she was presented in court, the court is inclined to grant the claim for loss of earning capacity. For the death of certificate of the victim, she was 38 years old at the time of her death, and applying the formula, thus, NETEAR NINGCAPACITY equals LIF EEXPECTANCYXGROSSANNULINCOMELS necessary living expenses life expectancy equals 2/3 x 80 age of the deceased at time of death equals 2/3x 80 to 38 equals 2/3x42 equals 28 years GROSSANNULINCOME equals 5 Cuban pesos 000 00x12 equals 6 Cuban pesos 0.0000 loss of earning capacity equals life expectancy x 1/2 annual gross income equals 28 years x 1/2 60,000 Cuban pesos equals 28 years x 30,000 Cuban pesos loss of earning capacity equals 840,000 Cuban pesos hence, the following damages are to be awarded to the family of Eleanor Dalmatio. A. Civil indemnity, 100,000.00 billion Cuban pesos moral damages, 100,000 Cuban pesos C. Exemplary damages, 100,000 Cuban pesos D. Tempered damages, 50,000.00 E. Loss of earning capacity, 840,000 Cuban pesos 26. 4. Victim Cynthia A. Oquendo, regarding the claim for actual damages, witness Dennis A. testified that he cannot tell the exact amount of funeral expenses since it was his mother-in-law Anita J. Oquendo who kept the receipts in connection with the funeral services extended to his wife and father-in-law who were both victims of the massacre. Hence, the discussion with respect to the actual damages insofar as victim Cynthia Oquendo is. Page 697 concern will be discussed altogether with the actual damages being claimed for victim Catalino Oquendo. As regards the claim for loss of earning capacity, witness testified that her wife was a practicing lawyer at the time of her death. He presented the following documents to prove that the victim was engaged in the legal practice when she was still alive, viz. A. Integrated Bar of the Philippines ID card of the victim with roll of attorneys number 45,548. Marked as Exhibit 5, R6, B. Certification from Dole Philippines, dated August 3, 2010, signed by Corazon L. Madanguit, Accounting Manager, certifying that Dole Philippines, Inc. had made several payments to the victim for legal services for various dates starting September 17, 2008 to November 20, 2009, amounting to a total of 200,600 Cuban pesos, marked as Exhibit 5, R7, C. An estimated income earned by attorney Cynthia J. Oquendo for the year 2009 dated August 3, 2010, with a total amount of 1,302,750 Cuban pesos, prepared and signed by Dennis Q. marked as Exhibit 5, R8, and D. 2 booklets of official receipts of the Oquendo Law Office marked as Exhibits 5, R9 and 5, R10. Based on the foregoing evidence, the court is convinced that the prosecution had sufficiently established the basis for the grant of the loss of earning capacity of the victim despite the fact that the defense counsels cross-examined the witness regarding the victim's income. As earlier discussed, in claiming the loss of earning capacity of the victim, what is necessary to prove is the capacity of the victim to earn and not the actual loss of the amount of income he could have earned. From booklet marked as Exhibit 5, R9, the dated receipts which are considered by the court are as follows. Description date amount payment from Janelle Carafa for appearance fees or receipt No 0020 November 7, 2008 26,000 Cuban pesos payment from Elena Mucho et. AL for attorney's fees or receipt No 0021 September 18, 2008 21,000 Cuban pesos payment from Nacarda, Verdigan and Sabajan, CC No 075 823 5825, or receipt No 0022 November 22, 2008 26,000 Cuban pesos payment from Conchita Fernandez for attorney's fees or receipt No 0023 November 21, 2008 21,000 Cuban pesos. Page 698 payment from Dolores Dacia, et. AL for attorney's fees or receipt No 0024 December 12, 2008 26,000 Cuban pesos payment from Edita Jimena for spot or receipt No 0025 January 12, 2009 2,000 Cuban pesos payment from Feliza Nicola Jura, Howard Hubbard Memorial. For legal fees or receipt no 0026 July 2009 17,000 Cuban pesos payment from Lonnie A. Jinjoyan for notary all fee of the deed of absolute sale or receipt no 0027 February 5th, 2009 1,000 Cuban pesos payment from Bonifacio Villager, E.T. A.L. for legal fees or receipt no 0028 January 29th, 2009 26,000 Cuban pesos payment from Catherine Malampong for legal fees or receipt no 0030 January 30th, 2009 2,000 Cuban pesos payment from PPV Franier, libel case, or receipt no 0031 February 19th, 2009 23,000 Cuban pesos payment from PPV Franier, libel case, or receipt no 0032 February 19th, 2009 26,000 Cuban pesos payment from Lilibeth Franier for legal fees or receipt no 0034 March 4th, 2009 26,000 Cuban pesos payment from Eva Cabag or receipt no 0035 March 10th, 2009 7,000 Cuban pesos. Payment from Legal Department, Dole Philippines, Incorporated, or receipt no 0036 March 11th, 2009 25,500 Cuban pesos payment from Lilibeth Franier for legal fees and CC no 2315-07 libel or receipt no 0037 March 17th, 2009 26,000 Cuban pesos payment from Lilibeth Franier for legal fees in April 8th, 2009 26,000 Cuban pesos. Page 699 CC no 2315-07 libel or receipt no 0038 payment from Arcadio Solon for attorney's fees or receipt no 0040 May 7th, 2009 26,000 Cuban pesos payment from Maluyong Central Elementary School for notarization of resolution or receipt no 0041 May 20th. 2009 100 Cuban pesos payment from Lilibeth Franier for legal fees and CC no 2315-07 libel or receipt no 0042 May 29th, 2009 26,000 Cuban pesos payment from Howard Hubbard Memorial Hospital for notarization or receipt no 0043 June 8th, 2009 150 Cuban pesos payment from William Lee for appearance fee in PPV Lee or receipt no 0044 June 17th, 2009 1,500 Cuban pesos payment from Arcadio Solon for attorney's fees or receipt no 0045 June 22nd, 2009 26,000 Cuban pesos payment from HR Department Howard Hubbard Memorial Hospital for legal fees or receipt no 0046 July 10th, 2009 17,000 Cuban pesos payment from Legal Department, Dole Philippines, in for legal fees or receipt no 0047 July 11th, 2009 10,000 Cuban pesos, but in the form of payment it was written that it was in check amounting to 8,500 Cuban pesos. Corresponding to the one written in the certification issued by Dole Philippines, Incorporated payment from Howard Hubbard Memorial Hospital for Sun Celit July 6th, 2009 150 Cuban pesos. Page 700 contract or receipt no 0048 payment from Howard Hubbard Memorial Hospital for physicians contract or receipt no 0049 July 22nd, 2009 500 Cuban pesos payment from Wilma Calva for affidavit of two disinterested persons or receipt no 0050 July 23rd, 2009 200 Cuban pesos total 435,100 Cuban pesos from this booklet marked as Exhibit 5, R9. The court notes that there were two receipts which were also included in the certification issued by Dole Philippines, Inc., one amounting to 25,500 Cuban pesos, or no 0036, and the other receipt amounting to 10,000 Cuban pesos, where 8,500 Cuban pesos was part of the payment made by Dole Philippines, Incorporated, or no 0047. From the total of 435,100 Cuban pesos, the amounts of 25,500 Cuban pesos and 8,500 Cuban pesos will be deducted, hence, leaving a total amount of 401,100 Cuban pesos. The court also notes that from this booklet, there were receipts which were undated and the original receipts were attached together with the duplicates, to wit, description amount payment from Elena Mudko, E.T. AL for attorney's fees or receipt no 0001 20,000 Cuban pesos payment from Shirley Donnan, E.T. AL for attorney's fees or receipt no 0002 20,000 Cuban pesos payment from Serviaco Bagarineo, E.T. AL for attorney's fees or receipt no 0003 20,000 Cuban pesos payment from Jonito Toledo and Apolinario Boiler Jr. for attorney's fees or receipt no 0004 20,000 Cuban pesos payment from Eric Galuli and Tristan Papa for attorney's fees or receipt no 0005 20,000 Cuban pesos payment from Dole Philippines Incorporated Legal Department for legal fees or receipt no 0006 10,000 Cuban pesos payment from Dennis Lacayan and Perlito A. Onguig for attorney's fees or receipt no 0007 20,000 Cuban pesos payment from Loreto Baybayin and Serafin Labrador for attorney's fees or receipt no 0008 20,000 Cuban pesos payment from Janilin Sarafa and Johnny Nacardat or receipt no 0009 20,000 Cuban pesos. Page 701 payment from unnamed, CC no 07-5824/CC no 07-5825, for attorney's fees or receipt no 0010 20,000 Cuban pesos payment from Raul Yuzan and Dolores Dacia for attorney's fees or receipt no 0011 20,000 Cuban pesos payment from Bonifacio Viager and Gennaro Apollo for attorney's fees or receipt no 0012 20,000 Cuban pesos payment from Milagros Mendoza and Janilin Oliveras or receipt no 0013 20,000 Cuban pesos payment from Yulita Mayana and Renaciel de la Cruz for attorney's fees or receipt no 0014 20,000 Cuban pesos. Payment from Teresita Magtoto and Erlinda Daca for attorney's fees or receipt no 0015 20,000 Cuban pesos. Payment from Renaciel de la Cruz and Cars Bueron for appearance fees or receipt no 0001 23,000 Cuban pesos. Payment from Janito Toledo Boisier and Eric Galun for legal fees or receipt no 0017 20.
Total 371,000 Cuban pesos. Hence, the court cannot include the
receipts in the computation for the loss of earning capacity of the victim, as it cannot be determined whether these payments were received before or after the death of the victim. Moreover, from booklet marked as Exhibit 5, R10, the receipts which are considered by the court are as follows. Description: date, amount, payment from Oriaco Bagarino, E.T. AL or receipt no 0051 December 18th, 2008 26,000 Cuban pesos. Payment from Edgar R. Arboleda for deed of conditional sale of real property or receipt no 0052 June 22nd, 2009 7,000 Cuban pesos. Payment from Happy Living Realty Dev T. Corp for notary alls or receipt no 0055 September 1st, 2009 300 Cuban pesos. Payment from Lilibeth Frangel libel case no. October 14th, 2009 26,000 Cuban pesos. Page 702 2313-07 to 2317 for legal fees or receipt no 0056. Payment from Lilibeth Franja for appearance fee or receipt no 0057 October 28th, 2009 26,000 Cuban pesos. Payment from Sarangani Resources Corp for legal fees or receipt no 0058 November 20th, 2009 15,000 Cuban pesos. Total 100,300 Cuban pesos. From this booklet, the court did not take into consideration the or no 0060 dated December 8, 2009, which was the payment from Johnny Nacardat, E.T. AL, amounting to 17,850 Cuban pesos for appearance fee, as this payment was made after the death of the victim. Thus, the total income derived from the victim's law office from September 2008 up to her death on November 2009, which were duly supported by receipts, amounts to a total of 501,400 Cuban pesos. In addition, the court also considers the certification issued by Dole Philippines, Int which provided the income received by the victim for her legal services from September 2008 to November 2009, amounting to 200,600 Cuban pesos. Hence, the total income from September 2008 to November 2009 of victim Cynthia Oquendo amounts to a total of 702,000 Cuban pesos. Based on the death certificate of the victim, she was 35 years old at the time of her death. Thus, applying the formula, viz. Net earning capacity equals life expectancy x gross annual income less necessary living expenses, life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80 to 35, equals 2/3x 45 equals 30 years income provided equals 702,000 Cuban pesos for 14 months, September 2008 to November 2009. AVERAGE equals 7 Cuban pesos 0.0000/14 equals 50,142 Cuban pesos and 86 cents. Gross annual income equals 50,142 Cuban pesos and 86 cents x 12 months. Page 703 equals 601,714 Cuban pesos and 32 cents. Loss of earning capacity equals life expectancy x 1/2 annual gross income equals 30 years x 1/2, 601,714 Cuban pesos and 32 cents, equals 30 years x 300,857 Cuban pesos and 16 cents. Loss of earning capacity equals 9,025,714 Cuban pesos and 80 cents. In conclusion, the following damages are to be awarded to the heirs of victim Cynthia Oquendo: A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 A. Actual damages, 872,595.00, also for victim Catalino Oquendo. D. Loss of earning capacity, 9,025,714 Cuban pesos and 80 cents 27, for victim Marif Montano. Based on the judicial affidavit of witness Mora Montano, she claimed that she incurred 22,750 Cuban pesos for the burial of her daughter victim Marif Montano. The following receipts were presented by the witness to support said amount. Description: date amount Sarangani merchandising cash invoice number 153,058 marked as exhibit 5, N8 November 30th, 2009 4,500 Cuban pesos. Fujoso store cash invoice number 2,109 marked as exhibit 5, N9 December 3rd, 2009 8,250 Cuban pesos. LP Lechin House cash receipt No 0100 marked as exhibit 5, 9 December 4th, 2009 10,000 Cuban pesos. Total 22,750 Cuban pesos, considering that the expenses supported by receipts only amounted to 22,750 Cuban pesos and since the same was lesser than the amount for tempered damages as held in established jurisprudence, and considering further that the death of victim Marif Montano was established by the prosecution and expenses were indeed incurred in connection thereto. Page 704, the court believes that it is only proper to award the amount of 50,000 Cuban pesos as tempered damages in lieu of the actual damages. Regarding the claim for loss of earning capacity, the witness claimed that the victim was the publisher of Saksi Mindanao News at the time she was killed, and she was earning around 83,727 Cuban pesos per month. To substantiate her claim, she presented a copy of the victim's ID card from Saksi Mindanao News with her picture and signature and stated therein that she was the publisher, marked as Exhibit 5 and 11. Further, she presented the following receipts, to wit, description: date amount Saksi Mindanao News or hashtag 0001 received from Honorable Roy Chongian for advertising rates marked as Exhibit 5 and 12 November 3rd, 2009 9,072 Cuban pesos. Saksi Mindanao News or hashtag 0002 received from Mayor George Sambaga for advertising rates marked as Exhibit 5 and 12 on November 5th, 2009 1,260 Cuban pesos. Saksi Mindanao News or hashtag 0003 received from Jaibo Teodoro for advertising rates marked as Exhibit 5 and 12 being November 6th, 2009 2,520 Cuban pesos. 6e Mindanao News or hashtag 0004 received from Kalimutan Festival for advertising rates marked as Exhibit 5 and 12C November 6, 2009 5,040 Cuban pesos. 6e Mindanao News or hashtag 0005 received from Manny Villar for advertising rates marked as Exhibit 5 and 12D November 5, 2009 1,260 Cuban pesos. 6e Mindanao News or hashtag 0006 received from Governor Priscilla Chongian for November 9, 2009 11,592 Cuban pesos. Page 705 advertising rates marked as Exhibit 5 and 12E. 6e Mindanao News or hashtag 0007 received from Steve Solon / Vice Governor for advertising rates marked as Exhibit 5 and 12F November 12, 2009 1,260 Cuban pesos. 6e Mindanao News or hashtag 0008 received from IPD for advertising rates marked as Exhibit 5 and 12G November 11, 2009 5,040 Cuban pesos. 6e Mindanao News or hashtag 0009 received from Kalimutan Festival for advertising rates marked as Exhibit 5 and 12H November 12, 2009 11,592 Cuban pesos. 6e Mindanao News or hashtag 0010 received from Roy Chongian for advertising rates marked as Exhibit 5 and 12I November 16, 2009 1,260 Cuban pesos. 6e Mindanao News or hashtag 0011 received from Datu Cadile / Mayor for advertising rates marked as Exhibit 5 and 12J November 17, 2009 1,260 Cuban pesos. 6e Mindanao News or hashtag 0012 received from BRGY KGD Josephine Matubato for advertising rates marked as Exhibit 5 and 12K November 16, 2009 630 Cuban pesos. 6e Mindanao News or hashtag 0013 received from BM Napoleon Alaba for advertising rates marked as Exhibit 5 and 12L November 19, 2009 630 Cuban pesos. Page 706 6e Mindanao News or hashtag 0014 received from Honorable Mayor Corazon Lura Filo for advertising rates marked as Exhibit 5 and 12M November 18, 2009 2,520 Cuban pesos. 6e Mindanao News or hashtag 0015 received from BM Art Lala for advertising rates marked as Exhibit 5 and 12N November 20th. 2009 1,260 Cuban pesos. 6e Mindanao News or hashtag 0016 received from Honorable Vice Mayor Benjamin Gilly for advertising rates marked as Exhibit 5 and 12 on November 20th, 2009 1,260 Cuban pesos. 6e Mindanao News or hashtag 0017 received from BM Nene Santos for advertising rates marked as Exhibit 5 and 12p November 20th, 2009 1,260 Cuban pesos. 6e Mindanao News or hashtag 0018 received from Frito Basino for advertising rates marked as Exhibit 5 and 12q November 18th, 2009 7,434 Cuban pesos. 6e Mindanao News or hashtag 0019 received from Attorney Perla Cartageno for advertising rates marked as Exhibit 5 and 12R November 20th, 2009 1,260 Cuban pesos. 6e Mindanao News or hashtag 0020 received from Roy Chongian for advertising rates marked as Exhibit 5 and 12S November 19, 2009 1,260 Cuban pesos. 6e Mindanao News or hashtag 0021 received from PIO for November 19th, 2009 1,260 Cuban pesos. Page 707 advertising rates marked as Exhibit 5 and 12T. 6e Mindanao News or hashtag 0022 received from Kalimutan Festival for advertising rates marked as Exhibit 5 and 12U November 18th, 2009 5,040 Cuban pesos. 6e Mindanao News or hashtag 0023 received from Datu Kadil Masahat for advertising rates marked as Exhibit 5, N12V November 18, 2009 2,520 Cuban pesos Saksi Mindanao News or hashtag 0024 received from Honorable Abu Alas Mamansul for advertising rates marked as Exhibit 5, N12W November 18, 2009 1,260 Cuban pesos Saksi Mindanao News or hashtag 0025 received from PIO for advertising rates marked as Exhibit 5, N12X November 19, 2009 1,260 Cuban pesos Saksi Mindanao News or hashtag 0026 received from Mayor Pedro Acaran Jr. for advertising rates marked as Exhibit 5, N12Y November 20, 2009 1,638 Cuban pesos Saksi Mindanao News or hashtag 0027 received from Governor Datu Zaldi Ampatuan for advertising rates marked as Exhibit 5, N12Z November 21, 2009 2,079 Cuban pesos total 83,727 Cuban pesos. The witness was cross-examined by the defense counsels regarding these receipts. She confirmed that she did not know what the receipts, page 708, were all about. During cross, the defense counsels manifested that there was disparity as to the signatures written in the receipts. Considering the foregoing, the court cannot give credence to these receipts as basis for the claim of loss of earning capacity. The prosecution failed to sufficiently establish the basis for said claim. Hence, the same cannot be granted by the court. Thus, the following damages are to be awarded to the family of Marif Montano: A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.0028. For victim Jeffon Katadagan, to claim for actual damages, the prosecution through witness Remia Katadagan presented an itemized burial, funeral and other miscellaneous expenses spent for the death of Jeffon C. Katadagan with a total amount of 110,179 Cuban pesos, marked as Exhibit 4, T5. Likewise, she presented the following receipts to support her claim. Description: date, amount, Ms. Variety Store cash invoice number 845 marked as Exhibit 4, T6 November 26, 2009 16,674 Cuban pesos. Abraham's Lechin receipt marked as Exhibit 4, T7 November 29, 2009 49,000 Cuban pesos. Solo Flight Store cash invoice number 1,328 marked as Exhibit 4, T8 November 29, 2009 6,505 Cuban pesos. Marble Subir Funeral Home contract number 2,355 marked as Exhibit 4, T9 November 25, 2009 48,000 Cuban pesos. Forest Lake General Santos, Inc. or hashtag 1,849 marked as Exhibit 4, T10 November 26, 2009 11,000 Cuban pesos. Total 131,179 Cuban pesos. Page 709. Based on the foregoing evidence, it shows that the actual expenses substantiated by receipts amounted to 131,179 Cuban pesos, which is more than the standard amount provided by established jurisprudence for tempered damages. Considering that the prosecution was able to prove the actual expenses, the court resolves to grant the aforesaid amount to the family of the victim. Regarding the claim for loss of earning capacity, the witness testified that her son victim Jeffon Katadagan was a photographer and driver for Saksi Mindanao News at the time he was killed. She also claimed that the victim had a trucking business and earned an average of 111,210 Cuban pesos and 40 cents per month, or 1,893 Cuban pesos and 60 cents for 9 months of trucking services he rendered as a contractor of Dole Philippines, Inc. To substantiate the same, she presented the following: 1. LTO receipts showing her son's ownership of the vehicles relating to his business marked as exhibits 4, T17 to 20. 2. Business permit No. 000101-0 dated January 12, 2009 granted to the victim Jeffon C. Katadagan for Go Forth Trucking. 3. Certification from Dole Stan Filco, a division of Dole Philippines, Inc., certifying that the victim, Go Forth Trucking, was one of their contractors doing field operations since March 2009 up to August 24, 2011, marked as Exhibit 4, T21, and 4. Supplier payment inquiry for Go Forth Trucking from March 5, 2009 to November 12, 2009 with a total amount of 1,893 Cuban pesos and 60 cents marked as Exhibits 4, T22 to 4, T22B. But as to the salary of his son as photographer and driver for Sexy Magandanao News, she confirmed that she had no idea as to the same. During her cross-examination, the witness was asked about the certification issued by Dole as well as the incidental expenses incurred by the victim in relation to his business. She confirmed that her son had four drivers employed for the trucking business, but she does not know their monthly salaries. She also stated that the office of the business was only in their house. Considering the evidence presented by the prosecution notwithstanding the cross-examination conducted by the defense and based on established jurisprudence, the court is of the opinion that the documents presented were sufficient basis to support the claim for the loss of earning capacity of the victim Jeffon Katadagan. The court will consider the income of 1,893 Cuban pesos and 60 cents for 9 months as sufficient basis for the computation of the loss of earning capacity. Since the income provided was only for 9 months, it is best to get the average to arrive at the monthly gross income. Based on the death certificate of the victim marked as Exhibit T22, he was 28 years old at the time of his death. Thus, net earning capacity equals life expectancy x gross annual income less necessary living expenses. Life expectancy equals 2/3 x 80 age of the deceased at time of death. Page 710 equals 2/3x 80 to 28 equals 2/3x 52 equals 34.6667 years. Income provided equals 1 Cuban peso 000,893.60 for 9 months. Average equals 1 Cuban peso 000,893. 60/9 equals 111,210 Cuban pesos and 40 cents. Gross annual income equals 111,210 Cuban pesos and 40 cents. X 12 months equals 1 Cuban peso 334,524.80. Loss of earning capacity equals life expectancy x 1/2 annual gross income equals 34.6667 years. X 1/2 1,334,524 Cuban pesos and 80 cents equals 34.6667 years. X 667,262 Cuban pesos and 40 cents. Loss of earning capacity equals 23,131,785 Cuban pesos and 44 cents. To conclude, the following are the damages to be awarded to the family of Jeffon Katadagan: A. Civil indemnity, 100,000.00. B. Moral damages, 100,000.00. C. Exemplary damages, 100,000.00. D. Actual damages, 131,179.00. E. Loss of earning capacity, 23,131,785 Cuban pesos and 44 cents. 29 and 30. For victims Eduardo and Cecil Lechencito, witness Stephanie Cecil Lechencito testified that she spent 110,000 Cuban pesos each for the funeral services of her parents. Victims Eduardo and Cecil Lechencito as evidenced by the following receipts. 1. Charito El Colado Funeral Parlor Official Receipt No. 0149 dated December 3, 2009 for funeral services of late Cecil Lechencito with a total amount of 110,000.00, marked as Exhibit 9, R2, and 2. Charito El Colado Funeral Parlor Official Receipt No. 0149 dated December 3, 2009 for funeral services of late Eduardo Lechencito with a total amount of 110,000 Cuban pesos, marked as Exhibit 9, S6. Considering that the expenses incurred as alleged by the witness were duly supported by receipts, the court is inclined to award the amount of 110,000 Cuban pesos for each victim as actual damages. Page 711. Insofar as the claim for loss of earning capacity for victim Eduardo Lechencito is concerned, the witness presented the following. 1. Appointment paper of Eduardo Lechencito dated March 10, 2008 as permanent employee of the Office of the City Mayor as Licensing Officer 3, SG 18/1 with annual salary of 209,100 Cuban pesos, marked as Exhibit 9, S4, and 2. Notice of salary adjustment from the Office of the City Mayor Tacurong dated August 28, 2008, with the information that the adjusted monthly basic salary of the victim effective July 1, 2008 is 19,168 Cuban pesos marked as Exhibit 9, S5. Although the witness was cross-examined by the defense counsels, the court gives credence to the evidence presented by the prosecution as sufficient basis to support the claim for the loss of earning capacity of the victim. As per his death certificate marked as Exhibit T5, victim Eduardo Lechencito was 53 years old at the time of his death, and applying this to the formula, viz. Net earning capacity equals life expectancy x gross annual income less necessary living expenses, life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80253, equals 2/3x27 equals 18 years, gross annual income equals 19,168 Cuban pesos x 12 months equals 230,016 Cuban pesos, loss of earning capacity equals life expectancy x 1/2 annual gross income equals 18 years x 1/2, 230,016 Cuban pesos, equals 18 years x 115,008 Cuban pesos, loss of earning capacity equals 2,070,144 Cuban pesos. With regards to the claim for loss of earning capacity for victim Cecil Lechencito, the witness presented a certified true copy of the OFW membership verification sheet of the victim with the information that the latter was a servant at Sheikh Suhaim bin Suhaim Hamad Al Thani at Qatar with a contract duration of 24 months and monthly salary of $400 and departure date on October 22, 2007. On cross-examination, witness was asked if she had personal knowledge about the details written on the said verification sheet, which she answered in the negative. This notwithstanding, the court believes that the prosecution was able to establish with this evidence the capacity of the victim at the time of her death to earn. It is to be noted that the claim for loss of earning capacity is not for the loss of actual salary earned but for the loss of the victim's earning capacity. Based on the death certificate of victim. Page 712. Cecil Lechencito marked as Exhibit T49. She was 52 years old at the time of her death. Hence, net earning capacity equals life expectancy x gross annual income less necessary living expenses, life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80252, equals 2/3x28 equals 18.6667 years. Income provided equals $400 monthly as of November 2009. The average US dollar conversion to Philippine peso is P47.0324 based on the Banco Central NG Pilipinas pesos to US dollar rate. 1948 to 2018 986 MONTHLYS RY and PESOSA foot ER conversion equals $400 asterisk 47.0324 Cuban pesos equals 18,812 Cuban pesos and 96 cents. Gross annual income equals 18,812 Cuban pesos and 96 cents x 12 months equals 225,755 Cuban pesos and 52 cents. Loss of earning capacity equals life expectancy x 1/2 annual gross income equals 18.6667 years x 1/2, 225,755 Cuban pesos and 52 cents equals 18.6667 years x B112,877.76. Loss of earning capacity equals 2,107,055 Cuban pesos and 28 cents. In summary, the following are the damages to be awarded to the heirs of victims Eduardo and Cecil Lechencito. A. Civil indemnity, 100,000.00 for each victim. B. Moral damages, 100,000.00 for each victim. C. Exemplary damages, 100,000.00 for each victim. D. Actual damages, 110,000.00 for each victim. E. Loss of earning capacity, 2,070,144 Cuban pesos for Eduardo, 2,107,055 Cuban pesos and 28 cents for Cecil. 31. For victim Catalino Oquendo Jr., 986 W. With respect to the claim for actual damages, witness Nanita Oquendo testified that her family incurred expenses for the burial and wake of victims Catalino Oquendo Jr. and Cynthia Oquendo in the amount of 780,995 Cuban pesos. Witness presented several receipts, but the court only considered the following. Description: date, amount, BFE Food Products cash invoice number 954 marked as Exhibit 4/05 November 24th, 2009, 4,500 Cuban pesos. BFE Food Products cash invoice number 35,951 marked as Exhibit 4/06 November 24th, 2009, 6,040 Cuban pesos. BFE Food Products cash invoice number 35,955 marked as Exhibit 4/07 November 25th, 2009, 30,000 Cuban pesos. BFE Food Products cash invoice number 35,953 marked as Exhibit 4/08 November 25th, 2009, 22,500 Cuban pesos. AJ Trio Mark cash invoice No 0199 marked as Exhibit 4/09 November 24th, 2009, 14,485 Cuban pesos. Order slip marked as Exhibit 4/10 November 23rd, 2009, 3,200 Cuban pesos. Funeraria Galado contract number 1,887 marked as Exhibit 4/12 November 25th, 2009, 177,800 Cuban pesos. Order slip marked as Exhibit 4/13 November 27th, 2009, 65,000 Cuban pesos. BFE Food Products cash invoice number 57,535 marked as Exhibit 4/14 November 30th, 2009, 190,000 Cuban pesos. Vincar Motor Works official receipt number 1007 marked as Exhibit 4/15 November 27th, 2009, 50,000 Cuban pesos. Sadoc Refreshment cash invoice number 33,708 marked as Exhibit 4/16 November 29th, 2009, 17,535 Cuban pesos. Page 714 Sadoc Refreshment cash invoice No 0221 marked as Exhibit 4/17 November 29th, 2009, 28,000 Cuban pesos. Funeraria Galado contract number 1,184 marked as Exhibit 4/18 November 25th, 2009, 177,800 Cuban pesos. AJ Trio Mark cash invoice No 0203 marked as Exhibit 4/19 November 28th, 2009, 16,300 Cuban pesos. Sadoc Refreshment cash invoice number 29,048 marked as Exhibit 4/20 November 27th, 2009, 69,435 Cuban pesos. Total 872,595 Cuban pesos. The court did not consider the receipt from BFE Food Products dated January 2nd, 2010. amounting to 47,500 Cuban pesos, as it was admitted by the witness that the said expense relates to the catering during the 40 days of the victims. As earlier discussed, expenses incurred after the burial and wake, which corresponds for the 9th day, 40 days, or death anniversaries, are no longer included in the claim for actual damages. Considering that the prosecution was able to support the expenses which were directly related to the wake and burial of the above-named victims, the court will allow the grant of actual damages amounting to 872,595 Cuban pesos. Insofar as the claim for loss of earning capacity of victim Catalino Oquendo is concerned, the witness testified that the victim was a farmer and legal researcher of victim Cynthia Oquendo. From the coppers, the victim was earning 65,000 Cuban pesos for every three months. However, She could not present proof as to this amount as they only list it whenever the coppers are weighed. She also testified that their land was being rented by Dole Philippines where they received 200,000 Cuban pesos yearly. As proof, she presented a certification from Dole dated August 3, 2010, signed by Elizabeth A. Garcia, Land Admiral Superintendent, Legal and Admiral Services Department, certifying that Lot No/S2406D, CSD 11-025881D, 65, GSS 211 and 106, GSS 390 located at Polo and Quinals, Polomoc, South Cotabato, were entered by spouses Mr. Catalino Oquendo and Mrs. Nanita Oquendo into a lease contract with Dole Philippines, in for a term of 25 years from July 1, 2006 to June 30, 2031 and was receiving an annual income of 203,959 Cuban pesos and 68 cents for the year 2010, marked as Exhibit 404. Considering that the certification issued by Dole Philippines, it indicates that the lease contract was entered by the spouses Catalino and Page 715 Nanita Oquendo, it only means that despite the death of the victim Catalino, the lease contract with Dole Philippines, in which has a term until June 30, 2031 is still subsisting. In fact, as stated in the said certification, for the year 2010, or a year after the death of the victim, the lessor had earned the amount of 203,959 Cuban pesos and 68 cents. With respect to the supposed income of the victim for the coppers and his work as legal researcher, the prosecution failed to present any evidence to support the same. In view of the foregoing, the court is inclined to deny the grant of the claim for the loss of earning capacity of the victim. Thus, the following are the damages to be awarded to the heirs of victim Catalino Oquendo: B. Civil indemnity, 100,000 Cuban pesos. C. Moral damages, 100,000 Cuban pesos. D. Exemplary damages, 100,000 Cuban pesos. D. Actual damages, 872,595 Cuban pesos, also for victim Cynthia Oquendo, 32, for victim Rasul Dud. To claim for actual damages, witness Halima T. Dud presented an itemized burial and other miscellaneous expenses spent during the death of the victim with a total of 441,045 Cuban pesos marked as Exhibit 4E11. However, no single receipt was presented to substantiate these expenses. Thus, the court is inclined to award tempered damages in the amount of 50,000 Cuban pesos in lieu of the actual damages incurred by the family which were not proven during trial. With respect to the claim for loss of earning capacity, the witness presented the following: 1. Service record of Rasul Dud from Regional Legislative Assembly Autonomous Region in Muslim Mindanao Cotabato City dated August 4, 2010 signed by Harita A. Biruar, Chief Administrative Officer, with the information that the victim was employed as an executive assistant until November 21, 2009, with annual salary of 205,764 Cuban pesos. 2. Contract of employment dated January 2, 2008 between Honorable Pays Alan P. Tago, CPA, and Rasul Dud, engaging the services of the latter as executive assistant district, with monthly compensation of 10,836 Cuban pesos, marked as Exhibit 4E6. 3. Contract of service dated January 5, 2009 between Honorable Regis Sahalai General and Rasul Dud, engaging the services of the latter as executive assistant district, Asi Mang Diodatato with monthly compensation of 15,181 Cuban pesos, marked as Exhibit 4E7. 4. Office payroll indicating Rasul Dud as executive assistant with monthly salary of 17,147 Cuban pesos, marked as Exhibit 4E8. And 5. ID cards of the victim from Regional Legislative Assembly. Page 716 showing that he was holding the position of executive assistant collectively marked as Exhibit 4E9. Although the witness was cross-examined by the defense counsels regarding the previous employment of the victim, they did not question the certifications or contract of service presented in court. Thus, The court is of the opinion that the evidence presented by the prosecution were sufficient to support the claim for loss of earning capacity of the victim. Based on the certificate of death of the victim marked as Exhibit T13, the latter was 26 years old at the time of his death. The court will consider the annual salary of 205,764 Cuban pesos indicated in the service record since it is the most recent. Applying the formula for the computation of the loss of earning capacity, to wit, net earning capacity equals life expectancy x gross annual income less necessary living expenses life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80-26, equals 2/3x54 equals 36 years loss of earning capacity equals life expectancy x 1/2 annual gross income equals 36 years x 1/2, 205,764 Cuban pesos, equals 36 years x 102,882 Cuban pesos loss of earning capacity equals 3,703,752 Cuban pesos in summary. The following damages are to be awarded to the family of victim Rasul Dud, A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 3,703,752 Cuban pesos 33. For victim Abdullah Ayada, witness Bailia Ayada presented an affidavit of burial and other expenses in relation to the death of her husband Abdullah Ayada with a total amount of 631,045 Cuban pesos marked as Exhibit 4D. 9. However, she confirmed during her cross-examination that these expenses were not supported by any receipts because in their culture, they do not get receipts. Based on the earlier discussed jurisprudence, to claim for actual damages, the same should be substantiated by receipts. Further, it was page 717 earlier discussed that expenses incurred for the death anniversary, 40th or 9th day are not included in the award for actual damages. Thus, the court cannot grant the award of the amount alleged by the witness as the same was not proven by receipts. However, the court can grant tempered damages of 50,000 Cuban pesos in lieu of the actual damages considering that the fact of death of the victim was established by the prosecution and expenses were incurred in relation thereto. As regards the claim for loss of earning capacity, the witness presented a certification from the office of the manager of Venus Transport Service Cooperative signed by Conando A. Macaulay, operator manager, certifying that the victim was employed by the company as driver until his death on November 23, 2009 with a compensation of 30,000 Cuban pesos per month, marked as Exhibit 4D25. The said certification was not opposed by the defense counsels but the witness was cross-examined by them. She confirmed during cross-examination that her husband was a driver but aside from that, they have other source of income coming from the farm. Considering the foregoing, the court gives credence to the certification presented by the prosecution as the same is sufficient basis for the claim of the loss of earning capacity of the victim. Based on the death certificate of the victim, he was 36 years old at the time of his death, hence, net earning capacity equals life expectancy x gross annual income less necessary living expenses life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80-36, equals 2/3x44 equals 29.3333 years gross annual income equals 30,000 Cuban pesos x 12 months equals 360,000 Cuban pesos loss of earning capacity equals life expectancy x 1/2 annual gross income equals 29.3333 years x 1/2, 360,000 Cuban pesos, equals 29.3333 years x 180,000 Cuban pesos loss of earning capacity equals 5,279,994 Cuban pesos in summary. The following damages are to be awarded to the family of victim Abdullah Ayada, A. Civil indemnity, 100,000.00. Page 718b Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E loss of earning capacity, 5,279,994 Cuban pesos 34, for victim Maritz Cabletas, in support of his claim for actual damages in connection with the death of his wife Maritz Cabletas. Witness Eliver Cabletas presented an affidavit of burial expenses with a total amount of 62,610 Cuban pesos, marked as Exhibit 4, U10. But the only proof he submitted to substantiate said expenses was the certification from Forest Lake indicating that the lot price was 16,353 Cuban pesos and the interment fee was 9,500 Cuban pesos, marked as Exhibit 4, U9. The receipt from Nilo A. Allen Memorial Home with the amount 20,000 Cuban pesos for the mortuary services marked as Exhibit 4, U8 was denied admission by the court for being a mere photocopy. Hence, the court can only award temporary damages amounting to 50,000 Cuban pesos in lieu of the expenses alleged by the heir of the victim. Regarding the claim for loss of earning capacity of the victim, witness testified that the victim was a publisher and journalist of News Focus newspaper and a radio announcer and account executive of RPNDXDX at the time of her death. As proof, witness presented the following: A. ID cards of the victim from RPNDXDX with designation as announcer/account executive and the News Focus with designation of the victim as publisher, both marked as Exhibit 4, U11. B. Copy of the News Focus newspaper dated November 16 to 22, 2009, showing the staff box with the name of the victim as publisher marked as Exhibit 4, U12. C. Certificate of Business Name Registration dated December 20, 2006 issued by DTI to the victim certifying that the News Focus publication is a business name registered to said office marked as Exhibit 4, U13. D. A copy of the business proposal from the News Focus publication dated October 10, 2009 signed by the victim marked as Exhibit 4, U14. And E. 2. Booklets of official receipts of the Mindanao News Focus marked as Exhibits 4, U15 to 4, U15ZZ. Although the witness was cross-examined by the defense regarding the salary of the victim he provided, the court is of the opinion that the prosecution was able to establish the basis for the claim for the loss of earning capacity of the victim. It was clearly proven that at the time of her death, the victim was gainfully employed, and were it not for her untimely death, she could have earned more. In view thereof, the court will consider the salary provided by the witness that the victim was earning between 10,000 Cuban pesos to 15,000 Cuban pesos a month. The court will get the average of the salary range to arrive at the estimated monthly salary of the victim when she was alive. Based on her death certificate, the Page 719 victim was 38 years old at the time of her death. Thus, applying the formula, viz. Net earning capacity equals life expectancy x gross annual income ls necessary living expenses life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80 to 38, equals 2/3x 42 equals 28 years income provided equals 10,000 Cuban pesos to 15,000 Cuban pesos average equals 1 Cuban peso 0, 00 plus 15,000 Cuban pesos /2 equals 2 Cuban pesos 5, 000 /2 equals 12,500 Cuban pesos gross annual income equals 12,500 Cuban pesos x 12 months equals 150,000 Cuban pesos loss of earning capacity equals life expectancy x 1/2 annual gross income equals 28 years x 1/2, 150,000 Cuban pesos equals 28 years x 75,000 Cuban pesos loss of earning capacity equals 2,100,000 Cuban pesos. In summary, the court awards the following damages to the heirs of victim Maritz Cabletas: A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 2,100,000 Cuban pesos 35, for victim MC Delbert Arreola, based on the submitted evidence by the prosecution insofar as victim MC Delbert Arreola is concerned. there was no evidence showing the burial and funeral expenses incurred by the heirs of said victim. This notwithstanding, and considering that the death of the victim was established by the prosecution, the court rules to grant tempered damages in the amount of 50,000 Cuban pesos. Page 720. With respect to the claim for loss of earning capacity, the prosecution presented a certification from UNTV signed by Ramona G. Domingo, Chief Finance Officer, Breakthrough, and Milestones Productions INTL Inc., certifying that the victim was a contractual talent of BMPI UNTV Channel 37 until the time of his death and was receiving a contracted fee of 382 Cuban pesos per day, marked as Exhibit 5, L4. Based on the certificate of death marked as Exhibit T37, victim was 20 years old at the time of his death. Thus, the computation for the loss of earning capacity for the victim is as follows: net earning capacity equals life expectancy x gross annual income less necessary living expenses. Life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80 to 20, equals 2/3x 60 equals 40 years. GROSSANNULINCOME equals 382 Cuban pesos x 260 working days equals 9 Cuban pesos 9, 320.00 loss of earning capacity equals life expectancy x 1/2 annual gross income equals 40 years. X 1/2, 99,320 Cuban pesos, equals 40 years x 49,660 Cuban pesos. Loss of earning capacity equals 1,986,400 Cuban pesos. To summarize, the court awards the following damages to the heirs of victim MC Delbert Arreola: A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 1,986,400 Cuban pesos. 36. For victim Ernesto Maravilla, Jr., in order to claim for actual damages, witness Ivy Maravilla executed an affidavit of burial expenses with a total amount of 259,000 Cuban pesos, marked as Exhibit 6, D9. However, the same was not supported by receipts. Thus, the court is constrained to award tempered damages amounting to 50,000 Cuban pesos in lieu of the actual expenses which were not substantiated. Page 721. Insofar as the claim for loss of earning capacity is concerned, witness presented a certificate of employment from Bombo Radio Philippines signed by Fael Tabanggenit, HRD head, certifying that victim Ernesto Maravilla, Jr. was an employee of said station until the time of his death, handled the position of Chief of Reporter of DXMC, Bombo Radio Marble, and was earning 111,043 Cuban pesos and 51 cents, including COLA, and 13th month pay, marked as Exhibit 6, B11. The defense counsels did not object to this certification and did not cross-examine the witness. As ruled earlier, the court will only consider the basic salary of the victim. Based on the same certification, the victim was earning a basic salary of 101,657 Cuban pesos and 64 cents. Per the death certificate marked as Exhibit T52, victim was 49 years old at the time of his death. Thus, applying the formula for the computation of his loss of earning capacity, to wit, net earning capacity equals life expectancy x gross annual income less necessary living expenses. Life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80 to 49, equals 2/3x 31 equals 20.6667 years. GROSSANNULINCOME equals 1 Cuban peso 0.1657. 64x12months equals 1 Cuban peso 219,891.68. Loss of earning capacity equals life expectancy x 1/2 annual gross income equals 20.6667 years x 1/2, 1,219,891 Cuban pesos and 68 cents, equals 20.6667 years x 609,945 Cuban pesos and 84 cents. Loss of earning capacity equals 12,605,567 Cuban pesos and 69 cents. In conclusion, the following are the damages to be awarded to the heirs of victim Ernesto S. Maravilla, Jr., A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 12,605,567 Cuban pesos and 69 cents. Page 722-37, for victim Benji Adolfo, to substantiate the claim for actual damages, the prosecution presented a summary of expenses with total amount of 124,646 Cuban pesos and 79 cents, marked as Exhibit 5Y9. However, the said summary was not supported by receipts. Hence, the court cannot grant the total amount as the actual damages incurred by the victim's heirs. In lieu thereof, the court awards tempered damages in the amount of 50,000 Cuban pesos, considering that the death of victim Benji Adolfo was established and there were indeed burial and funeral expenses incurred by the family. Further, the court cannot grant the claim for loss of earning capacity as there was no evidence or proof presented by the prosecution to establish the basis to determine the same. Thus, the court awards the following damages for the heirs of victim Benji Adolfo: A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100
41. For victim Bienvenido Legarda Jr., to support her claim for actual damages.
Witness Glenna Legarda presented a handwritten list of burial expenses with a total amount of 80,500 Cuban pesos, marked as Exhibit 5, E10. However, the same was not supported by receipts. Thus, the court deems it proper to instead award the amount of 50,000 Cuban pesos as temporary damages in lieu of the actual expenses incurred by the family of the victim which were not duly substantiated. As regards the claim for loss of earning capacity, the witness presented a certificate of employment dated October 1, 2010 signed by Freddie E. Salinas marked as Exhibit 5, E6, certifying that the victim was employed as a sea correspondent of periodical ENI South Cotabato up to the time of his death on November 23, 2009, a certification from Rapido. Page 728 dated October 1, 2010 signed by Freddie E. Salinas marked as Exhibit 5, E7, certifying that the victim was employed as associate publisher of said news agency until November 23, 2009, and a certification from periodical ENI South Cotabato signed also by Mr. Salinas marked as Exhibit 5, E9, certifying that the victim received a monthly commission of 10,000 Cuban pesos to 15,000 Cuban pesos based on his sales production. These certifications were also identified by Mr. Marisco when he testified in court on November 8, 2012. Considering that the prosecution was able to establish that the victim was indeed employed at the time of his death, the court moves to grant the claim for loss of earning capacity. Based on the marriage certificate presented marked as Exhibit 5, E2, the victim was born on September 26, 1971. Thus, he was already 38 years old at the time of his death on November 23, 2009. Following the same principle as that in the case of victim Ray Marisco, the court will consider the average of the salary range testified by the witnesses. Hence, net earning capacity equals life expectancy x gross annual income less necessary living expenses life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80 to 38, equals 2/3x 42 equals 28 years income provided equals 10,000 Cuban pesos to 15,000 Cuban pesos average equals 1 Cuban peso 0, 0, 0, 0. 00 plus 15,000 Cuban pesos /2 equals 2 Cuban pesos 5, 0, 0, 0. 00/2 equals 1 Cuban peso 2, 500. 00 gross annual income equals 12,500 Cuban pesos x 12 months equals 150,000 Cuban pesos loss of earning capacity equals life expectancy x 1/2 annual gross income equals 28 years x 1/2, 150,000 Cuban pesos equals 28 years x 75,000 Cuban pesos loss of earning capacity equals 2,100,000 Cuban pesos. In conclusion, the following are the damages to be awarded to the heirs of victim Bienvenido M. Legarda, Jr., a civil indemnity, 100,000.00. Page 729b moral damages, 100,000.00 C exemplary damages, 100,000.00 D tempered damages, 50,000.00 E loss of earning capacity, 2,100,000 Cuban pesos 42, for victim Daniel Timeson. Witness edited Timeson testified that she incurred a total burial expenses of more or less 100,000 Cuban pesos. To substantiate her claim she presented the following documents. Description date amount PAL Air Waybill No 079-6053459-6 of human remains of Daniel Timeson from General Santos City to Manila marked as Exhibit 5 I-6 December 4, 2009 4,802 Cuban pesos and 40 cents PAL electronic ticket passenger itinerary receipt from General Santos City to Manila flight No. PR/454 on December 4, 2009 marked as Exhibit 5 I-7 December 4, 2009 5,495 Cuban pesos Lamachi Makati, Incorporated, or No 001-1139 for funeral services marked as Exhibit 5 I-8 December 2, 2009.
Page 730. Insofar as the claim for loss of earning
capacity is concerned, the prosecution presented a certification from Breakthrough and Milestones Productions International Incorporated dated November 9, 2010, signed by Ramona G. Domingo, Chief Finance Officer, certifying that the victim was a contractual talent of BMPIUN TV Channel 37 at the time of his death and that he was receiving a fee of 382 Cuban pesos per day. Although the witness was cross-examined, the said certification was not objected to by the defense counsels. In fact, during the cross-examination of the witness, she was consistent that the commission/salary of her husband was 382 Cuban pesos per day as evidenced by the said certification. Hence, the court allows the award of the loss of earning capacity of the victim. Based on the death certificate marked as Exhibit T34, the victim was 54 years old at the time of his death. Applying the formula for the computation of the loss of earning capacity, thus, net earning capacity equals life expectancy x gross annual income less necessary living expenses. Life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80252, equals 2/3x28 equals 18.6667 years. GROSSANNULINCOME equals 382 Cuban pesos x 260 working days equals 9 Cuban pesos 9, 320.00 loss of earning capacity equals life expectancy x 1/2 annual gross income equals 18.6667 years x 1/2, 99,320 Cuban pesos, equals 18.6667 years x 49,660 Cuban pesos. Loss of earning capacity equals 926,988 Cuban pesos and 32 cents. Hence, the following are the damages to be awarded to the heirs of victim Daniel Timeson: A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Actual damages, 101,297 Cuban pesos and 40 cents. E. Loss of earning capacity, 926,988 Cuban pesos and 32 cents. 43. For victim Romeo Cabello. Page 731. During the presentation of witness Corazon Cabello, she claimed to have incurred a total of 133,000 Cuban pesos for burial expenses, as evidenced by the affidavit of burial expenses she executed marked as Exhibit 6, A6. This affidavit, however, was not duly supported by any receipts or documents. Hence, the court cannot allow the grant of 133,000 Cuban pesos, but instead thereof, an award of 50,000 Cuban pesos as tempered damages is deemed proper, considering that the death of the victim was established by the prosecution and in relation thereto, there were expenses incurred by the family of the deceased. Regarding the claim for loss of earning capacity, one of the purposes for the presentation of the witness was to prove that the victim was earning a monthly average commission of 25,000 Cuban pesos as correspondent of Midland Review and a monthly average of 10,000 Cuban pesos as MC during political parties. To support her claim, the only document presented was a copy of the Midland Review showing the staff box with a certain Jimmy Pal A.K. Cabello as one of the correspondents. This notwithstanding, the court finds the evidence presented not substantial to grant the claim for loss of earning capacity. In summary, the court awards the following damages to the heirs of victim Romeo Cabello: F. Civil indemnity, 100,000 Cuban pesos. G. Moral damages, 100,000 Cuban pesos. H. Exemplary damages, 100,000 Cuban pesos. I. Tempered damages, 50,000.0044. For victim Gina Dela Cruz, in her judicial affidavit, witness Nancy Dela Cruz stated that she incurred a total of 25,000 Cuban pesos for the wake and burial of her daughter victim Gina Dela Cruz. However, the witness admitted that she had no receipts or other documents to support her claim. Considering that the death of the victim was established by the prosecution and there were expenses incurred in connection thereto, the court rules to grant the award of 50,000 Cuban pesos as tempered damages pursuant to established jurisprudence. With respect to the claim for loss of earning capacity, The witness claimed that the victim at the time of her death was a correspondent of Saksi Mindanao News and was earning an average of 5,000 Cuban pesos per month, as evidenced by a certification from Radio Philippines Network, dated August 12, 2010, signed by James D. Catalan, station manager, and a copy of the Saksi Mindanao News showing the staff box with the name of the victim as correspondent. Considering the evidence presented and the fact that there were no cross-examinations conducted by the Page 732 defense counsels, the court is convinced to grant the claim for loss of earning capacity. Based on the death certificate marked as Exhibit T43, victim was already 41 years old at the time of her death. Applying the established formula, viz. Net earning capacity equals life expectancy x gross annual income less necessary living expenses, life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80241, equals 2/3x39 equals 26 years grosssannualincome equals 5 Cuban pesos, 000. 00x12months equals 6 Cuban pesos 0.0000. Loss of earning capacity equals life expectancy x 1/2 annual gross income equals 26 years x 1/2, 60,000 Cuban pesos equals 26 years x 30,000 Cuban pesos. Loss of earning capacity equals 780,000 Cuban pesos. Hence, the following are the damages awarded to the heirs of the victim Gina Dela Cruz. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.00. E. Loss of earning capacity, 780,000 Cuban pesos. 45. 4. Victim Roina D. Ante. In order to claim for actual damages, the prosecution through witness Thong Ante presented an itemized approximate burial and other miscellaneous expenses spent during the death of Roina Ante with a total amount of 158,000 Cuban pesos marked as Exhibit 4, I-8. However, there were no receipts or other documents to support this list. Thus, the court is constrained to award tempered damages in the amount of 50,000 Cuban pesos considering that the death of Roina Ante was established by the Page 733. Prosecution and expenses were incurred by the family in connection thereto. Regarding the claim for loss of earning capacity, witness presented a photocopy of the victim's service record provisionally marked as Exhibit 4, I-9. But the same was denied admission as evidence by the prosecution for victim Roina Ante. Aside from this document, no other proof was offered by the prosecution to establish the fact that the victim was an employee of the municipality of Buliwan. Considering that the prosecution was not able to establish the basis of the loss of earning capacity of the victim, the court denies to grant the same. Therefore, the following are the damages to be awarded to the heirs of victim Roina Ante. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.00. 46. For victim Sureda Bernan, to claim for actual damages, witness Faisal Bernan presented an itemized burial and other miscellaneous expenses spent during the death of victim Sureda G. Bernan amounting to 213,000 Cuban pesos marked as Exhibit 4, H6. However, the same was not duly supported by receipts. This notwithstanding, the court grants the awarding of tempered damages in the amount of 50,000 Cuban pesos based on jurisprudence. As regards the loss of earning capacity, the court takes note of the submission of a service record from the municipality of Buliwan signed by a certain Ferda W. Saligan marked as Exhibit 4, H5. In the said service record, at the time of the death of victim Sureda Bernan, she was licensed Inspector 2 and earning an annual salary of 88,824 Cuban pesos. Based on the certification issued by the Office of the Municipal Civil Registrar, victim was born on August 19, 1972, thus, at the time of her death she was already 37 years old. Applying the formula to determine the loss of earning capacity, viz., Net earning capacity equals life expectancy x gross annual income less necessary living expenses. Life expectancy equals 2/3 x, 80. Age of the deceased at time of death equals 2/3x, 80 to 37 equals 2/3x 43 equals 28.6667 years. Page 734 LOSSOFEAR NINGCAPACITY equals LIF EEXBECTANCYX 1/2 ANNULGROSS income equals 28.6667 years x 1/2, 88,824 Cuban pesos equals 28.6667 years x 44,412 Cuban pesos. Loss of earning capacity equals 1,273,145 Cuban pesos and 48 cents. In conclusion, for victim Sureda Bernan, her heirs are entitled to the following damages: A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 1,273,145 Cuban pesos and 48 cents. 47. For victim John Canavan, with respect to actual damages, witness Teresita Canavan presented the following receipts together with the affidavit of burial expenses amounting to 125,000 Cuban pesos marked as Exhibit 5, M8. Description: date, amount, Cherito El Colado Funeral Parlor receipt No. 0118 for the funeral services rendered to the late John Canavan marked as Exhibit 5, M10 January 4, 2010 25,000 Cuban pesos receipt from attorney Agustin Sardido for the notarial fee marked as Exhibit 5, M11 September 21, 2010 250 Cuban pesos receipt with stamp at the back of attorney Agustin Sardido for spa marked as Exhibit 5, M12 November 15, 2013 300 Cuban pesos letter of Teresita Canavan to the municipality of Isulan requesting for the construction of a tomb in the public cemetery marked as Exhibit 5, M13 November 26, 2009 20.00/50.00. Page 735 NSO official receipt for birth certificate of John Canavan marked as Exhibit 5, M14 July 7, 2011 140 Cuban pesos. NSO official receipt for death certificate of John Canavan marked as Exhibit 5, M14 July 8, 2011 140 Cuban pesos. Total 25,900 Cuban pesos, considering that the receipts presented amounted to 25,900 Cuban pesos, which is lesser than amount provided by recent jurisprudence. The award of tempered damages amounting to 50,000 Cuban pesos is proper. As regards the loss of earning capacity, the court denied admission of the certification issued by Freddy Salina since the same was a photocopy. At the time Freddy Salina testified in court on November 8, 2012, he did not identify said certification. Further, when Teresita Canavan testified on November 20, 2013, the defense counsels objected to the presentation of said certification for being a mere photocopy. Also based on her judicial affidavit, her knowledge about the salary of her son was based on the said certification. Hence, the court cannot grant the awarding of the loss of earning capacity as it has no basis to determine the same based on the evidence presented by the prosecution. As summary, the following are the damages awarded to the heirs of John Canavan: A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.0048. For victim Hannibal Cachadula, for actual damages, the only documents presented by witness Ricardo Cachadula were the NSO official receipts for the birth certificates of Ricardo J. Cachadula and Hannibal D. Cachadula amounting to 140 Cuban pesos each. No receipts or documents were offered to prove the burial and funeral expenses incurred for the death of Hannibal Cachadula. This notwithstanding, the court resolves to award tempered damages of 50,000 Cuban pesos in lieu of the actual damages incurred due to the death of the victim. Page 736. Insofar as the loss of earning capacity is concerned, witness Ricardo Cachadula testified that his brother was earning an estimated amount of 30,000 Cuban pesos per month at the time he was killed. His claim was supported by two certifications, one issued by Leo L. J. Sereno, president and chairman of the board, Manila Star, where it was stated that the victim was a reporter of said publication and that he was receiving a salary of 40% commission basis on advertisements for publication in Region 12, and the other issued by Mario B. Basilio, publisher-editor, Punto Daily News, certifying that the victim was a freelance correspondent and was receiving as compensation, on a commission basis, 50% on advertisements he transact with a newspaper. The court believes that the 30,000 Cuban pesos estimated salary testified to by the witness is acceptable as basis of the award, and considering that the defense counsels at the time the witness was presented did not object thereto, the award of the lost earnings is only proper. At the time of his death, victim was 51 years old based on the certificates of birth and death. Thus, net earning capacity equals life expectancy x gross annual income ls necessary living expenses life expectancy equals 2/3 x 80 age of the deceased at time of death equals 2/3x 80251 equals 2/3x 29 equals 19.3333 years gross annual income equals 30,000 Cuban pesos x 12 months equals 360,000 Cuban pesos LOSSOFEAR NINGCAPACITY equals LIF EEXPECTANCYX 1/2 ANNULGROSS income equals 19.3333 years x 1/2 360,000 Cuban pesos equals 19.3333 YEARSX 1 Cuban peso 80,000 loss of earning capacity equals 3,479,994 Cuban pesos. In summary, the court awards the following damages to the heirs of victim Hannibal Cachadula: A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 3,479,994 Cuban pesos 49, for victim Wahida Ali Kalim. Page 737. To claim for actual damages, witness Benji Kalim executed a document denominated as miscellaneous and other expenses for the death of Wahida Kalim amounting to 103,500 Cuban pesos marked as Exhibit 4, C4. However, there were no receipts or other documents to prove the expenses incurred by the family in relation to the death of the victim as enumerated in said document. Considering that the death of victim Wahida Ali Kalim was proved, regardless of the fact that there was no evidence to prove the expenses, the court rules to award tempered damages in lieu of the actual damages in the amount of 50,000 Cuban pesos. Insofar as the loss of earning capacity is concerned, the court cannot grant the same as the victim's work or livelihood does not fall within the exceptions provided by jurisprudence, and considering further that the defense counsels conducted their cross-examinations on the witness, questioning if there was any proof of tax payments with respect to the victim's business, which was answered in the negative. Hence, the following are the damages awarded to the heirs of the victim Wahida Ali Kalim: A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.0050, for victim by Farina Hassan Mangyudadatu. As proof for the actual damages, witness Fatah D. Hassan presented an itemized burial and other miscellaneous expenses during the casualty and death of Bai Farina Mangyudadatu with a total amount of 325,500 Cuban pesos marked as Exhibit 3, Y5, but the same was not supported by receipts. Considering that the death of the victim was proved and in relation thereto there were expenses incurred by the family, the court still grants tempered damages in the amount of 50,000 Cuban pesos. As regards the loss of earning capacity, the court rules to also grant the same, considering that a certification was issued and signed by Ferda W. Saligan, HRMA of the municipality of Bulian, certifying that the victim was employed as a revenue collection clerk at the time of her death, with annual compensation of 71,844 Cuban pesos, marked as Exhibit 3Y8. Likewise, a service record marked as Exhibit 3Y11 was submitted to the court showing the annual salary and position of the victim. Based on the birth certificate of the victim marked as Exhibit 3Y10, she was born on April 18, 1987, thus making her 22 years old at the time of her death in November 2009. However, on her death certificate, page 738 marked as Exhibit T21, at the time of her death she was already 24 years old. Further, based on the certificate of marriage marked as Exhibit 3Y2, her date of birth is April 8, 1985, the same date as recorded in her service record. Hence, the court considers that the date of birth of the victim is the latter date and that she was 24 years old at the time of her death. Net earning capacity equals life expectancy x gross annual income ls necessary living expenses life expectancy equals 2/3 x 80 age of the deceased at time of death equals 2/3x 80224 equals 2/3x 56 equals 37.3333 years LOSSOFEAR NIN GCAPACITY equals LIF EEXBECTANCYX 1/2 ANNULGROSS income equals 37.3333 years x 1/2 71,844 Cuban pesos equals 37.3333 years x 35,922 Cuban pesos. Loss of earning capacity equals 1,341,086 Cuban pesos and 80 cents. The following are the damages to be awarded to the heirs of victim by Farina Hassan Mangudadatu. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 1,341,086 Cuban pesos and 80 cents. 51. For victim Miriam Kalimbal Pandal, with respect to the actual damages, witness Salama Musa presented an itemized list of burial and other miscellaneous expenses spent during the death of Miriam Kalimbal Pandal with a total amount of 170,764 Cuban pesos, marked as Exhibit 4, F7. However, the same was not supported by receipts. In lieu thereof, tempered damages may be awarded in the amount of 50,000 Cuban pesos. As regards the loss of earning capacity, the prosecution submitted a certification dated August 3, 2010 signed by Ismail G. Mangudadatu, certifying that the victim was an employee of EGM Fishpen at the time of her death with a monthly salary of 12,955 Cuban pesos and 58 cents. This certification was page 739 subject to the stipulation of the parties during the time that the witness was presented. In cross-examination, though the witness cannot recall when her mother exactly started working for said company, she confirmed that since she grew up she already knew her mother was already working with EGM company. The court believes that the prosecution was able to establish the basis for the determination of the loss of earning capacity for victim Miriam Kalimbal Pandal. Based on the death certificate marked as Exhibit T40, victim was 42 years old at the time of her death. Thus, applying the formula, net earning capacity equals life expectancy x gross annual income ls necessary living expenses life expectancy equals 2/3 x 80 age of the deceased at time of death equals 2/3x 80242 equals 2/3x 38 equals 25.3333 years GROSSANNULINCOME equals 1 Cuban peso 2,955. 58x12months equals 155,466 Cuban pesos and 96 cents. Loss of earning capacity equals life expectancy x 1/2 annual gross income equals 25.3333 years x 1/2 155,466 Cuban pesos and 96 cents. equals 25.3333 years x 77,733 Cuban pesos and 48 cents. Loss of earning capacity equals 1,969,245 Cuban pesos and 57 cents. The court grants the following damages for the death of victim Miriam Kalimbal Pandal: A. Civil indemnity, 100,000.00. B. Moral damages, 100,000.00. C. Exemplary damages, 100,000.00. D. Tempered damages, 50,000.00. E. Loss of earning capacity, 1,969,245.57. 52. For victim Concepcion Jamie Brizuela, to support the claim for actual damages, the prosecution through witness Cielo Brizuela presented an itemized burial and other miscellaneous expenses spent in connection with the death of the victim with a total amount of 411,630 Cuban pesos, marked as Exhibit 5, P4. Also, the witness offered an affidavit of burial expenses with a total amount of 160,500 Cuban pesos, marked as Exhibit 5, P12. But the only proof which supported these documents was a single receipt from Fantanile Funeral. Page 740, Holmes number 130, dated February 2, 2010, representing the payment for funeral services for the victim in the amount of 35,000 Cuban pesos, marked as Exhibit 5, P4C. Considering that the death of the victim was established but the only amount of burial and funeral expenses proved was below the amount provided in the jurisprudence, the court rules to award the amount of 50,000 Cuban pesos as tempered damages. As proof of the loss of earning capacity of the victim, who was a lawyer broadcaster, the prosecution presented the following documents: A certification from the Office of the Governor, Amas, Quitapavan City, dated February 14, 2014, marked as Exhibit 5, P6, certifying that Governor Emilulala J. Talino Mendoza engaged the services of the victim as retainer lawyer until the time of her death with a retainer's fee of 15,000 Cuban pesos per month. B. Certification from the Polytechnic Foundation of Cotabato and Asia, Inc/Andolana Broadcasting Network 90.3 MHz Charm Radio/TV, dated February 13, 2014, signed by Gregorio A. Andolana, President/CEO, certifying that the victim was a broadcast/journalist commentator of the station up to the time of her death with average monthly commission of 30,000 Cuban pesos, and C. An acknowledgement receipt dated March 15, 2009, showing the payment amounting to a total of 58,575 Cuban pesos, with handwritten plus 5,000, March 15, 2007, as partial payment of attorneys/acceptance fees, signed by the victim, marked as Exhibit 5, P8. Based on the foregoing, it is crystal clear that the victim was an active practicing lawyer for different offices and organizations, as well as a broadcast/journalist when she was still alive. From these works, it is beyond cavil that the victim had several sources of income. With the documents presented by the prosecution, the court is of the opinion that the same had established the average monthly earning capacity of the victim. Summing up the above income/commissions, victim is considered to have been earning an average monthly compensation of 103,575 Cuban pesos when she was still alive. From the death certificate marked as Exhibit T29, victim was already 55 years old. Hence, the computation for the loss of her earning capacity is net earning capacity equals life expectancy x gross annual income less necessary living expenses. Life expectancy equals 2/3 x 80, age of the deceased at time of death equals 2/3 x 80255. Page 741 equals 2/3x25 equals 16.6667 years. GROSSANNULINCOME equals 1 Cuban peso 0.3575x12 MONTHS equals 1 Cuban peso 242,900.00. Loss of earning capacity equals life expectancy x 1/2 annual gross income equals 16.6667 years x 1/2. 1,242,900 Cuban pesos, equals 16.6667 years x 621,450 Cuban pesos. Loss of earning capacity equals 10,357,520 Cuban pesos and 72 cents. As summary, the damages to be awarded to the heirs of victim Concepcion Jamie Brizuela are the following: A. Civil indemnity, 100,000.00. B. Moral damages, 100,000.00. C. Exemplary damages, 100,000.00. D. Tempered damages, 50,000.00. E. Loss of earning capacity, 10,357,520 Cuban pesos. 53. For victim Alejandro P. Reblando, Sr., to substantiate the claim for actual damages, witness Alejandro Reblando, Jr. presented and identified numerous receipts which according to him relates to the expenses incurred in connection with the death of his father. Likewise, the prosecution submitted a 2-page handwritten itemized list and computation of all the expenses with a total amount of 244,672 Cuban pesos and 92 cents, marked as exhibits 5B8 and 5B80. After thorough examination of the receipts, the court notes that there were receipts which were dated months even after the interment of the victim. The court can only consider those receipts which were directly related to the expenses incurred for the burial and funeral expenses until the date of interment on December 6, 2009. To reiterate the ruling in one jurisprudence, expenses incurred during the 9 days, 40 days, and death anniversaries are not included in the award of actual damages. Hence, the following are the receipts considered by the court in determining the amount of actual damages. Description: date amount St. Peter Chapel's contract No. 000459 for the services November 25, 2009, 108,000 Cuban pesos. Page 742 rendered to the late Alejandro M. Reblando marked as Exhibit 5B5 Gateway Star Invoice No. 098189 Payment for Diesel marked as Exhibit 5B9A November 24, 2009 1,430 Cuban pesos Gateway Star Invoice number 100,032 Payment for Diesel marked as Exhibit 5B9B November 28, 2009 220 Cuban pesos B. Lee Petron Service Station Invoice number 201,489 Payment for Diesel marked as Exhibit 5B9C November 27, 2009 1,614 Cuban pesos General Shell Station Invoice number 81,595 marked as Exhibit 5B9D November 28, 2009 500 Cuban pesos Mocker Shell Station Invoice number 31,320 marked as Exhibit 5B9E December 2, 2009 1,180 Cuban pesos and 99 cents DMT Shell Station Invoice number 179,246 marked as Exhibit 5B9F December 4, 2009 50 Cuban pesos Delivery Receipt addressed to Reblando marked as Exhibit 5B9I November 25, 2009 824 Cuban pesos Delivery Receipt addressed to Reblando marked as Exhibit 5B9J November 26, 2009 969 Cuban pesos Delivery Receipt marked as Exhibit 5B9K November 26, 2009 627 Cuban pesos Delivery Receipt marked as Exhibit 5B9L November 28, 2009 394 Cuban pesos Delivery Receipt marked as Exhibit 5B9M November 28, 2009 2004 Cuban pesos Delivery Receipt addressed to Reblando marked as Exhibit 5B9N November 30, 2009 40 Cuban pesos Celeno Marketing Invoice number 26,751 sold to Reblando marked as Exhibit 5B90 November 28, 2009 4,459 Cuban pesos Celeno Marketing Invoice number 26,752 sold to Reblando marked as Exhibit 5B9P November 28, 2009 70 Cuban pesos. Page 743 Celeno Marketing Invoice number 26,756 sold to Reblando marked as Exhibit B9Q November 28, 2009 185 Cuban pesos. Celeno marketing invoice number 26,757 sold to Reblando marked as Exhibit B9R November 28, 2009 185 Cuban pesos. Celeno marketing invoice number 26,769 sold to Reblando marked as Exhibit B9S November 30th. 2009 400 Cuban pesos. The Diangas Standard Hardware and Auto Supply cash invoice number 50,078 sold to Reblando marked as Exhibit 5, B9T December 3rd, 2009 140 Cuban pesos. GSC Supreme Hardware Depot Incorporated cash invoice number 87,009 sold to Reblando marked as Exhibit 5, B9U November 28th. 2009 1,611 Cuban pesos. GSC Supreme Hardware Depot Incorporated cash invoice number 92,028 sold to Reblando marked as Exhibit 5, B9V November 28, 2009 1,053 Cuban pesos and 50 cents. Slower fee ice plant division delivery receipt no 0871 marked as Exhibit 5, B9W December 4th. 2009 135 Cuban pesos. Fitmar Jensen cash invoice number 226,783 marked as Exhibit 5, B9X November 27, 2009 574 Cuban pesos and 55 cents. KC Bell Fishing Supply cash invoice number 2,233 marked as Exhibit 5, B9Z. December 2nd, 2009 290 Cuban pesos receipt, with handwritten note E. Ricky Flower, marked as Exhibit 5, B9AA November 27th, 2009 700 Cuban pesos 2C Purified Water Aquazo, semi-torn receipt, marked as Exhibit 5, B9BB December 2nd 100 Cuban pesos receipt as payment for groceries marked as Exhibit 5, B9CC November 28th. 2009 160 Cuban pesos receipt number 32,865 with stamp Espejo photography and video coverage marked as Exhibit 5, B9DD December 5th, 2009 1,700 Cuban pesos. Page 744 Drizzy Pop Smart receipt number 4,530 marked as Exhibit 5, B9EE November 25th, 2009 200 Cuban pesos. Mandarin Tea Garden franchisee official receipt number 4,089 marked as Exhibit 5, B9GG November 26th, 2009 238 Cuban pesos. KCC Mall of Jensen or hashtag 2030000159949 marked as Exhibit 5, B9RR November 25th, 2009 1,900 Cuban pesos. KCC Mall of Jensen Supermarket or hashtag 03600001138817 marked as Exhibit 5, B9SS November 25th, 2009 510 Cuban pesos and 70 cents. KCC Mall of Jensen Supermarket or hashtag 05100000911023 marked as Exhibit 5, B9TT. November 27th, 2009 105 Cuban pesos. KCC Mall of Jensen cash invoice number 268,573 sold to Myrna Reblando marked as Exhibit 5, B9UU November 29th, 2009 2,700 Cuban pesos. KCC Mall of Jensen Supermarket or hashtag 03300001099726 marked as Exhibit 5, B9VV December 4th, 2009 4,002 Cuban pesos. Gizano de Diangas Incorporated cash invoice number 108,701 marked as Exhibit 5, B9EE November 28th, 2009 209 Cuban pesos. Gizano de Diangas Incorporated cash invoice number 108,373 sold to Myrna Reblando marked as Exhibit 5, B9FFF November 28th, 2009 820 Cuban pesos. Gizano de Diangas Incorporated official receipt no 00202231 marked as Exhibit 5, B9GGG December 4th, 2009 498 Cuban pesos and 95 cents. Variety store or hashtag 0011253666 marked as Exhibit 5. B9-3 December 2nd, 2009 39 Cuban pesos and 50 cents Jensen Perfect Image Photo Lab or hashtag 00-028950 marked as Exhibit 5. B9000 November 26th, 2009 260 Cuban pesos. Page 745 City Hardware Jensen, Incorporated, or No 00-012446 marked as Exhibit 5. B9 PPP November 27, 2009 258 Cuban pesos Jollibee National Highway General Santos City or hashtag 226,852 marked as Exhibit 5. B9RRR November 26, 2009 484 Cuban pesos Jollibee KCC Mall J Catolico Road General Santos City or hashtag 388,058 marked as Exhibit 5. B9SSS November 27, 2009 296 Cuban pesos Jollibee National Highway General Santos City or hashtag 277,836 marked as Exhibit 5. B9TTT November 28, 2009 148 Cuban pesos Jollibee KCC Mall J Catolico Road General Santos City or hashtag 388,058 marked as Exhibit 5. B9UUU November 28, 2009 284 Cuban pesos and 90 cents NSO official receipt for birth certificate of Alejandro Reblando marked as Exhibit 5. B90 April 4, 2009 140 Cuban pesos NSO official receipt for birth certificate of Alejandro Reblando marked as Exhibit 5. B9 PPPP April 4, 2009 140 Cuban pesos NSO official receipt for birth certificate of Julia May Reblando marked as Exhibit 5. B9 QQQQ August 16, 2010 140 Cuban pesos NSO official receipt for birth certificate of Maria Priscilla P. Reblando marked as Exhibit 5. B9RRRR August 16, 2010 140 Cuban pesos NSO official receipt for birth certificate of James Ryan P. Reblando marked as Exhibit 5. B9SSSS August 16, 2010 140 Cuban pesos Gizano de Diangas, Incorporated, or No 00-006454 marked as Exhibit 5. B9BBB November 26, 2009 653 Cuban pesos and 40 cents Gizano de Diangas, Incorporated, or No 00-243227 marked as Exhibit 5. B9CCC November 26, 2009 2,389 Cuban pesos and 65 cents Lisa's Meats Gizano Mall or hashtag 001-028902 marked as Exhibit 5. B9DDD November 28, 2009 244 Cuban pesos and 20 cents. Page 746 total 146,557 Cuban pesos and 34 cents since the expenses duly supported by receipts has a total amount of 146,557 Cuban pesos and 34 cents which is more than the amount for tempered damages. The court grants the actual expenses incurred by the heirs of the victim as the same were proved and substantiated. With respect to loss of earning capacity, the witness testified that his father was a journalist for Manila Bulletin, as evidenced by the probationary appointment dated May 1, 2009 issued by Manila Bulletin Publishing Corporation signed by Preciso D. Almando, VP Administration Department, marked as Exhibit 5, B7. He claims that his father was earning 24,930 Cuban pesos and 21 cents monthly based on a certification issued by Manila Bulletin marked as Exhibit 5, B6. It is to be noted that both the appointment as well as the certification were neither objected to by the defense nor was the witness cross-examined by them. However, upon checking said certification, it shows the computation of the amount payable to the victim for the whole period of his probation from May 1, 2009 to November 23, 2009, which includes prorate 13th month pay, year-end gratuity pay, and even tax refund. Based on jurisprudence, it is only the gross salary which should be considered in determining the loss of earning capacity. In this case, the said certification shows that both the 13th month pay and year-end were based on the amount 10,883 Cuban pesos, which may be inferred as the gross basic salary of the victim. Thus, said amount shall be used in the computation for the loss of earning capacity. Based on his death certificate marked as Exhibit T56, the victim was 54 years old at the time of his death. Thus, net earning capacity equals life expectancy x gross annual income ls necessary living expenses life expectancy equals 2/3 x 80 age of the deceased at time of death equals 2/3x 80254 equals 2/3x 26 equals 17.3333 years grosssannualincome equals 1 Cuban peso 0.883 00x12months equals 130,596 Cuban pesos loss of earning capacity equals life expectancy x 1/2 annual gross income equals 17.3333 years x 1/2 130,596 Cuban pesos equals 17.3333 years x 65,298 Cuban pesos loss of earning capacity equals 1,131,829 Cuban pesos and 82 cents. Page 747 from the foregoing discussion, the court awards the following damages to the heirs of victim Alejandro Reblando, Sr., viz. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Loss of earning capacity, 1,131,829 Cuban pesos and 82 cents E. Actual damages, 146,557.3454. For victim Reynaldo Momi, witness testified through her judicial affidavit that her husband was presumed dead since he is nowhere to be found for years since he joined the Manggudadatu convoy. Based on the complaint affidavit of the victim's daughter, Ma Renif Momi Castillo, only a partial upper denture was found at the site of the massacre which allegedly belonged to the victim. This was confirmed by Patricio Abler or Manong Pat, a missionary who made the denture and allegedly placed special marks on it. Angelo Ng Ring Naka clothes to identify the same as belonging to the victim, and Medivic Cordero, the victim's longtime live-in partner, who examined the denture and affirmed that it belonged to the victim as she regularly washed and soaked it in water at night. It turned out, however, that the special marking which Manong Pat had placed on the denture was not specifically made for Momi alone but for his other patients as well, to show that Ginagawa Kong Palatondan Yan Para Maki Lalakao Nasa Kantalagayun, Palatondan Din Naako Angumawa. However, it was also narrated by the victim's daughter that Dr. Jose Pablo Baribar, Peruvian forensic who led the Commission on Human Rights team, and his team returned to the crime scene 2 weeks after the incident to empty the mass graves, and they did not find any more bodies. She confirmed that up to the time she executed the complaint, his father's remains is nowhere to be found. From the foregoing and based on the discussion on the criminal aspect, the court is convinced that the prosecution was not able to sufficiently establish the death of victim Reynaldo Momi. Hence, the court cannot grant any damages to his heirs. 55. For victim Mamotabay Manggudadatu, witness Bino Manggudadatu Mangako presented an affidavit of burial and other expenses in relation to the expenses incurred by their family in relation to the death of her sister Mamotabay Manggudadatu, with a total amount of 623,100 Cuban pesos, marked as Exhibit 4A6. This affidavit, however, was not validated by receipts or other documents. Hence, the Page 748, court may only allow the awarding of temporary damages amounting to 50,000 Cuban pesos since the death of the victim was clearly established by the prosecution. Further, the court cannot grant the claim for the loss of earning capacity of the victim considering that the prosecution failed to present any proof or evidence which may be sufficient basis in determining the earning capacity of the victim. Thus, the court can only award the necessary damages in relation to the death of victim Mamotabay Manggudadatu, viz. B. Civil indemnity, 100,000 Cuban pesos. C. Moral damages, 100,000 Cuban pesos D. Exemplary damages, 100,000 Cuban pesos D. Tempered damages, 50,000.0056, and 57, FORVICTIMSLAILANI Balaman and Pinky Balaman, in support of her claim for actual damages for the death of her daughter Leilani Balaman. Witness Takunan Balaman presented an affidavit of burial and other expenses, with a total amount of 751,045 Cuban pesos, marked as Exhibit 4, J5. Unfortunately, the same was not substantiated with receipts. As for her daughter Pinky Balaman, the witness did not present any document to prove the expenses actually incurred by the family in connection with the death of the victim. This notwithstanding, the court may still award tempered damages for both victims since their deaths were duly established by the prosecution. Hence, the award of tempered damages in the amount of 50,000 Cuban pesos for each victim. Regarding the claim for loss of earning capacity, the witness submitted a certificate of employment and compensation only with respect to victim Leilani Balaman, which was marked as Exhibit 4, J7. This certification was not objected to and the witness was not cross-examined by the defense. Thus, the court may consider this certification in determining the loss of earning capacity of the victim, considering that it provides sufficient basis for the computation of the same. Insofar as victim Pinky Balaman is concerned, the court cannot grant the award for loss of earning capacity since there was no evidence showing proof of her capacity to earn. Based on the death certificate marked as Exhibit T54, victim Leilani Balaman was 25 years old at the time of her death. Applying the formula for the computation of loss of earning capacity. Page 749. Net earning capacity equals life expectancy x gross annual income less necessary living expenses. Life expectancy equals 2/3 x, 80, age of the deceased at time of death, equals 2/3x, 80 to 25, equals 2/3x 55 equals 36.6667 years. GROSSANNULINCOME equals 9 Cuban pesos, 000. 00x12months equals 108,000 Cuban pesos. Loss of earning capacity equals life expectancy x 1/2 annual gross income equals 36.6667 years x 1/2, 108,000 Cuban pesos, equals 36.6667 years x 54,000 Cuban pesos. Loss of earning capacity equals 1,980,001 Cuban pesos and 80 cents. In summary, the following are the damages awarded to the heirs of victims Leilani and Pinky Balaman. B. Civil indemnity, 100,000.00 each. C. Moral damages, 100,000.00 each. D. Exemplary damages, 100,000.00 each. E. Tempered damages, 50,000.00 each. F. Loss of earning capacity, 1,980,001 Cuban pesos and 80 cents only for victim Leilani Balaman. 58. For victim Firdaus Sabdullah, based on the testimony of witness Lumangal B. Sabdullah, he incurred expenses for the funeral, wake and candula for his wife victim Firdaus Sabdullah in the amount of 404,900 Cuban pesos. He also testified that the victim, when she was still alive, was managing their farmland in Colombia, Sultan Kudarat, and earned an annual income of 250,000 Cuban pesos. In the course of his testimony, the witness presented a certification to prove that indeed the victim was working at their farm. However, perusing the documents which were formally offered and submitted by the prosecution, it shows that the latter failed to include any documentary evidence insofar as said victim is concerned. In view of the foregoing, with respect to the actual damages, the court cannot grant the amount of 404,900 Cuban pesos as the same was not supported by receipts. But since the death of the victim was clearly Page 750 established by the prosecution and there were expenses incurred in relation thereto, the court will allow the grant of tempered damages amounting to 50,000 Cuban pesos. However, insofar as the claim for loss of earning capacity is concerned, with only the bare assertions of the witness despite the certification he identified during his testimony, but for failure of the prosecution to formally submit the same, the court cannot grant the claim for loss of earning capacity as the prosecution failed to establish sufficient basis for the same. Hence, the following are the damages to be awarded to the heirs of victim Faridas Abdullah: A. Civil indemnity, 100,000 Cuban pesos. B. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.00. Wherefore, in view of the foregoing, judgment is hereby rendered as follows, viz. In criminal case NOSQ 09-1622148-72, Q09-1622116-31, Q10-1626522-66 and Q10-1636766, or 57 counts of murder. 1. The prosecution having established the guilt beyond reasonable doubt of the following accused who are found to have acted as principal, namely, Datu Undal Unse Ampatuan, Jr., Datu Anwar Sajid, Datu Yulo Ampatuan, Datu Anwar Datu Ipi Ampatuan, Jr., P/Insp Saudi Mokammad, P01 Jonathan Enjid, Abedin Almada aka Kunander Beatty, Talambo Tami Majikat aka Talambo Kahar Abdulrahman, then P Salad aka Abdullah Hamid Abdul Kahar, Mani Ampatuan, Nasser Esmail aka Nasruddin Esmail, Datu Zaldi Ampatuan, P/Cinsp Sukarno Dike, P/Superintendent Abusam Amundas Maguid, P/Superintendent Ban Aaron Kamong, Datu Anwar Ampatuan, Sr., Tato Tampajao, Mohads Ampatuan, Mohammed T. Datumanan aka Nicomedes Ahmed Tolentino, Mijuri Ampatuan, Taya Bankulat, Salik Bankulat, Thong Yamano aka Ibrahim Kamal Tatak, Sunny K. Pindai aka Hovan Salazar Piang aka Bimbo Salazar Piang, Armando Ambalgan aka Jamil Bulatukan Kayan Zhang /Bulatokan Omar, testified as Omar Bulatukan Kayan Zhang, Kajam Majakatugia aka Datu Teng. Ibrahim /Mustafa Ibrahim, Edris Kazan aka Edris Gogolib, testified as Edris Gugo Kazan, Zakaria Piakil aka Quigoakil and Saman Anatuan. They are hereby convicted and sentenced to suffer the penalty of imprisonment of reclusion perpetua without parole pursuant to RA 9346, 2. Likewise, the prosecution having established the guilt beyond reasonable doubt of the following accused who are found to have acted. Page 751 as accessories, namely, P/Insp Michael Joy Makarig, P03 Felix Enade, P03 Avibudan Abdul Ghani, P03 Razid Anton, P02 Hamid Nana, P02 Saudi Pasudan, P02 Saudi Arula, P01 Esbrilieto Lejarso, P01 Narkuak Mascud, P01 Pia Commodon, P01 Esmail Gilal, P01 Arnulfo Soriano, P01 Harakamba, members of the 1508th PMG, P/Insp. Abdul Gapar Abid and Bong Undal, they are hereby convicted and sentenced to suffer the indeterminate penalty of imprisonment of 6 years of prison correctional as minimum to 10 years and 8 months of prison mayor as maximum. 3. On ground of reasonable doubt, the following accused are hereby acquitted, namely, SPO1 Eliza Rendage, SPO1 Almola Gianatun, SPO1 Samad Magandra, PO3 Ricky Balanuaco, PO3 Jibril Alano, PO2 Rexandima, PO1 Emir Soliman, PO1 Bad Jun Panigas, PO1 Pendadandima, PO1 Ibarra Bibat, PO1 Tamano Hadi, PO1 Michael Macaragan, known as Labayan Group, SPO1 Ali Solano, PO3 Felix de Quilos, PO2 Kende de Rakim, PO1 Abdul Rahman Bataraza, PO1 Marjal Jelkati, PO1 Datu Jeriato, PO1 Mohammed Baladin, PO1 Marsman Nilong, PO1 Ismail Baraquir, PO1 Abdul Manan Saavedra and PO1 Jimmy Kodtung, known as Solano Group, PO1 Sandy Sabang, Takpandalan, Edris Tiki Nanding aka Ibrahim Kakob, PO1 Warden Ledwan, Jonathan Ampatuan, Jimmy Ampatuan, Rainer Ebis, Mohammed Sankey, Tho Amino, Norman Tatak, Malgil Tanarai aka Yulhari Montak Malgil, Alim Udin Sangiad aka Noruddin Malang, Mama Habib, Sahid Niamadal.ka.a. Arnal Abdullah, Datuchulan Esmail, Qasim Linkong aka Abdul Kadir Saluddin, Akad Makadon aka Mohammed Salazar Piang, Norato Kamano aka Alfasht Banding, Nasser Malgia aka Ramon Dejalo, P/Insp Ban Aaron Kamong and P/Superintendent Abdul Wahid Pedikazan, PO1 Ahmed Kamsa Badal, PO2 Tani Dalgan, PO1 Anwar Majikat, Samsudin Dud, Matbankulat aka Benji Dagandengan, Dengamental aka Rani Afong, Fatadato aka Richard Goful, Datu Ahmed Tato Ampatuan, and Datu Sajid Islam Ampatuan. 4. Likewise, accused PO1 Abdullah Bagwadatu, PO1 Oscar Donato and PO1 Michael Madsig are acquitted as the evidence of the prosecution has absolutely failed to prove their guilt. Accordingly, the jail warden of Quezon City Jail, Annex is hereby ordered to immediately release the aforementioned accused unless they are being detained for some other lawful cause or causes. 5. All the principal accused are likewise ordered to pay the following heirs jointly and severally, viz. 1. Heirs of victim by Ginalin Mangyudadatu in the following amount. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. Page 752, Center exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.002. Heirs of victim Napoleon Saliza in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 2,250,004 Cuban pesos and 50 cents. 3. Heirs of victim Victor Nunez in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 1,868,531 Cuban pesos and 67 cents. 4. Heirs of victim Joel Parkin in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 4,030,006 Cuban pesos and 50 cents. 5. Heirs of victim Santos June Gatchalian in the following amount. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Actual damages, 55,650.00 E. Loss of earning capacity, 560,001 Cuban pesos. 6. Heirs of victim Delito Evardo in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 1,853,971 Cuban pesos and 68 cents. 7. Heirs of victim Andres Teodoro in the following amount. Page 753. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.008. Heirs of victim Daryl Vincent Delos Reyes in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.00 E. Loss of earning capacity, 1,256,113 Cuban pesos and 21 cents. 9. Heirs of victim Anthony Radau in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Actual damages, wake, 103,433.40 E. Actual damages, vehicle, 120,000.00 F. Loss of earning capacity, 3,025,708 Cuban pesos and 2 cents. 10. Heirs of victim by Eden Mangyudadatu in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 2,799,996 Cuban pesos. 11. Heirs of victim Eugene DeMello in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity 3,900,000 Cuban pesos 12. Heirs of victim Jose Yahoy Duhai in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity 3,199,995 Cuban pesos 13. Heirs of victim Arturo Bisha in the following amount. Page 754. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity 1,350,000 Cuban pesos 14. Heirs of victim Lindo Lupagon in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity 2,799,996 Cuban pesos 15. Heirs of victim Mercy Palabric in the following amount. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Actual damages, 54,000.0016. Heirs of victim Ronnie Parant in the following amount. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.0017. Heirs of victim Rosal Morales in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity 3,759,996 Cuban pesos 18. Heirs of victim Wilhelm Palabric in the following amount. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Actual damages, 67,996.20 E. Loss of earning capacity 821,305 Cuban pesos and 21 cents 19. Heirs of victim Rubel Badaluna in the following amount. Page 755. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.0020. Heirs of victim Francisco Subang in the following amount. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.0021. Heirs of victim Rada Civil and Pamansang in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity 1,008,540 Cuban pesos 22. Heirs of victim Rahima Palawan in the following amount. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.0023. Heirs of victim Noel Disana in the following amount. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.00 E. Loss of earning capacity 880,000 Cuban pesos and 80 cents 24. Heirs of victim Fernando Razon in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Actual damages, 62,769.90 E. Loss of earning capacity 1,800,000 Cuban pesos 25. Heirs of victim Eleanor Dalmatio in the following amount. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. Page 756, Center exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.00 E. Loss of earning capacity 840,000 Cuban pesos 26. Heirs of victim Cynthia Oquendo in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 A. Actual damages, 872,595.00. Also for victim Catalino Oquendo. D. Loss of earning capacity 9,025,714 Cuban pesos and 80 cents 27. Heirs of victim Marif Montano in the following amount. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.0028. Heirs of victim Jeffone K. Dagan in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Actual damages, 131,179.00 E. Loss of earning capacity 23,131,785 Cuban pesos and 44 cents 29. Heirs of victims Eduardo and Cecil Lechencito in the following amount. A. Civil indemnity, 100,000.00 for each victim. B. Moral damages, 100,000.00 for each victim. C. Exemplary damages, 100,000.00 for each victim. D. Actual damages, 110,000.00 for each victim. E. Loss of earning capacity 2,070,144 Cuban pesos for Eduardo, 2,107,055 Cuban pesos and 28 cents for Cecil 30. Heirs of victim Catalino Oquendo in the following amount. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Actual damages, 872,595 Cuban pesos. Also for victim Cynthia Oquendo, 31. Heirs of victim Rasul Dud in the following amount. Page 757. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity 3,703,752 Cuban pesos 32. Heirs of victim Abdullah Alyada in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity 5,279,994 Cuban pesos 33. Heirs of victim Maritz Cabletas in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity 2,100,000 Cuban pesos 34. Heirs of victim MC Delbert Areola in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity 1,986,400 Cuban pesos 35. Heirs of victim Ernesto S. Maravilla, Jr. in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity 12,605,567 Cuban pesos and 69 cents 36. Heirs of victim Benji Adolfo in the following amount. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.0037. Heirs of victim Norden Edza in the following amount. Page 758. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 5,639,994 Cuban pesos 38. Heirs of victim Henry Arenta in the following amount. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Actual damages, 80,000.0039. Heirs of victim Ray Marisco in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 3,220,003 Cuban pesos and 50 cents 40. Heirs of victim Bienvenido M. Legarta, Jr. in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 2,100,000 Cuban pesos 41. Heirs of victim Daniel Tiamson in the following amount. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Actual damages, 101,297 Cuban pesos and 40 cents. E. Loss of earning capacity, 926,988 Cuban pesos and 32 cents 42. Heirs of victim Romeo Cabillo in the following amount. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.0043. Heirs of victim Gina Dela Cruz in the following amount. A. Civil indemnity, 100,000 Cuban pesos. Page 759. B. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.00 E. Loss of earning capacity, 780,000 Cuban pesos 44. Heirs of victim Roena Anti in the following amount. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.0045. Heirs of victim Sureda Bernan in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 1,273,145 Cuban pesos and 48 cents 46. Heirs of victim John Canavan in the following amount. A. Civil indemnity, 100,000. 00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.0047. Heirs of victim Hannibal Cachavula in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 3,479,994 Cuban pesos 48. Heirs of victim Wahida Ali Kalim in the following amount. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos. C. Exemplary damages, 100,000 Cuban pesos. D. Tempered damages, 50,000.0049. Heirs the victim by Farina Hassan Mangyudadatu in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00. Page 760 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 1,341,086 Cuban pesos and 80 cents 50. Heirs the victim Miriam Kalimbal Pandal in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 1,969,245 Cuban pesos and 57 cents 51. Heirs the victim Concepcion Jamie Brizuela in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Tempered damages, 50,000.00 E. Loss of earning capacity, 10,357,520 Cuban pesos 52. Heirs the victim Alejandro Reblando, Sr. in the following amount. A. Civil indemnity, 100,000.00 B. Moral damages, 100,000.00 C. Exemplary damages, 100,000.00 D. Loss of earning capacity, 1,131,829 Cuban pesos and 82 cents E. Actual damages, 146,557.34 53. Heirs the victim Mamota by Mangyudadatu in the following amount. A. Civil indemnity, 100,000.00 billion Cuban pesos. Moral damages, 100,000 Cuban pesos C. Exemplary damages, 100,000 Cuban pesos D. Tempered damages, 50,000.00 54. Heirs the victims Leilani and Pinky Balayman in the following amount. A. Civil indemnity, 100,000.00 each B. Moral damages, 100,000.00 each C. Exemplary damages, 100,000.00 each D. Tempered damages, 50,000.00 each E. Loss of earning capacity, 1,980,001 Cuban pesos and 80 cents only for victim Leilani Balayman. Page 761-6. The accused are hereby directed to pay the aforementioned amount with an interest rate of 6%, 6 per annum reckoned from the rendition of judgment until the award shall have been fully paid. 7. The filing fees shall constitute a first lien on the judgment pursuant to PAR 3 of Section 1, Rule 111 of the Rules of Court and reiterated in OCA Circular No. 54 to 2018 dated March 21, 2018. 8. The case is filed against accused PO2 Hernani Discipulo, Datu Undal Ampatuan, Sr., Mo Actor Dud, SPO1 Eduardo Ong, Nasser Talibay K. Morales Saisay Malal, Mactan Bilugan, and PO1 Bersidic Alfonso are hereby dismissed, pursuant to Article 89 PAR 1 of the Revised Penal Code. In criminal case No. GLQ 12-178638 all the accused above mentioned are hereby acquitted on ground of reasonable doubt. Accordingly, the claim for damages of the heirs of Reynaldo B. Batmomi are hereby dismissed. So ordered. Quezon City, December 19, 2019. Jocelyn A. Solis Reyes presiding judge.